Uh, Commissioners should just take their places so that we can see if we are all here except those who have sent apologies. Secretariat, just count and see whether it's only those who have sent apologies who are not here. Otherwise, everybody is here or not. Commissioners, the commissioners who have sent in apologies, it's Commissioner Malloy, who is not able to attend today. Commissioner Kane is represented by Commissioner Steinberg, and Commissioner Lucas will join us virtually. Commissioner Singh will also attend virtually. I'm told that Commissioner Malema has just sent in his apology. He won't be able to attend today. The Secretariat told me that given those who have sent in their apologies, we are all here except Commissioner Breitenbach. But the Secretariat says she's around, so they're trying to find her. Oh, okay, all right. Okay, she will join us shortly. Okay, I think we should start. Thank you very much to everybody for making it possible for us to have this session today. I know
Good morning, Chief Justice. Good morning, members of the Commission.
How are you this morning?
I am fine, thank you.
Thank you. Thank you very much for availing yourself for consideration for appointment to the Supreme Court of Appeal. And thank you for coming to this interview. I will ask you some questions, and then I will give the opportunity to the head of the Supreme Court of Appeal to ask you questions. She will ask you more questions, and thereafter I'll allow the minister and other commissioners to put questions to you. The questions that we'll put to you are aimed at determining whether or not you should be appointed to the Supreme Court of Appeal. And there is nobody here who just wants to treat you unfairly or in any way. You will be treated with courtesy, but you will be asked difficult questions if there are difficult questions that must be put to you. You understand?
Yes, I do. Thank you.
Okay, all right. Now, we have a lot of information about you which you have supplied, which is in the bundle that we all have. Therefore, we are not going to ask you a lot of questions to confirm what is already there. Everybody is taken to have read the documentation, but we will seek to highlight certain points that we are of interest to us in regard to the criteria that I spoke to you about. You understand that?
Yes, I do. Thank you.
You hold a BUris and an LLB degree, and you worked as a prosecutor, you worked as a magistrate, and you were director at the People's Family Law for some time. You then acted as a judge, and you were appointed as a judge in 2009 in the Western Cape Division of the High Court. Is that correct?
That is correct.
And you got an opportunity to act in the Supreme Court in 2015. You acted actually for quite a long time, about a year, is that correct?
Yes,
May 2015 to April 2016.
2016.
And you went back to the Supreme Court of Appeal in December 2023, and you are still there, is that correct?
That is also correct, yeah.
That suggests that you have had a lot of opportunity to acclimatize to the work environment of the SCA and to get used to their work. Is that correct?
That is correct.
Yes. Now, let's talk about the High Court. The judgments that you have written since you were appointed for the first time as a judge of the High Court, can you share with the commissioners what branches of law they cover?
Yes. At the High Court, I dealt with matters of civil law, contract, of family law. I dealt with criminal law. In fact, every aspect of law, I dealt with constitutional issues, and yeah, a wide spectrum I dealt with at the High Court. It's been a long time that I've been on the High Court bench.
Yes, so we see the purpose for this question is just to see the breadth of your experience.
Yeah.
So you're not doing yourself a good service when you just say a wide spectrum. It's good to specify. You have specified some, but if those are the ones, that's fine. But if there are more, it's better to tell us.
Okay. Thank you. In my time at the High Court, I dealt with family matters. I dealt with constitutional matters. I dealt with contract. I dealt with criminal law. I dealt with administrative issues and interdicts, everything that happens in a motion court, sometimes back to back, I had to do that. And then literally everything that every type of application that one can possibly imagine, I have dealt with over these years.
So you then acted in the Supreme Court of Appeal. Share with us the same information in relation to the Supreme Court of Appeal now. In other words, tell the commissioners these are the branches of law where you have written judgments in the SCA, and therefore they can see the breadth of your experience.
Okay. In the first year that I was at the SCA, the matters that I dealt with was also very broad. It involved issues of contract again. And this time when I went to the SCA, in fact, I was called in very late in the day, and I was called in for a matter that was allocated to me there was a 62-volume matter involving German law of contract. So I had to, when I was called up, I was busy with a criminal matter. I had to finalize that matter and then study into the German law for that hearing. Myself, I was not the scribe in that matter, but I was a member of the panel and I was thoroughly prepared and understood the principles of German law in that 62 volume in the time available to me. In addition to that, the matters that I wrote was a matter on the NCA and law of contract. There were more than one issue of contract involved in that judgment that I wrote. And further, once the matters that I did not write involved matters of, but where I was a member of the panel, that involved contract again. It involved the constitutional law and administrative law. Also, issues of criminal law was involved in 2 of those matters. So again, it's a wide spectrum.
Yes, thank you. May I refer you to the questionnaire that you filled and submitted to the Commission? And in particular, I want to refer you to question 16, which appears on paginated page 7.
I am there. Yeah.
You are there. 16, question 16 says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. And then you listed a number of cases there. The first one is Shabros Property Investments. There you say, Networks Pty Limited, electronically delivered. The colleague ceased with the matter, took ill, and the matter remained outstanding for many months. At the time, I was seized with a criminal matter, but volunteered to finalize this and other matters as it was unclear when or if the colleague would be able to return to office. He is still on sick leave. This is an indication of a mature and responsible attitude towards the administration of justice. You see that?
Yes, I see that.
It appears to me that you are not answering the question that has been asked there. You are asked to list cases that you regard as most significant and say why they are significant. My reading of what you say there, which I've just read, doesn't seem to go to the question of why that judgment was significant. It just talks about the fact that you saw the need to assist.
Yes.
Do you agree?
Can I explain?
Sorry?
Can I explain?
Well, do you
Yeah,
agree and you want to explain, or do you not agree and you want to explain? I first want to know whether you agree or not.
I, I, I looked at it differently than you do.
Yes,
My
okay,
reason
tell
for,
me. Yeah, tell us.
okay. This matter, we have a problem generally in the judiciary where people complain about long outstanding judgments. This was a commercial contract that's involved here, and the matter had been fully ventilated. There was a trial in this matter. Now, it's not easy to get into a trial like that and then write a judgment with, it's not an appeal. I must write a judgment as a court of first instance, not having had the opportunity to see the witnesses. And then to write that judgment and get the basic principles of the contract that was involved here correct. I thought that added to the reason why I wanted the commission to see that I'm not just somebody who, how shall I call it, just quickly do things. It was actually having to go through that record, study the record, and distill the principles of contract there. There was an initial rejection of the contract party repudiation, and then afterwards there was an acceptance
Let
of
me
it.
stop you there. There is nothing talking about principles of contract in that passage, isn't it?
I know, yes, yeah, that is correct.
The question was asking you to tell the commissioners to list cases you regarded as most significant and to say why you regarded them as most significant.
I
Do you
agree
still
with
say
you.
you answered the question?
Yeah, I've, I've answered it now, not
No,
in
no,
my, yeah.
in the questionnaire.
No, yes, no, that does not give the answer that I gave you now.
Okay, let's go to uh, case number 3, which is on paginated page 8.
Yeah.
Poison versus merger and another. You are supposed to be a case to regard as most significant, and you are supposed to indicate why you regard it as most significant. And what you say there is this: the respondent alleged that the applicant had sexually assaulted her. The applicant approached the court seeking an interdict and prescribing to the rape survivor how she should narrate her complaint. I held that it would be preposterous to give the alleged abuser editorial rights over his victim's narrative. What do you
Yes,
say about that answer?
that answer is correct because, and
Sorry?
I say that answer is correct. That was the importance of that case.
What is the importance of the case?
The importance of the case is that an abuser has no right to tell his victim or his survivor how they must, or he or she should narrate their experience and their harm. It is very important that a survivor of rape is able to tell their version as they see and experienced it. If the abuser is able to tell, this is how you can report it, it takes away from the power of the victim, survivor now, to tell their version of what they say happened. And that is why we often now have interdicts and trying to gag a survivor saying, you can't say that, this is how you must report your complaint. And I thought that is very important, that the survivor is given a voice of their own.
Let's go to case number 4, Ramando. You say in this matter the applicant was included in a list of alleged abusers. I held that he had the right to challenge his inclusion in the list that did not bring the validity of the list in issue. Is that right? You say that one answers the question?
I say it does because the list was an issue. At the university at the time, there were people saying that list is defamatory and the list should not be circulated anymore. This judgment dealt with one person who said, my name on the list is not warranted. And I said that that is not the judgment does not affect the validity of the list because people were standing back now and were afraid how many more of these are there going to be. And that has the effect of perturbing people coming forward because look what happens when you complain. It is necessary to say that the accuser had the right to challenge his name on the list, but that did not bring the validity of the list into question.
The last one that I
Sorry,
want
Chief
to
Justice.
raise.
Sorry, Chief Justice. Her voice is too soft. We are struggling this side.
Sorry?
Her voice is too soft. We are struggling this side.
Oh, I'm sorry. I'm sorry. Her voice. Oh, okay. No, I thought you said mine. Okay, please speak up so that the commissioners can hear you. Okay. All right. The last one that I want to refer you is case number 9, on page 9, Labertus von Wille Bester. You say that the importance of that case is that you refused an application to separate a special plea of prescription from the merits. I held that the merits of a special plea of prescription are linked to the merits of the plaintiff's claim. That evidence will have to be led in the separated trial and again in the main trial. Is that right?
That is correct.
You say it answers the question.
Yes.
Okay, all right. Thank you. Justice Mullerman.
Thank you. Thank you, Chief Justice. Good morning, Justice Bartman.
Good morning, President.
I'll just continue from where the Chief Justice left off in relation to your overall experience. You mentioned that you've been exposed to a broad spectrum of the law. I know that you are from a coastal city. Have you had an opportunity to do any maritime law cases there?
Yes, I have. In fact, if you look at my list of number on page 10, case number case number 4, that was a maritime matter that I did in my first year after my appointment. Since then, I've been involved in it on urgent applications, having to arrest a boat or release. We have a lot of that in Cape Town.
Okay, thank you. And at the level of the SCA?
Not at the SCA, I have not had.
Oh, you haven't. All right. So you indicated that you were allocated a 62-volume matter that, amongst others, required you to familiarize yourself with German law. Would you say you coped? I know you mentioned that you were not described, but did you cope? Did you make a significant contribution, either in court or in your post-hearing conference in this matter?
In the post-hearing,
Yes.
there I made my contribution.
Yes.
In court, I took ill at that time, so there wasn't much contribution in court.
Yes.
But prior to the hearing, I fully was well versed in the application and understood the facts, and therefore was able to make a meaningful contribution.
Yes. So, having participated in this voluminous record appeal, did you manage to prepare sufficiently for your other appeals? Or did your participation in this matter compromise in any way your participation in other appeals?
No, it did not compromise me in any way. I wrapped up what I was busy with at the High Court and immediately started doing that. Hence, I was able to finalize the judgments that I had for myself as well.
Yes. So you acted at the SCA in 2015 and 2016, and then had a long break where you were at the High Court and came back to the SCA in 2023, I think. Yes?
That is correct.
Yes. You must have realized when you arrived at the SCA that things were different in as far as the research capacity is concerned. Is that correct?
Yes, yeah, it's very different.
Yes, in terms, we have limited, more limited research capacity at this stage.
Yes, you do.
Yes, and as a matter of fact, the justices, 26 justices of the SCA have had to rely on only 3 law researchers.
Yeah.
Yes, you'd agree that this would mean that a judge has to be self-reliant, largely self-reliant in terms of preparation for the hearing and also in terms of preparing the judgment.
Yes, yeah, you really have to be able to do research by yourself.
Yes, and did you manage all these tasks?
I had no problem with that.
Yes.
Yeah.
All right. And in terms of the environment, during your last stint, your most recent one, how did you find it?
The SCA has, sorry, the SCA has changed. There is a general collegiality about that was not that obvious last time. In 2015, 2016, it is a pleasant working environment. Although you work very hard, but it's pleasant.
Yes, you'd agree that it is not the kind of environment that permits a lot of hand-holding, meaning that colleagues that are appointed there must be able to really hit the ground running.
Oh yes, for sure. There's no time for somebody to handhold it.
Yes. I note that you have now been a judge for 15 years.
That's
That's
correct.
correct. Okay, and prior to your appointment to the bench, you were in the legal profession for approximately 20 years.
Yeah.
Yes. How would you say this experience, your judicial experience of 15 years and the experience prior to your appointment to the bench, how has this prepared you for your appointment to the Supreme Court of Appeal?
Because you, as you correctly pointed out, you need to hit the ground running. There's no time for hand-holding. All those years of experience prepares you for that. You're able to work independently and goal-directed.
Did you have any difficulty in preparing your judgments during your most recent stints?
No, I did not.
Did other colleagues have to make extensive inputs on matters of substance?
The inputs that colleagues made was mainly of a cosmetic issue. There was no rewriting and substantive reworking of my judgments. That was never necessary.
Yes, and you have produced your judgments promptly?
Promptly.
Excuse me?
Yes, I have.
Yes. Yes, so you probably know that the SCA has lost a lot of experienced judges due to attrition.
Yes, I know that.
Yes, so in terms of your experience, what are the special attributes that you bring to the table at the Supreme Court of Appeal?
It is the fact that I've been exposed to, as I say, a wide range. When the Chief Justice asked me, I said, many matters, and he said, you're not doing yourself favors. But I've been exposed from everything that you can be exposed of at the High Court in these years. And that's literally everything from an interdict, from maritime matters to constitutional matters to criminal matters to family law. I've experienced and had input in all areas of law.
Yes, my last question is, taking from your response where you said during your most recent acting stint, you found the environment particularly collegial. You'd agree that collegiality is very, very important at an appellate court because judges sit only in panels.
Yes, you have to be able to work in a team.
Yes. Have you personally had any issues with any colleagues?
None that was not amicably resolved.
Okay. Thank you. Thank you, Chief Justice.
Thank you.
Thank you. Minister?
Yeah, thank you very much, CJ. Also welcome Commissioner Bredenbach for her maiden appearance physically at the JSC. Good morning, Judge Bergman.
Good morning.
Yeah, I only have one question in relation to the matter you have handled of the joint owners of Hardenbos versus Minister of Local Government and so forth. For sure you remember the matter.
Yes, I do.
In relations to NEMA, where do you strike the balance between compliance with NEMA and the imperative of economic developments, create jobs and so forth in the country?
That's a very important balance. It's a balance that must be struck taking into account the environmental issues that we live in, making sure that there is something to pass on to our children thereafter. So projects and the implementation of every project must comply with certain basic criteria so that a project does not destroy whatever there is in the environment. And that can be done. It's usually putting in place certain measures. And in this judgment, that speaks to the measures that needed to be in place for every activity in that project.
Thank you, CJ.
Thank you. JP?
Thank you. Good morning, Judge Bartman.
Good morning, JP.
Just one question, or two maybe, if the CJ will allow me. You're applying to sit in the SCA. I've looked at the judgments you've listed, which you regard as most important. The CJ took you through them. Are any of them full court judgments from the Western Cape?
Yes, just one.
Just one.
Yeah, I was the presider and scribe.
I see.
Yeah.
That's what I wanted to check with you, because you are applying to work in an appellate court.
Yeah.
I would have expected to see more full court judgments that you would have written, but I'm not critical of you, but I just want to check, have you sat in a lot of full court judgments as a senior judge? I mean, you're more than 15 years on the bench now.
Yes, I have. The reason for not submitting more of those is I want the commission to see what I can do on my own. And that's why I gave judgments that I wrote on my own, so that you can see this is just my work.
Yes, but even if when you are presiding and you are a scribe for a full court, you're not on your own, but you're leading a bench, isn't it?
Exactly. That's why I gave you one of those.
I see. Okay. Thank you very much, CJ. Oh, sorry, one last question. It's just, I found it strange in your questionnaire when you refer to the OCJ, you say Department of Justice, then OCJ in brackets. Can you explain that? I'm very passionate about my independence.
No, I'm not trying to undermine the independence. It is just a matter of habit and making sure that we're talking about the same. Yeah.
We're out of their pocket, you know. We're on our
Yes.
own.
Yes. No, the
Thank you very
independence
much.
is very
Thank you.
much.
But I think that what the judge president is seeking to establish is whether you know the difference between the Department of Justice and the OCJ.
Yes, I do.
What is it?
Okay. The Department of Justice is just that. It is the Department of Justice. And the OCJ is the judiciary on its own, where we belong.
Commissioner Dodovu.
Thank you very much, CJ. Just good morning, Justice Barber. You appeared here in 2018 for SCA possible appointment. And one question that was a concern about you was that you lean more towards criminal matters than civil matters. To what an extent have you addressed and improved that area? If you don't mind, can you just raise your voice a bit?
Sorry, the microphone went off. Okay. In the time that I was between that and now, I have been exposed and had dealt with so many matters of difference. You will see the matters that I even volunteered to be involved with civil matters. And when called to the SCA now this time, I was called in, as I have said before, into a matter of German criminal law and could fully immerse myself into that. So there was not a problem with only doing criminal law. You can't, in our division, specialize in like criminal law, although you have a criminal background. Yeah.
Thank you, CJ.
Thank you. Commissioner Matolo Sepu.
Thank you, CJ. Mine is just a question for Judge Bartman. I see you have done a lot of training in diversity, and you have done a lot of domestic violence matters, and you have been very, very involved in such trainings. Are you still participating in that? Or are we going to lose you to the SCA?
Sorry, the microphone goes off. No, my appointment to the SCA, if successful, would not lose me because you continue to take part and advocate these issues.
Thank you. Commissioner Marumwagai.
Thank you very much, CJ. Good morning, Judge.
Morning, Commissioner.
I realize that you seem to be quite passionate about the area of law, contract law, from your responses. And I just want to ask you one question in relation to contract law. Can I take you to page 617, I think, of your paginated documents?
Yes.
Yes, there's a judgment there, Shabros Property Investment and Mobile Telephone Networks. I see that in this, obviously, this is not a test, and I'm not going to ask you about the nuances of the case, but I'm just curious about one thing. I see that in this case, you were applying one of the theories of contract law, the doctrine of quasi-mutual assent,
Yeah.
which is probably one of the most important doctrines in contract law, and one can argue it's at the heart of contract law. And after reading the case, I'm not really sure if I get a sense of how you are actually applying it, because I can see you quote the Locus Classicus SONAP case that was decided in 1992 of the Supreme Court of Appeal.
Yeah.
Well, there is a more recent case, but that is besides the point. What I want to understand is what role does this doctrine play in the contract itself when two people are actually entering into a contract? And what is the significance of this contract if there should be a dispute?
Well, first of all, you will then, your issue is, was there a contract? Did the parties enter into a contract?
No. In the judgment, the parties entered into a
Into a
contract,
contract.
and you were resolving the dispute that arose from the contract.
Yes.
So I'm not necessarily asking you about the case per se, but after reading the case, a question came to my mind that what is the significance of this doctrine in a contract when people are actually contracting, are entering into an agreement? And what role, if any, does it play in assisting a court to resolve a dispute should one arise?
Because we don't know what happens in somebody's mind. All the court has is the outward appearances. How did you present yourself? Mislead, or what impression did you make on your contract? And that is what this doctrine, that you can't sit there and have your reservations for yourself and saying, oh, further down the line, I'll say this was not consent. And parties are held to their outward appearance and their outward manifestation of their intentions.
Sorry, CJ, can I just
Okay,
a last bite on it?
yeah, last one.
The reason I'm asking you this question is contract law generally in South Africa, it is on the crossroads. And there is a question as to whether you can infringe, and I'm using this quite guardedly, into common law, contract law with constitutional principles, right? And when one looks at these subjective sort of doctrines that we apply in relation to how contracts are interpreted, and this is why I'm asking you this question. In other words, what is the role of this kind of doctrine in the development of contract law in South Africa? Can we still, because the thing is, you are going to the higher court, you are going to be expected to interpret some of these contracts in line with this doctrine. So I just want to understand your jurisprudential sort of thinking around this particular doctrine, which is quite subjective, but you need to apply it on a quite an objective contract. And that's where my discomfort is.
Please speak up. You
Sorry,
can keep
the
your mic on.
microphone. Yes, the
Okay.
microphone goes up. The contract is measured against the constitutional principles. You will see if this is a contract that is contra bonus mores or not. But parties in general are held to their agreements that they must be held to their agreements. The court cannot make decisions for contracts for a party. So in finding what the contract between the parties are, the court looks at what is there, what does the document say, and then in finding that, you look at what the parties, how they manifested themselves in terms of the contract.
Thank you very much. Thank you very much, CJ.
Thank you, Commissioner Nochesi.
Thank you, CJ. Good morning, Judge Bartman.
Good morning.
Yeah. I just want to confirm one thing. As you are applying for an appellate court where you'll work as a team,
Yeah.
you will be in panels. Is it, would I be correct to say one of the special attributes is that you must be a collegial person, you must be respectful to all your colleagues, You must not have some superiority over others. You must be able to be persuaded in the team. Is that, am I right that that is a special attribute for a judge who must be in an appellate court? Would you agree with me?
Yes, I agree with you. You must also be able to persuade others of your view without imposing your view.
Thank you.
Thank you. Commissioner Moimana.
Thank you, Chief Justice. Good morning, Judge Batman.
Good morning, Commissioner.
Just one question from my side, which relates to your questionnaire, where you list a judgment that were successfully appealed against you. So my question relates to the Speaker of the National Assembly versus the Public Protector.
I'm sorry, can you speak up? I didn't hear. On which page are you?
It's page 10
Page
of your
10.
questionnaire, where you list cases that were appealed against your judgment.
Yeah, which one? Number?
The Speaker of the National Assembly versus the Public Protector.
Yes.
Yes. The one of the aspect relates to that was successfully appealed against your judgment is the pronouncement that you made in relation to the inclusion of a judge in the preliminary stages of the inquiry. And from yourself, from the judgment, you said that it violates the separation of powers.
Yes.
So now, the question that I want to understand from yourself, Justice, is what are the lessons that you have learned from this judgment in relation to the doctrine of the separation of powers, particularly in relation to the role that the judiciary can play in promoting the values of our constitution, particularly the rule of law, because my understanding is that separation of powers is not absolute. It has a role to play in our transformation of the judiciary and transformative justice. Thank you.
Thank you. Yes, it has, but the court cannot shy behind separation of powers from dealing with the matter. You will see in the matter of, there's another matter that I said, the Scalabrini matter. There the state also said, oh, there's separation of powers. The court cannot interfere with separation of powers. It was actually not a separation of powers issue. It was an issue whether the regulations were against our own law, in terms of where we do not send somebody back against to the country where they face persecution. So in that process, separation of powers didn't save the day for the respondent. In another matter, it might save the day for them, but it's for the court in each instance to delineate whether we are dealing with separation of powers. Is the court overstepping? And be careful not to overstep, but not hide behind that and not deal with an issue. That's where sort of you've got to draw the line.
Thanks, Justice Batman. Thank you, Chief Justice.
Thank you very much.
Sorry, Chief Justice.
Yes.
I just wanted the answer to be repeated. I'm not sure if I understand the explanation of the doctrine of separation of powers.
Switch on your mic. You can keep it on until you finish.
Thank you. I indicated that you have the various divisions, and the court must be mindful and with due deference to the other legs of the government and not to overstep. But at the same time, the court cannot hide behind and be timid and not venture into an area when you have to. Not everything is separation of powers or intrude into that doctrine of separation of powers.
Yes, I'm still not sure if I understand. I mean, if you do have a proper separation of powers case,
Yeah.
on what basis will then a court intrude into the sphere of the legislature or into the sphere of the executive?
If you have true separation of powers, the only way that you then you don't interfere when you say this is within that particular arm of government's jurisdiction to do that. They've exercised that discretion within their powers. Whether I like the way they've exercised it, that's not the issue.
I don't know if there's no confusion in concepts. The one instance is where a court is trying to give an order that is just an equitable under Section 172.
Yes.
That may or may not engage separation of powers,
Yeah.
but it is a discretionary question. The other is where a court is deciding where the law allocates a decision-making function,
Yes.
which is on the merits, not on the remedy.
Exactly.
The problem with the answer is that it seems to conflate the two. And it seems to say there are instances where a court would be justified in intruding on separation of powers. And I'm not sure if I actually understand. Maybe the starting point is, how do you understand the separation of powers? What are the exceptions to it?
The separation of powers, I understand, is the court looks at the separation of powers will come from the case itself. You will see what are you dealing with. Is this issue exclusively in the domain of that particular actor? Did they exercise their discretion that is allocated to them? Did they extend or go over what they were supposed to? Were they able to implement their particular decision within the powers allocated to them? Once that is the question, that is, if that's the finding, that this is a power for you, for that particular actor, they've acted within their power. Whether the court likes the result or not is then not the issue. It's judicial, it's within the Constitution, it is a decision that could be taken.
Thank you, Chief Justice.
You referred in your answer, talk about separation of powers, to, I think, Commissioner Muimang, to legs. What was that about? I just want to make sure I understand.
It's a different arms of government.
Arms, yes.
Arms, not
Okay.
legs. Yeah.
Let me put these questions. You want to share with the commissioners your knowledge of what the rule of law is?
Yes.
Yes, please go ahead.
In terms of the rule of law, it's the legality of everything we do is derived from the rule of law. It infuses what we do. Legality and the rule of law goes hand in hand. To be legitimate, you must draw it from some source of power where you get that legitimacy from.
Is that the full answer?
That is my answer.
I don't see any further hands, so, and from the
There's a hand
commissioners. Oh,
I'm so sorry, Chief Justice.
yes, please go
Just-
ahead, Commissioner Pillay.
2 questions, Chief Justice. Good afternoon, Judge. Good morning. Judge, may I ask you a question on your Shabros judgment? It's at paginated page 17 of your pack. Now, when I initially read your judgment, like the Chief Justice, I was a bit confused about why you selected this judgment for inclusion in the pack. The dispute in that matter seemed to be a very simple and straightforward one. It was around the existence of a partly written and partly oral contract. But when I read your judgment, and particularly when I got to paragraph 36 of your judgment, what confused me was your handling of the onus in that matter. So in the lead up to paragraph 36, you deal with some principles of contractual interpretation with reference to the Cool Ideas judgment. And then in paragraph 36, you say the following. You say, and I'm reading on the third line of paragraph 36. You say, I am persuaded that the plaintiff hasn't met its onus in proving the existence of the parking lease as pleaded, which is fine.
Yes?
And then you say the plaintiff's version is true and accords with sensible commercial practice.
Yes.
And then you say the defendant's version to the contrary is rejected. And what interested me is the footnote there, footnote 4, which is the National Employers General Assurance case. And that's locus classicus for a contrary proposition. And that is when the probabilities are evenly balanced and you can't make a decision on the credibility of the witnesses, that you then make a finding that the plaintiff has failed to discharge its onus. So I just wanted you to explain this finding that you're rejecting one version and finding that the other version is true in a contractual context, and then using a locus classicus for a completely different proposition.
Yes. That locus classicus tells you how you deal with it when you can't decide. Therefore, I reference that because actually I find against that, but I have considered that principle, and that was the argument that people were making. And I was saying, no, this is actually not in line with that.
Sorry, Chief Justice, can I just make one more follow-up on these points of contract? I just want to just make sure that in the deliberations, I have a sense of your grasp of these concepts and what you will do on appeal. There was a debate you had with Commissioner, one of the commissioners, I can't remember now, around contract. It's triggered by the discussion you're having now with Commissioner Pillay. Maybe I should ask it differently. Can you set aside a clause in a contract because it is unfair?
You have to see whether the contract, you can't make a contract for parties. It is not for the court to say, this is unfair, you bargained a bad deal for yourself. The court cannot do that. You can only set aside when that term or contract itself is contra bonus moris, that's a different inquiry. But the fact that you've made a bad deal, the court cannot sympathize with you and then set it aside on that basis. No.
Thank you.
Sorry, Chief Justice, just the objection, if I can just put.
Yes, yeah, okay, please put the objection.
So, Judge, it was drawn to your attention that an objection had been raised with the commission by a litigant who had appeared before you. I think it was in a matter, you were presiding over an application to compel compliance with an earlier court order.
Yes.
And you granted default judgment in the absence of the litigant being in court.
Yes.
And the litigant has raised an objection that essentially says that you acted irregularly, Judge, and to just distill the objection, that questions are raised around whether or not you acted ethically in that process. I just wanted to give you an opportunity to respond to that.
Yes, that matter is now before the SCA, but I will deal with the matter and have dealt with it. It came to my attention late Friday. In my response, there's a letter from Advocate Brink explaining the long history with this particular litigant. This is a family issue and siblings fighting over a house, and one party deliberately trying to delay the process. When the matter appeared in front of me in the urgent court, there was a valid judgment, enforceable, no appeal against it. She was properly called to court, absented herself, which in the address to me was in line with what happened. And I put into operation the enforceable order that was in place in any event.
Thank you, Judge. Thank you, Chief Justice.
Thank you very much. Commissioners on virtual, I haven't.
Chief Justice, I just want to tell the judge that the objections committee dismissed the objection against you.
Thank you. There's no indication from the virtual platform. Thank you very much, Judge Bartman. We have come to the end of this interview. Once again, thank you for availing yourself. You are now excused.
Thank you.
It will remain with direct light.
Okay.
Good morning, Judge Coppin. Please switch on your mic and you can keep it on
Sorry,
until the end of your
morning,
interview.
Chief Justice.
How are you this morning?
No, I'm fine.
Good, good. I haven't seen you in a very long time, so I think you have been very busy at the SCA.
Relatively busy.
Relatively busy. Well, thank you very much for making yourself available for consideration for appointment to the SCA and for coming to this interview this morning. We will ask you questions aimed at satisfying us whether we should advise the president to appoint you as a judge of the Supreme Court of Appeal. In doing so, we will have due regard to the selection criteria that we have adopted as the commission. So our questions will be aimed at seeing whether those criteria are satisfied. You will be treated fairly. Nobody who is here wants to just make sure that you don't get appointed. Everybody wants to just make a fair assessment of your abilities with regard to the Supreme Court of Appeal. You understand?
Yes, Lord.
I will ask you some questions, and thereafter I will allow the president of the SA to put questions to you, and thereafter the minister, and after that other commissioners who might wish to ask you questions. You have supplied the commission with a lot of information, which we have in our bundle. All that information is taken as read, and in asking questions, we will simply seek to focus on certain areas that we would like to get answers on from you. I see that you obtained BA and LLB from the University of Witwatersrand, is that right?
That is correct.
And before you went to the bar, you were a teacher, teaching accountancy, and later on part-time lecturer at Wits, is that correct?
No, I was actually, I would say a full-time lecturer at Wits, but for 6 months.
Oh, you were full-time, okay. I don't know why I thought part-time, but that was for about 6 months, 7 months.
For about 6, I tried to, because I thought I can finish my master's degree.
Oh,
But I was also trying to combine it with practice at the bar.
yes.
And it didn't work because financially I couldn't survive. So I went back to the bar.
Yes.
And
And you started at the bar in 1985.
1 July 1985.
Yes, and in 2010 you took silk. No, 2005 you took silk.
I took silk in.
And in 2010 you became a judge of the High Court in Johannesburg. Is that right?
That is so.
And so that means you have been a judge for 13 years or so.
No, it's actually, I'm in my 15th year now.
Oh, you are in your 15th year
In fact,
now.
I'm already qualifying for my, I'm supposed to get it in the next few weeks.
Also, I see why you are emphasizing 15th year. Yes, and you have acted in the Supreme Court of Appeal quite a few times, is that right?
That is so.
The first time you acted was from December 2016 to 31 May 2017. And thereafter you started on 1 December 23 to 31 March 2024. And you say possibly next term too.
Yes.
Yes. Of course, it's not possible now. It is so, is that right?
It is so, yes.
Yes. Now, in the High Court, are you able to share with the commissioners what branches of law you have been able to write judgments in? The purpose of this question is to enable you to tell the commissioners the breadth of your experience as a judge. So what branches of law have you had a chance to write judgments in?
Well, being in the High Court in Johannesburg, you're actually exposed to a very, very wide range of matters. And I've never written, for example, the thing I can exclude would be, say, I never wrote on maritime law, for example. But somewhere
being in
along the
Joburg,
line, I was
understandably
exposed
so.
to it, yeah.
Being in Joburg, understandably so.
And then, Yeah, but otherwise one would have been exposed to bits of everything, I would think.
Do you want to specify branches of law where you have written judgment? That might help than being general, just to make sure the commissioners are aware
Well,
of their
company
breadth of
law,
experience.
contract, tax,
Tax,
company law, contract, tax, criminal law.
trademarks,
You don't see too much of that in the High Court anymore. I mean, maybe bits of it. As I say, I had exposure to that in practice.
yeah,
But in the High Court, you don't see much of that.
customary law,
Customary law, not really, no. Not in
Yes.
Joburg.
constitutional law,
I've written a bit on constitutional law. Yes.
yes,
It's actually my favorite part.
yes. And in the Supreme Court of Appeal, during the acting stints that you have had, what branches of law have you had a chance to write judgments in?
I think criminal law, contract, I think in those two areas. If you
Is
say
that contract and?
and criminal law, I think.
Yes. Well, in the context of the Supreme Court of Appeal, maybe I'm being unfair if I just limit
But I have sat in all
limit you.
in a whole
Yeah,
a
just
broad
hang
sphere of
on.
matters.
Hang on. Maybe I'm being unfair to you if, in the context of the Supreme Court of Appeal, I limit you to branches of law where you have written judgments.
Oh,
Maybe
and
you
I'm-
can share also branches of law where you were part of the panels, even if somebody else wrote a judgment.
And as I said, right now I'm writing on insurance law in that court. But I'm busy, I haven't completed.
Sorry,
Insurance
your
law.
voice. Come closer to the mic so that we can hear you. You are
I
writing
say-
on insurance law at the moment?
Insurance law, yes.
Yes. In terms of panels where you are sitting, what branches of law are those cases
Administrative
involved?
law, constitutional type of law. But administrative law mainly, but also things like property law issues. So for me, I don't really see the distinctions between these branches. It's all law.
Yes. Can you share with the commissioners your understanding of what the doctrine of the separation of powers is?
Well, every sphere, I mean, the different spheres of government, being the state, the
I'm sorry,
judiciary.
Judge Coppin. Can
state-
commissioners all hear him clearly? Can you hear me clearly? Okay, it looks like they do. Okay.
There are different spheres of government, different. The judiciary, the executive, and the legislature, and each has different functions to fulfill. And one must just usually make sure that you keep within your line, if you look at it from that perspective. That's really what it's about.
And the rule of law?
The rule of law, it's got lots of facets to it. It could mean, but technically it means that we shouldn't be resorting to self-help and vigilantism. We should be ruled by law.
President of the SCA?
Thank you, Chief Justice. Good morning, Justice Coppin.
Morning.
Justice Coppin, just following up on one of the questions that was posed to you by the Chief Justice regarding the spectrum of laws that you've had exposure to. Maybe I should just put the question differently to say, which new areas of law did you get exposure to when you were at the SCA? Something new that you had not been exposed to
No,
before?
I was not exposed to any new area.
You have not yet participated, you were not a member of a panel in a maritime matter?
Not yet, no.
Or a trademark matter?
No.
Not yet, I see. All right, so You indicated that you have been a judge for 15 years, but you'd agree that one's experience before appointment to the bench is also critical.
Yes.
Yes. It would seem from my calculation that before joining the bench, you were in the legal profession for approximately 25 years.
I would say 24, but I see
24.
they said 25, but it's actually 24.
I see. So before being invited to act at the SCA last year, you had last acted there in 2017. Is that right? Okay.
That is so.
Yes. Now, on your return to the SCA, how did you find the environment?
Well, it had completely changed. As I said, I actually went there with reservations, but I heard that it had changed. And when I got there, I was pleasantly surprised by the change.
Yes. What stands out in terms of the change that you are referring to?
Well, I must say the emotional IQ has gone up quite a lot. There's a lot more collegiality. People tend to work together more easily. There are less big egos. Because I remember my first nasty experience when I acted, the first time is I had to write a dissenting judgment. And that set the trend for me. That's in 2016. My first week, my first matter, I couldn't agree with the presider. And I had the task of having to write a dissent. And I was visited by all kinds of people that said, this is not the way we do things here. Mustn't come and do it like this and like that. And I just thought, because at that time I had already sat in the LAC, which had a completely different environment. There we could easily differ from each other, easily discuss matters, which was not there. People basically had the attitude that, how dare you? How dare you? And that's what stuck in my mind. So I didn't enjoy that first. Let me put it this way. I didn't enjoy that first part.
Yes. But you say now
It's a completely different place.
Yes, the environment has changed for the better in terms of collegiality. Would you say that collegiality is important?
I think it's very, very important because I've said as a single judge, I've made mistakes. And I know that those mistakes wouldn't have happened if I sat with colleagues, because they may have been able to see those perspectives. I think that's why you have multiple judges sitting in matters, so that what you don't see, after all, we're human. I'm not sitting here as a perfect human being.
Yeah.
I've got my faults. I've got my weaknesses. I make mistakes, but your colleague is likely to pick it up. And that's what I really appreciate from that type of work.
Would you say that the writing of judgments at an appellate level is pretty much a collaborative exercise?
Absolutely, absolutely a collaborative exercise. That's why I was happy when at some stage there was a requirement that we had to put up our judgments that we wrote as judges, single judges. And that would actually give you some indication of what I'm able to do as a single judge. But collaboratively, it's a collaborative effort. Because if I listen to my colleague and he comes with a suggestion I'm persuaded by, Alex, I can either accept it or go on board or not. But in the end of the day, it enriches me. And I look at it in that way.
Okay, so it being a collaborative exercise, then the handing down of judgments also depends on how quickly colleagues respond to the scribe's judgment. Is that correct?
That is in fact so.
Yes.
That is in fact so, because what happens if you give someone a draft, some colleagues would take a bit long to come back, and that has a knock-on effect, which would mean that the judgment gets handed down much later.
Yes. Have you ever delayed
No, not at all.
Yeah, either through not giving inputs or giving inputs
No,
late?
no, I usually tend to my input immediately. It's like with petitions, I read them immediately.
Yes.
I try to do that.
Yes. All right, so, you know,
I must just qualify it by saying I was given a judgment,
Yes.
I think on Friday, and I asked a colleague, I just need to prepare for this before I actually would respond to the colleague. So if that constitutes a delay, it's something that I've told the colleague about.
Yes, but generally you hand down your judgments promptly.
That is so. As I say, there's been a bit of a problem there in that court now. I saw with the researchers, where sometimes the judgment's given to the researchers, and there's a bit of a delay there.
Yes.
But that's only,
Yes, yes, you are alluding to a very important aspect, the inadequate research capacity at the SCA. Would you say that in itself then speaks to the need for judges that are appointed to that court to be self-reliant in terms of doing your own research prior to the hearing and doing research in preparing your own judgment?
no, I think so. I think you must do the best that you can.
Yes.
Mustn't rely on the fact that the researcher is going to be doing it for you.
Yes.
Fortunately, that's always been my habit. Even in the High Court, I almost never relied on the researcher. But I'm not saying that the researcher's role is insignificant. I think they play a very, very important role. Can only enrich your judgment by making use of a researcher. But I don't think one must become totally dependent on the researcher.
Yes. So you'd agree that judicial experience is important as well as your overall skill set?
No, absolutely. And
Yes.
you actually see it when you're dealing with petition, because they come in at the time when you're at your busiest. So you must be able to read it and immediately have that feel. And that feel only comes with experience.
What special attributes would you bring to the table at the SCA?
I think I've got experience over all these years. As I said, I'm not perfect. I've also got a lot still to learn. For me, life is it's a learning experience. I never stop learning. I don't know all the answers,
Yes.
but I think I have the experience. I wouldn't have applied much earlier than what I've applied. In other words, if I wasn't sure that I could make a difference, I wouldn't have applied.
All right, so my last question is, obviously you receive inputs from other colleagues. Have you had to change your judgment or to amend it on substantive issues because of the inputs that you received from your
No, I've
colleagues?
never really had to change on my judgment substantively.
Thank you. Thank you, Chief Justice.
Thank you very much, Minister.
I am fine.
You're covered.
Thank you.
Thank you. JP?
Thank you very much, Chief Justice. Good morning, Judge Coppin. You've sat extensively as an appellate court judge in the LAC. Am I correct? I can't hear you.
Please switch on your mic, and then you can
Sorry.
keep it on until the end
I'm
of
sorry
the interview.
about that. I've just about to finish my tenure term that I was appointed for in that court.
And have you also presided in full court appeals in the
High
division?
Court, yes.
Right. Your appellate court experience in the LAC, do you think that has equipped you sufficiently to sit in the SCA?
I think it has, but I must just say that different styles of writing. I mean, the LAC has its own strengths, the way they do things. Some things I admire greatly, which we don't find in the LAC.
Yes.
And, it would obviously enrich the LAC judgments, as I've said earlier. But the LAC, the problem in the the SCA, as I've indicated earlier, to do with personalities, the way things were done. Whereas in the LAC, there's always been this openness, which meant you grew quite quickly. And it was a pleasant experience to discuss with your colleagues. But as I say, the way the SCA goes about the business, the rigorousness of checking judgments and of making certain everything is, I think that could be emulated in the LAC. And as I say, while there we tried bits, but that could help.
Yes. And can you confirm that you've never had a problem with reserved judgments?
No, I actually dislike them because I found if you reserve them for too long, sometimes one is forced to reserve. I mean, I have reserved because of circumstances beyond my control. But it's something one doesn't encourage. I try to tackle the task immediately and get it done with.
You've never been reported, you've never reserved longer than 3 months?
Well, I see someone's, in one of the comments, I haven't really counted whether it was 3 months, somewhere it's mentioned that I had reserved for 4 months. I don't know. I've never checked.
Okay, thank you very much, CJ.
Thank you. Commissioner Teodoro.
Thank you very much, CJ. Good morning, Justice. I want to follow up the question that CJ asked you about the branches of law. And in your response, you said it's only maritime law that you are not involved in. Sorry, yes.
I'm sorry, Judge Coppin, keep your mic on, please.
It goes off. It goes off. I think I said trademark and patient. I haven't encountered those yet. Maritime law, somewhere along my practice, I had encountered it.
No, it's okay. It's okay. I'm not there. I was just
Please switch on
reiterating
your
what
mic. 1 second, Commissioner Teodoro. Secretariat, why is the candidate's mic giving problems today? Most of the time they can keep it on without any problems. Will you attend to it? Okay, all right. Thank you. Commissioner.
I wanted to ask you about public international law. South Africa is a signatory to the Rome Statute. We are a member to certain international organizations. And obviously, there are two courts, the International Criminal Court and the International Court of Justice, which are both in The Hague. What is the difference between the two?
Please switch on your mic.
One will deal with criminal matters purely, and the other one would deal with all other kinds of matters.
Can you elaborate that? What kind of, there are specific differences between the two courts, why they were established, dealing with international matters. And I want to test your knowledge in terms of the difference between the two. South Africa is featured quite prominently lately in respect of.
I must be
of
honest
those.
to say to you that it was one of my favorite areas of law, public international law. I haven't followed those developments too closely. I haven't had matters in that area.
And therefore, you don't know the difference between the two.
You mean the two courts?
Yes.
Not in that
You
area.
just say that the other one deals with criminal matters.
That's.
But there are distinct differences between the two.
I'm sure there would be, yes.
There are. And you are not familiar with that?
No.
Okay, it's fine then. Chief Justice, I was going to follow up certain things regarding that. Thank you.
Thank you very much. Commissioner Marmohai.
Thank you very much, CJ. Good morning, Judge Coven.
Morning, Commissioner.
I had a question that I wanted to ask you with regards to one of your judgments, but there's a statement that you made which makes me want to ask you the question, a different question. I'm not sure if you you have familiarized yourself with the rules of the Supreme Court of Appeal. Have you had an occasion to look at them?
You know what, because you hit the goal. I haven't really sat down and read them. As the cases come, I would look at them.
Yes.
If they become relevant.
Yes. I you know, I always wonder when I look at the rules of that court, and I always want clarity as to sometimes how things operate. Like, for instance, in the definitions, the rules define a court day, usually as any day apart from a Saturday, Sunday, or public holiday. But when you look at the rules that deal with special appeals and leave to appeals, the rules deals with a month, right? Which always, to me, I just wonder how that should be understood. Because when one applies for leave to appeal to that court, you will be told if an order was made by the lower court on the 8th of a particular month, by the 8th of another month, you should have your papers in. Otherwise, you have to apply for condonation. In your view, are these rules consistent with how we understand the dies, how they are calculated generally, in terms of the rules of other courts, and even in terms of the directives in other courts? Should it be like this? Do we need a month, which is not defined in the definition, or should there be like within 30 days? Will that not give more certainty?
Because as I say, a month is ambiguous. If you say a thing like a month, because it may mean one thing to someone and something else to someone else. So ideally, one would speak about specific days, or days rather. But yeah, I mean, I do agree that there's all those options, but sometimes that's what we have and we have to interpret it as best as we can.
So when you assist with such a case where somebody has, let's say maybe an order in the lower court was made on the 8th, and then the person brings an application on the 10th of the next month, is it compulsory for a person to apply for condonation and those? And if the person did not apply for condonation, can that be a ground for dismissal?
That would have to be, I mean, I would have to be persuaded one way or the other. As I say, for me, if that is the case, maybe I'll be inclined to condone if the other view is that it's not a month, because it may reasonably be interpreted to be a month. But it would be a matter of how I'm persuaded by the arguments to inform.
In a panel, the two of you, there's no case to be persuaded. You are just looking at the papers. But anyway, I'll leave it there.
We may have to debate it between us, because my colleague may have a different view.
Thank you very much, CJ.
Thank you. Commissioner Singh.
Yes. Yes.
I do not know if you are aware that there are a number of students, South African students who study abroad, that feel that they have been prejudiced by the HSPCA, and they've even gone to court on some of these matters, and the court have made findings in their favor. Now, many of these students study abroad, either in Cuba or in other parts of the world, because of the lack of capacity, space capacity in South Africa. And they often feel prejudiced because when they want to come back to South Africa, they're not given an opportunity to write board examinations on time or gain acceptance into medical institutions. What is your view on these South African students who train abroad and want to be accepted into our medical system? Thank you, Chief Justice.
Well, I don't know whether you're asking my view as a lawyer or just as an ordinary human being, ordinary citizen.
Well, I think because you served on the HSPCA.
No, but the last time I served was in 2007. Don't even know how relevant my views would be now. And one doesn't know the specifics. I don't know the facts. Why they're not being treated as they think they ought to be treated. I would have to know the specific facts before I can comment.
So what you are saying then is, in your tenure on that board, you did not become aware of the challenges
No,
faced by South African students
no,
studying
I think
abroad.
up to the time when I was there, no, that was not the case. I was there when that board was in transition. Subsequent to 2007, no, I didn't really keep up with what was happening in that field.
Now, then I can't ask you anything further if you were not there at that time. But in after that, you're not aware of any matters which you may not have presided over, or you're not aware of matters that the South African students who study abroad are facing, the difficulties?
I'm not aware of specifics. I mean, what I know is what I see on television or read in the paper. But I don't know all the facts.
Okay, thank you very much, Chief Justice.
Thank you. Commissioner Mangena.
Thank you, Chief Justice. Good morning.
Morning, Commissioner.
Judge Coppin. You are the first judge to deal with the claim of Mr. Makate against Vodacom.
Yes.
Yes. It's common knowledge that that judgment went all the way to the Constitutional Court. And you dismissed Mr. Makate's claim on two grounds.
Yes.
Prescription and
ostensible
authority.
Yes.
And the Concord said that you add in conflating ostensible authority with estoppel. That's one.
Yeah.
Two, and which is the basis of my question, was that you refused to, or you, is refused the right word? Or you were reluctant to develop the common law relating to prescription.
One doesn't, out of one's own motion, develop the common law. There was no case before me. There was no constitutional case before me. The case that was argued before the Constitutional Court was a total different case. In fact, if I'm telling you now, I don't know how I would have decided it if it was argued before me the way it was argued before the Constitutional Court. You can look at that judgment, you'll see the team changed almost completely. I had at the time, two of the most senior people against each other before me, with big teams. After they went from my court to the higher courts, the teams changed completely. The whole case took on a new dimension. And as I say, it's possible that if what was argued before that court had been argued before me, my decision may have been something else.
The question of ostensible authority was actually the basis of your dismissal of the claim.
Well, the point is that's the way I obviously assessed the facts, and it was my understanding of ostensible authority. That's not free from contestation. I mean, you can see in that particular case, there's no unanimity on that issue. I still don't know what it is. Now, since that particular case, if you read the academic writings, I'm interested to see what the next case is that's going to be dealing with that particular issue of ostensible authority, what it says about it. Because then we can talk. Right now, you have those different views that were expressed. Yes, there was a majority, and one accepts that. But that's how law is.
Okay. All right. But relying on precedent, do you accept?
I'm bound by it.
Thank you.
I was bound in that case by precedent. In fact, in respect of the prescription issue, and the other issue. I was bound by precedent.
Thank you.
Thank you. Commissioner Nyambi?
Chief Justice, I do want to follow
I'm
up
sorry?
on Makate.
Oh, yes.
Yes, before, unless Commissioner Nyambi also wants to talk about Makate. Yes, Judge, I'm interested in the point about you saying that the case argued in the Constitutional Court was a different case to what was argued before you.
Yes, I mean, if it's about, as Commissioner has pointed out, developing the common law, I wasn't asked to develop the common law.
But that's the point. There was no request in the Constitutional Court to develop the common law. It was a question of the meaning of the word debt under the Prescription Act, which you also applied.
Yeah, but you see, in my case, there was no contestation. There was a case, appellate division case. And these two senior counsel, they didn't quibble about whether or not it's applicable. In terms of precedent, that was the law. So
Yes.
there was no issue about me developing it further.
That's what I'm saying. I don't read the Constitutional Court judgment as developing the common law. It was about what does the word debt under the Prescription Act mean.
Yes, and then
that
that
was
court-
the same issue before you.
Yes. No, I appreciate that, Commissioner Kaitobi.
Yes. Now,
But there, as I say, there were the two cases in the, one was the Appellate Division, Supreme Court of Appeal, and they chose the latter one that gives a narrower definition to debt.
yes, in fact, I always thought that the good part about your judgment was that you found that the CEO of Vodacom had lied about him having developed the product, and you conducted an extensive analysis of the evidence, which has never actually been overturned throughout these rounds of litigation. In fact, the basis of the further cases have been the acceptance that you were correct in rejecting, I think it was Alan,
Yes.
not Craig's lies about the fact that he developed the product.
And I actually found that it was his idea. In fact, that was a very hard case for me to decide. As I say, if whatever had been argued in the Constitution, I don't know how I would have decided it, whether I would have come to the same, I don't know. But it was one of those hard cases that I had to decide. Because here I saw this person has to fail because of prescription and ostensible authority. Yet his idea had been used by Vodacom, and instead of owning up, they tried to cover up.
Yes.
Not an easy case.
Yes, I also got interested in your CV that the two judgments that were overturned by the Constitutional Court, Nyataza and Makate, were about prescription. So it seems you are very conservative on prescription.
No, well, I thought some people are very scared about prescription. In fact, if you look at the law now, the law in that court has developed to the extent, because Nyataza didn't yield a ratio. It was a split decision, 5-5. So if you look at the law now, in fact, if Nyataza had to be decided now, it would be a different result.
Yes, I always thought that 3 years is too short without a possibility of condonation. And that's really the problem, is that they need to give 5 years or 6 years.
Well, I think I'd agree with you, but as everyone says, prescription cuts both ways. Sometimes it comes to the rescue of this poor person that's being hounded by debtors. And you just feel, oh, if this prescription period had been shorter, maybe it would have been better for this person. So it cuts both ways. Prescription doesn't only hit one way.
Thank you, Chief Justice.
Commissioner Nyambi?
And thank you, CJ. Morning, Judge Kobe.
Morning, Commissioner.
I've got just one question. Already, the president of the SCA has covered your first and your second experience in the SCA.
Yes.
So, linked to that, I'm interested in what do you think are the immediate challenges facing the SCA currently, as we have been there and hope even last March?
I think it's challenges facing all the courts, in fact. It's attracting people with the necessary skills and experience. That's what's facing all our courts. It's a concern for the High Court, for the SCA, and I assume for the Higher Court, the highest court in the land as well.
Are you of the view that you are the right candidate to address those challenges that you have highlighted in terms of SCA?
Well, as I say, if I was not, I wouldn't put my hand up. My record is there for everyone to see. I think I can make a contribution. I'm not perfect, as I said. It's a challenge, but I'm up to the challenge, I think.
Thank you, Judge Corbin. Thank you, CJ.
Thank you, Commissioner. There are no further hands. I think we've come to the end of this interview. Thank you very much, Judge Coppin, for availing yourself. You are now excused.
Thank you very much.
Good morning, Judge Kitley.
Good morning, Chief Justice.
How are you this morning?
I think the accurate description is as well as can be expected. I trust you are well.
I think that's good enough. Thank you very much for availing yourself for consideration for appointment to the SCA and for coming to this interview this morning. We will ask you questions which are aimed at satisfying us to what extent you meet the selection criteria that has been adopted by this body for judges for appointment to various courts. We might ask you difficult questions, but nobody will be meaning to treat you unfairly or in any way wanting to block you from appointment to the SCA.
Thank you.
Everybody will just be trying to satisfy themselves that you meet the criteria.
I understand.
Yes. We have got our bundles which have got a lot of information here that you have supplied. Therefore, we are not going to seek to cover the information that we have. Everybody is presumed to have read the bundle. We will seek to simply highlight or focus on certain areas that we will be wanting to test you on.
Thank you.
And I will ask you some questions, and thereafter I will ask the president of the SCA to ask you questions, and thereafter the minister and other commissioners who might wish to put questions to you. Okay.
Good, thank you.
Thank you very much. I see that in terms of your academic qualifications, you obtained a BA from the University of KwaZulu-Natal. It was known as University of Natal then, 1982. You got LLB summa cum laude from the same university, and you got LLM first class from Cambridge University in the UK in 1988.
Correct.
And you served articles, and you got admitted as an attorney, is that right?
Yes.
And you practiced as an attorney for 1 year or 2 years, is that right?
I think
for
it was
time.
Probably around a year.
Yeah, around a year, yes. Over the period between then and your appointment as a judge, you spent some time in the academia. You were a lecturer, a senior lecturer, and an associate professor.
That's correct.
And you also spent some time in the asset forfeiture unit of the NPA, is that right?
Yes.
How many years did you spend there?
I think I spent, it was until 2006.
Yes.
It was 7 or 8 years, if memory serves me correctly.
Yes.
I was there from more or less the beginning of when the asset forfeiture unit started.
Yes.
Until I felt I wanted to move more into general law.
Yeah.
I felt I was getting a little bit too specialized.
Yes.
And that's when I went to the bar.
Yes. And at the bar, you didn't spend many years successively practicing. You were always also doing other things, including teaching a little bit, is that right?
While I was at the bar, I was appointed as the director of the Center for Applied Legal Studies at the University of the Witwatersrand, which is a very old, well-established human rights institute.
Yes.
And for about 3.5 years, I ran my bar practice concurrently with heading up the Center for Applied Legal Studies.
Yes.
And then went back full-time to the bar.
Yes. While you were practicing at the bar, did you do any substantial number of cases that got reported in the law reports?
I haven't looked at that for a while since my interview for for being appointed to the High Court.
Yes.
But I do remember including some that were.
Yes.
I remember appearing before the Constitutional Court
Yes.
in a matter where I represented the Centre for Child Law.
Yeah.
And that matter was reported. I can't remember the name. I'm sorry.
No.
But that matter was reported. And then
Yes.
there were a number of others that were reported where I was junior counsel.
Yes.
In the Constitutional Court matter, I argued as counsel.
Yes. No, that's all right. And as a lecturer and associate professor, you also published some articles.
Yes.
And you wrote chapters in a
That's
number
correct.
of books, about what, 11 books?
No, I think that those were the articles. Oh,
Yeah.
if you count I used to do the chapters on trusts and succession
Yes.
for the annual survey of South African law.
Yes.
And so, yes, you are quite correct. I did that for a number of years.
Yes, I see that actually you wrote and edited 2 scholarly legal books.
Yes.
And 16 book chapters.
Yes.
And 11 articles in
Yes.
peer-reviewed academic journals.
Yes, absolutely. That is correct. Most of my articles were on human rights topics.
Yes.
And then, of course, more sort of the annual survey chapters were more straight down the line law,
Yes.
succession and trusts, although
Yes.
the law of succession obviously has its constitutional aspects as well,
Yes.
particularly in terms of gender equality and so on.
Yes. Of course, in the questionnaire, you go on to indicate some of your articles which have been cited
Yes.
in decisions of various courts.
That's correct.
And I think you mentioned the Constitutional Court in one or so cases as well.
Yes, that's correct. I think that was the one on public international law is one of my areas of law that I taught and wrote in.
Yes.
And I think that was one of the articles that was referred to. The other one that has been referred to rather often is on the Extension of Security of Tenure Act.
Yes.
So that was on land restitution.
Yes. I see that you say that I think you have covered almost all branches of law as a judge of the High Court, if I understood
I think
the question correctly.
the only field of law that I can't recall writing on is shipping law.
Yes.
And there's an obvious reason if you're in the Gauteng High Court. There are not many ships that dock within our jurisdiction. So, but I think I've covered the field, so to speak.
Well, I don't know if you are able to, but you should be able to at least mention as many branches of law as you can remember in which you have given judgments.
Certainly. Administrative law, I've dealt with a number of administrative law judgments. Constitutional law, I've developed the I've developed the common law in YG versus the state. That was the judgment dealing with the reasonable chastisement defense in our law of delict. And there have been other cases where I have dealt with constitutional issues. Contract, commercial law, I've written a number of tax judgments, one of which was upheld by a full court and then subsequently also upheld in the Supreme Court of Appeal. That was Commissioner of the South African Revenue Service and BMW. I have written in patent, trademarks, unlawful competition. I have written equality court matters involving equality court, matrimonial matters, children's matters. What have I left out?
Customary law?
Sorry, Chief Justice?
Customary law?
Customary law I have.
Yes.
I have. Not reported judgments. And I was hoping to get a reported judgment because one of the judgments that I was assigned to scribe in my last term at the SCA was the King Partlaw judgment. And then, unfortunately, because of information we received at the hearing of the matter, it turned out to be moot because the president had already appointed the king. So it ended up being a judgment on mootness rather than on customary law. But I also taught customary law at university.
Yes.
So I am familiar with it. And in Johannesburg, it's not unusual for us to get customary law cases. And so I'm very familiar with the area.
Yes. And the labor law?
Labor law, no.
Okay.
I did do labor law when I was an articled clerk. In fact, I brought labor law matters into our firm and did a number of unfair dismissals. But when you get into practice, you are, as an advocate, you're largely determined by the briefs you get. And for whatever reason, labor law didn't come my way. The closest we get to it in the High Court is really when you're dealing with those barrier cases, when I say border cases, borderline cases where a person may bring a case to you that deals with employment, but they bring it on a contractual or an administrative basis rather than straight labor law.
So constitutional law, administrative
Criminal law,
contract
procedural
law, criminal law,
procedural law,
trademark law,
patents,
patent law, yeah,
tax
you've done
law,
it, tax law, international
company law, business rescue.
Yes.
I've said equality court. I was
Yeah.
trying to look at it alphabetically, but that doesn't always doesn't always help one.
Yes. So you have had quite
I've had very
wide experience.
very broad experience. I've been very lucky in the division I am in.
Yes.
We do get a range of matters that come to us.
Yes. Would you like to share with the commissioners your understanding of the doctrine of separation of powers? Separation of powers?
Very simply, I believe, as an ex-teacher, I believe in trying to explain things simply. So I'll endeavor to do that. Essentially, under our constitutional system, there are three branches of the state. The executive that really has the task of giving effect to laws, putting them into action and application. We have the legislature, which makes statutory laws. And then, of course, we have the judiciary. And the doctrine of separation of powers recognizes that each of those branches of government, well, of the state, not government, of the state, operate within their defined spheres, and that they should not trench on the sphere of any other unless they are lawfully entitled to do so under the Constitution. An obvious example of that would be the judiciary can and must rule on the constitutionality of executive action and obviously of legislation.
And rule of law?
It can mean many, it's a very broad concept, but from a constitutional point of view, well, broadly it would be rule by law. It's a founding value in our constitution is the rule of law. But really, my understanding of it from a constitutional point of view, it's very closely linked to separation of powers. And it would mean that each branch of the state cannot exceed what they are lawfully entitled to do. And so it really ensures that government as well as other arms of the state and organs of state operate within their constitutionally and legal defined boundaries. And that's to ensure that there's certainty, it's to ensure that there's constitutional security in the state, and the different branches and organs of state can be held to account, generally through the courts, if they act beyond their permit because they would then be, they would have undermined the principle of legality, which of course forms, I think, the core of the rule of law from a constitutional point of view.
Thank you very much. President of the SCA.
Thank you, Chief Justice. Good morning. Good morning, Justice Kitley.
Good morning, President Molomela.
Just following up on a few questions that
Yes.
were posed to you by the Chief Justice.
Yes.
It seems to me that you have had exposure to a broad spectrum of branches of law.
Correct.
Yes. I tried to establish from your CV, but I might have missed it. I'm curious to find out on what subjects or courses you lectured on at
Yes.
VIS and UCT.
Yes. I started my lecturing career, in fact, being responsible for devising a course falling under the academic development program. So it was a bridging course for law students who had potential, but who came from disadvantaged backgrounds. At the same time, I lectured in the introductory courses, Introduction to the Study of Law. I then also lectured in family law. I lectured in succession. I lectured in African customary law. I lectured in public international law. When I went to the University of the Witwatersrand, I continued to lecture in public international law. I lectured in the law of property as well. And then generally, I think that probably covers it.
I see. And so you mentioned that at the High Court you were never exposed to shipping law, which is
Yes.
not surprising.
Yes.
But have you ever had to be in a panel in a matter that deals with shipping law, maritime law at the SCA?
I haven't as yet. I look forward to that challenge.
I see. All right. So you started acting at the Supreme Court of Appeal last year.
That's correct.
And that was your very first acting stint.
Yes.
How did you find it?
I found it challenging, but in the most positive sense. I enjoy a challenge. I know that I'm up for a challenge. And I really, it pressed those buttons for me. I found it to be stimulating. I enjoyed the teamwork approach that one has to adopt if you're sitting in an appellate court where you are not the only judge. I learned a lot from the interchange of ideas and particularly experiences which one gets from a transformed court like the SCA.
Yes.
I enjoyed the discipline. I like the fact, I enjoyed the fact that you have to be prepared for your hearings, and then you must produce your judgments with quite a quick turnaround. I found that I had enough time to do that. I am quite an efficient worker, and I enjoyed working to that timetable. So all in all, and the collegiality was unbelievably positive. It really is. It is a court that is driven by the sense of a team, which I found to be extremely, extremely heartening. And could I just end off by saying, I realized when I've always, well, it really is a privilege to be invited to act there. And when you get there as a high court judge, particularly if you come from a very busy division, you realize how much of a privilege it is, because it's a small court, but yet it's dealing with, for the most part, it is I know it's not the apex court, but for most litigants, that will be the court of last call. And so I had an overwhelmingly positive experience at the SCA.
Thank you. I'm glad to hear that you were not overwhelmed, because I was very conscious of the fact that you were acting there for the first time, and unfortunately you came there during lean times. You
Yes.
know, when judges have to rely on only 3 law researchers. And that means that, you know, you have to be able to be self-reliant and to
Yes.
work independently. Would
No,
you
I-
say you managed that very well?
Oh, without a shadow, I am self-reliant. I went to boarding school at the age of 6. And so I learned to be self-reliant from an early age. But I'm an efficient worker, and I'm one of those judges who can hit the ground running. And I remember President Molomela, I don't know if you remember this, but I was supposed to act for the 4th term of last year and the 1st term of this year. And you called me up early and you said, "Are you able to come a term early?" And that was at the beginning of July. And the term started in mid-August. I got my records from the middle of July onwards. But I'm not easily overwhelmed. And I felt I didn't feel overwhelmed, and I certainly hope I didn't give the impression that I was overwhelmed. I felt I was able to cope adequately.
Yes. And you touched on collegiality. You realize the importance thereof since, you know, we all work as a panel.
Absolutely.
And-
Yes, I really do, and I enjoyed working in a collegial way.
Yes. And you'd also be mindful of the fact that you know, judgment writing is a very collaborative exercise at our court, so you depend on the inputs that you get from other colleagues as well. So
Yes.
during your stint, were you giving a lot of inputs to other colleagues? Were you also receiving inputs, and were you amenable to incorporating those inputs?
I received, and I believe it's one's duty to give comments and make suggestions. It's courtesy. You've expected your panel members to be doing it for your judgments, and so I would make a point always of giving what I felt would be helpful suggestions. I always accept suggestions unless I don't agree with them, because I understand the teamwork ethic. If people are going to agree, they must be comfortable in agreeing to your judgment.
Yes.
So my approach is to accept, if I don't agree, and then I would normally talk to the judge who's making the suggestion and discuss it if needs be. I never had any of my judgments substantially rewritten or substantially commented on. They mostly were received favorably, and certainly with very useful input to make them better, which is to be welcomed, and I certainly welcomed it.
Yes. Have all your judgments been handed down promptly or produced promptly at least?
I have a record in the High Court. I think all of my judgments, bar 1 or 2, were within 3 months. At the SCA, I had hoped that they would all be handed down now. We're conferencing a judgment I picked up in the very last week of me acting there. We're conferencing that one on Wednesday. And then there's one outstanding which has a very long history, and I anticipate we'll be conferencing that one next week.
Yes. And you've never been the source of a delay in another colleague's judgment in terms of giving your own input on that judgment, or in terms of taking long to write your separate judgment if you have chosen to write separately?
Not that I'm aware of. I've tried to give my comments promptly because that is the mode of the court. That's how it operates.
Yes.
I've written one dissent together with Judge Faiza Kathri Setlwane, and that was delivered promptly. The dissent was delivered promptly. The judgment also had a long history, but that wasn't because of our dissent. It took a long time to get there.
Yes.
So no, I can say in all honesty, I've never been responsible for that.
Yes. So I see you've been a permanent judge for 8 years.
Yes, I'm in my 9.
Yes. But prior to your appointment to the bench, you were in the legal profession
Yes.
for approximately 27 years.
I'm in my 39th year of legal practice.
Yes, okay, I've got it wrong here. I've got it as 35. So it's actually 39.
Yes.
Yes. So what, in your view, is your special attribute that you will bring to the table at the SCA? What will be your most important contribution? I'm asking this question because, as you are aware, we have lost a lot of colleagues due to attrition. As a result, we have lost a lot of experience and
Yes.
expertise. So my question really is, what will you bring to the table in terms of experience, expertise, your skill set in general?
I think I'm quite uniquely placed in that regard. I have many years of legal practice in many diverse fields, and they have all contributed to the judge I am today. And I believe those areas of activity, so being an attorney, which means engaging with clients, being a professor and lecturer, being an advocate in private practice and in the state, and being a judge and heading up a human rights organization. I'm used to leadership. I am able to act independently. My skill set is such that, I said it earlier, I can hit the ground running. I'm confident in my skills because of my background and history. And my knowledge of the law spans the gamut. I've written on the gamut of the law. And the other thing I think that I bring to the table is that I have an ability, and that's demonstrated in my judgments. I have an ability to, when I'm faced with an area of law that I didn't practice in, like tax law or patent law, I can very easily get on top of that and render judgments that are solid. And I think that is particularly needed in the SCA. You know, in the SCA, you deal with everything, bar, competition law, and labor law, quite frankly. And so the SCA really requires judges like me who have that breadth of experience which has been put into practice, not simply in an academic sense, but in a real practical sense. And then finally, I think my judgments and my life story show that I have a demonstrated record of understanding the need to progress the Constitution. I understand what it means to be a lawyer and a judge in our constitutional dispensation. And so in some of my judgments, I have developed the law. For example, in YG versus the state, I've developed the common law. So I'm not afraid to do what it takes, to act fearlessly and without fear and favor, and to promote the Constitution and constitutional values.
Thank you very much, Justice Kitley. Thank you, Chief Justice.
Thank you, Minister.
Yeah. Thank you very much, CJ. With your indulgence, I've got two questions. Good morning.
Good morning, Minister.
Yes, my first question relates to your judgment that was confirmed by the Concord in the separate matter of the religious, but is the YG versus the state.
Yes.
Yes. I'm just interested in the reasoning that you had put there, that I'm just looking for the correct wording. But it is to the extent that the court had implored that parents must find a different form of disciplining their children.
Yes.
Because of the removal of the common law justification or defense.
Yes.
What kind of discipline were you envisaging in that judgment? Because there is just confusion in society now. How should parents handle the discipline of their kids?
Certainly the judgment didn't say how parents should. But what it turned on was the common law principle that gave a defense that to a charge of assault that existed only for parents or other caregivers when chastising their child, punishing their child. And it was on those grounds and within the context of the rights of children that I found that the common law, continued common law recognition of allowing parents to raise the defense that they were meting out what essentially would otherwise be an assault in the name of discipline and punishment was okay in the common law. And that I found was contrary to many of the children's rights that are embedded in our Constitution, as well as to basic rights of dignity, bodily integrity. And it was ultimately upheld, as you know, by the Constitutional Court, not necessarily along the same line. So it was a straight, I approached the matter from the point of view, was there infringement of rights? Yes, there was. If there was an infringement of the right, was that infringement justifiable under Section 36 of the Constitution? And I found that it wasn't justifiable. And so in that sense, we didn't go so far as to say how parents should. What we were saying is if you choose to, what the effect of the judgment is if parents continue to choose corporal punishment, to enforce discipline on their children, they will be open to being charged with assault, if that should happen, on the same basis as anybody else who has assaulted any other person. So that was the effect of the judgment. It doesn't, I don't think it had the effect of immediately stopping parents from meting out corporal punishment. But they need to know that if they do, they can't come to a court and say, but it was okay because I was disciplining my child, and our law for well over 100 years has recognized that that's okay. So that was the thrust of the judgment. I'm not sure if that answers your question, Minister.
Yeah, no, it does.
Thank you.
My second
Could I just say, I think it does need the limits and the boundaries might need extrapolation in statute. So that may well be something that your ministry is considering.
Yes, it is. That's why I'm asking. But
yes.
Thank you very much. I think it helps. The second one, with the indulgence of the Chief Justice, is in relation to NA and others versus the National Director of Public Prosecution. On how you...
I'm sorry, Minister, I just didn't get that. The acoustics in this room aren't great.
NOP and others versus the
National
Director of Public
I've got
Prosecution.
you.
Yes.
Yes.
The differentiation on the restraint order granted under
Yes.
Chapter 5 of POCA and under Chapter 6.
Yes.
And why did you deem it necessary that it should not be appealable? Because this seems like a very drastic kind of a decision which obviously sees the assets of someone. I just want to get the...
I won't run through the whole judgment with you. I'm sure you can read it for yourself. But essentially, I analyzed the two systems, Chapter 5 and Chapter 6, and where the initial orders, so restraint under Chapter 5 and preservation under Chapter 6, I looked at the purpose of those two different types of infringing on the right to deal with one's property, as one normally would, and what the purposes were that were being served by it within the framework of the Act. But also, very importantly, there are important procedural differences between the Chapter 5 restraint order and the Chapter 6 preservation order. So the restraint order, generally speaking, the parties don't come back to the court, the High Court that granted the restraint order. That order stays in place until the conviction if there's a conviction, the sentence, and then the actual forfeiture of the property takes place after conviction and sentence. And procedurally, the civil route of asset forfeiture is very different. So the preservation stage is intended to be short. It's intended to be just a precursor, keeping assets safe, while the civil follow-on process, which happens in the High Court and has nothing to do with conviction. One doesn't even need a conviction until that runs its course in the same High Court. And so there are very important procedural differences, as well as, if one looks at the purpose of each, the role that each one plays in the framework of the Act as a whole. And really it was on that basis that I differentiated between a restraint order, saying it's different in its legal nature and effect, and a preservation order, different in its legal nature and effect. And for that reason, not appealable, because Chapter 6 allows the parties, and in fact makes it plain that parties should hurry up and get into court so that the court can make a final determination on the actual forfeiture of the property. Does that explain sufficiently succinctly to you, Minister?
Yeah, no, it is, because we have been criticized, as you are aware, that such are sometimes very drastic to the people that are affected by
Yes.
such an order.
Yes.
And yeah, because
I understand that, and you know, I was in on the ground when that law was sort of put into practice, and I think the courts have recognised that there is a need for that law if you are going to combat criminality, and particularly organised crime, and so I think it has found its feet. Yes.
Thank you, CJ.
Judge Ketty, I may not have heard you correctly.
Yes.
But did you say something along the lines that the SEA does competition law cases and labor law cases?
No, I said the opposite.
Oh, okay, all right. Okay, no, that's all right.
Chief Justice,
Okay.
I said the opposite.
Okay, no, so I didn't hear correctly.
Yes, you did.
Commissioner Marumwakai?
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Professor Marumakai.
I have a question for you that arises from one of the decisions that you wrote.
Yes.
But the question is more academic than anything else. Perhaps maybe it might have a practical effect depending on how you answer it. There's a particular doctrine that you dealt with in as MSM on behalf of KBM versus Minister of Executive Council
Yes.
for Health.
Is that one of the judgments that I cited?
Yes, it is one of the judgments that you provided. I'll give you the citation now. It is on page 27 of the bundle.
Yes.
Yes.
Is that National Credit Regulator?
No, not that one. The one where you dealt with the defense of.
Oh, MSM and KB. I've got you. Yes.
Yes.
It's my bundle 28, but I've got
Yes.
it. Yes.
No, actually you are right. It's 28.
Yes.
In this case, you are dealing with a doctrine
Yes.
of public health care defense that we saw has been used by government to ensure that it limits how compensation is ordered when the public facilities
Yes.
can provide. I have my question starts here. Is this a common law doctrine? Because I see a lot of cases referring to this doctrine as a common law doctrine, and a lot of writers refer to this as a common law doctrine.
Yes.
But I cannot see the root of it as to how you can associate it with the common law as a principle? That would be the first part of my
Yes.
question. The second part of my question will be whether or not it's a common law thing. It's part of our law, but obviously we know in Mashinini it was disturbed somehow. What is the future of this doctrine when one looks at the current National Health Insurance Act? Is it something that will see more development if NHI is implemented? I mean, there are people who believe that it cannot be implemented, but assuming
Yes.
that it can be
Yeah.
implemented,
Yeah.
what will then be the future of this doctrine? But the first part of the question, I think it's more important because it creates more challenges than.
Yes, thank you, Professor. And you've picked up on something about which there is a lot of confusion among legal commentators and on this very issue. It's well explained in the Constitutional Court decision of DZ, which opened the door. And in fact, one needs to understand that there are two, it's generally referred to as the public healthcare defense. It would probably be better to call it the public healthcare remedy, because it really is a remedy, it's not a defense. What DZ recognizes is that within the bounds of ordinary delictual principles, it is incumbent on a plaintiff to prove their damages, and therefore they must prove the amount of damages. And it is even under common law open to a defendant to say, you have asked for too much by way of damages for future medical expenses, because these services are available to you in state hospitals. You are more likely to use state hospitals, and therefore in fact, your damages for future medical expenses should be limited because it's reasonable damages, should be reduced by 50% or whatever, because most of those services you're going to access and pay nothing for in a public hospital. That's within the bounds of the common law, and I think the ACA case there was Ngubane, which understood that. And that's often confused with the public healthcare remedy. The public healthcare remedy doesn't fall within the common law, and the reason it doesn't is because the common law says that you must prove your damages, you must prove them once and for all, now and in the future, and critically, they are paid in money. And that's where the development of the common law comes in, because with the public healthcare remedy, what the state asks is that it asks that instead of giving money for services, it will be ordered to provide those services to the plaintiff, and that is then made part of the order. So it's actually a form of compensation. It's a form of damages, not sounding in money. And that's where the development of the common law comes in. So it's all very well explained in DZ. And I think it is important to make that distinction. You have to develop the common law if you are going to recognize that delictual compensation can be in a form other than money by the provision of services, and you oblige the state to provide those services. That's the development of the common law, and that's what I did in MSM.
Thank you very much. Thank you very much, CJ.
Thank you.
Do you still want an answer on your second question?
No, I think you do partly cover it.
I was just going to look in my bag
Yes.
for my crystal ball.
Commissioner Nochesi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner Nochesi.
I have thought that in your debate with the Chief Justice on customary law, you tell him that you actually come from the province of legends. You grew up at Nalini.
I did.
I thought you would say that.
Yes,
exactly. I thought you would say that. And now, my question really, Judge, quickly. In fact, I've been following your judgments, well reasoned,
Thank you.
well articulated.
Thank you.
Now, tell me, what do you consider collegiality
Yes.
as a key component of a judicial officer? That's only that question.
You're asking if it is a key component? Absolutely. And I think I think on a court that always sits in a panel, the appellate courts always do, whether it's 2 in the High Court, 3, there's collegiality amongst your colleagues. And a court system can't function without that collegiality. You need it. You need to know you're all on the same page, and you need to be directed. And might I just say, I think it extends beyond collegiality with colleagues. Judges need to be seen also to be collegial, and to understand being a judge is a privilege, wherever you are, and you are serving a community. And so, it extends beyond that as well. But I absolutely agree. Collegiality is you will not be a good judge unless you are collegial.
Thank you. Commissioner Makwanishe.
Thank you very much, Chief Justice. Good afternoon, Judge Ketle.
Good afternoon. There you are. Good afternoon, Commissioner.
Thank you. What are the requirements of a class action, and how does it differ from traditional individual lawsuits?
Oh, that's an area that I haven't dealt with. Thank you. I haven't yet had dealt with the class action. So that was a flag for one of the areas I haven't dealt with. Class action is, as I understand a class action, you need the class to be certified and the action to be certified by a court as a preliminary measure, as a preliminary step before the action can be taken forward. I'm making it sound far more simple than it is. It really is very complicated. So you have got to persuade the court that the class of persons who will form the basis of complainants are a class, and that they are, for example, sufficiently bound together with the legal issues that will be determined to be considered to be a class. You have also got to persuade the court that the issues in the case are suitable for determination as a class action. Because you may, for example, have an action against many different defendants. So if I think of some of the class actions involving silicosis, that was against many different mines or mining companies, and occurring over time. And yet you want in one action for those issues to be determined, not on a single litigant, single defendant basis. So you need to persuade the court that there is sufficient cohesiveness also in terms of the action itself, that it should be certified by the class. And there are also all sorts of other requirements that must be met. It is preliminary, and I understand the Supreme Court of Appeal has held it's not appealable, that certification, or not. If certification is granted, that it's not appealable.
Thank you very much, Chief Justice.
Thank you. I have only 2 more, and those will be the last 2, and that's Commissioner Moimang and Commissioner. There will be the objections and complaints side, but I'm now going to Commissioner Moimang.
Thank you, Chief Justice. Good day, Judges Kathleen.
Good morning, Commissioner Moimane. Not my Mane. I mustn't. It's election season. I shouldn't get that wrong.
It's Moimang.
Commissioner Moimane.
I'm sorry. Before we proceed, let me mention, with the past 2 candidates, we were doing roughly an hour. We are 1 hour 15 minutes with this one. So I'm just warning everybody. Okay, go ahead.
Duly noted, Chief Justice.
Thank you, Chief Justice. In the judgment of AfriForum,
yes,
versus the chairman of Council of UNISA,
Yes.
The AfriForum took issue with the remarks that Justice made, because in your remark you said, as South Africans who have less melanin than our fellow South Africans, we could learn to move more forward than more back. I'm more interested in terms of your reflection on the fact that AfriForum took issue with that, but locate that within the values of our constitution, particularly section 1 that talks about those values. Thank you.
I'm constrained not to answer you with my perceptions on the complaint, because there was a formal application for my recusal from a panel dealing with another AfriForum matter, and judgment is yet to be handed down. And so I can't comment, Commissioner. I do hope you understand that.
No, I think that is in order. I wasn't aware of.
Yes. Yes.
No, I fully appreciate it. Thank you, Chief Justice.
Okay. Thank you. Commissioner Mangena.
Thank you, Chief Justice.
Good morning, Commissioner.
Good afternoon. My question arises out of the judgment where you wrote a minority judgment with, or you concurred in the minority judgment with Judge Catherine Sitilwane.
Yes.
Yeah.
That's to do with the record in Rule 53 matters.
Rule 53 matters.
Yes.
Yes, and that's where my question is.
Yes.
I've always been under the impression that the Supreme Court of Appeal is generally reluctant to adjudicate over on appeal matters on a piecemeal basis. And I couldn't understand why would your court be interested in considering an interlocutory order?
Yes, that's an extremely good question. And we considered that question in the panel, and the short answer to it is that, although I don't think it's teased out very much in the judgment, but the short answer is if you order a party to produce a record, that record in proceedings, that record is then produced. It is there. It can never be recalled. And you may have situations where they produce a record that is then in the hands of, the other litigant, and that record, the documents in that record, will then be open to. They'll be a part of a public record, and so in a sense there was some final effect, because you can't then recall that record back, can you? If it's ordered that a party must produce that record as part of the appeal, it sits there, it's there. It's open for the applicant to use those documents as and when it wishes to in the trial. And so, to that extent, it was also understood to be an important question. And you'll see, and it's an important question because there was a dissenting judgment, and it turned. So for those two reasons, it was felt that that the appeal should be heard.
Thank you, Chief Justice.
Thank you. Commissioners, we have got to come to an end with this interview. I'm really not allowing anybody beyond Commissioner Steinberg and Lucas, but if you can, Commissioner Steinberg has indicated it's fine.
I'll withdraw in the
Yes.
interest of time.
Commissioner Lucas, do you insist on your question? I hear you saying no. Silence means no.
My hand that was up instead of.
It's actually Commissioner Singh.
Oh, I was told it was Commissioner Lucas. I'm sorry. Commissioner Singh, do you insist on yours?
A very quick one, Chief Justice, because it
Okay,
deals with criteria.
it's the last one then.
Yes, sir. Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
I'm on virtual. One of the criteria that we have to apply as commissioners is experience when we are
Yes,
appointing some.
yes,
Now, I note that you were only appointed in 2016 as a judge, but you have 39 years of experience in the law field.
yes,
And secondly, I note that in the SCA, you were there from July 23 until April 24,
yes,
which is also a relatively short period compared to others. But then I also note, and this is my final point before asking the question, that you served as presiding judge in appeals as a senior judge of the High Court.
yes.
And the question is, how has that helped you? And do you think that has equipped you sufficiently
Yeah.
to assume a position in the SCA? Thank you.
Thank you. The short answer is yes. I think my judgments speak for themselves. In the Supreme Court of Appeal, I've written judgments on some of the issues I've written judgments on are complex issues, and I feel I've acquitted myself well. And then my years of experience have all equipped me to be a very good SCA judge. My years, I have a good legal brain. I know how to analyze law. I have a mix of practice as well as academia. And that has all equipped me incredibly well. That's why I said I have followed a rather unique path. It's not as if I suddenly became a judge in 2016 and now wish to be elevated to the SCA. So I do feel that my entire gamut of experience equips me very well. And then, of course, sitting in a very busy division like ours, I've been sitting on panels of full court appeals and full bench appeals from when I was an acting judge, working my way up to presiding there. So I'm well versed in how one deals with appeals, the nature of an appeal, the powers of the court when the court deals with appeals, the limits of those powers. So I have absolutely no hesitation in giving a complete assurance that my elevation at this stage is timely. I have the experience, I have the capacity, the capability, and I believe I have demonstrated that.
Thank you very much. I am satisfied,
Thank you,
Chief
Commissioner.
Justice.
Thank you. That was the last question. Thank you very much, Judge Kitley. We have come to the end of the interview. Once again, thank you for availing yourself for consideration for appointment to the SCA, and now you are excused.
Thank you very much, Chief Justice and Commissioners and Minister.
Thank you. Commissioners, I'm going to try and keep everybody within an hour going forward. We really mustn't go beyond an hour. And some of those that are coming, we have interviewed before. Yeah, okay. Good afternoon, Judge Kun.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well, thank you, under the circumstances. Thank you.
Okay, all right. Thank you very much for availing yourself for consideration for appointment to the SCA, and thank you very much for coming to this interview.
Thank you.
We are going to ask you questions aimed at establishing to what extent you satisfy the selection criteria that have been adopted by this body for the selection of candidates for appointment to various courts. Everybody is here wants to simply test your abilities and experience and competence and knowledge of law to see whether this body should advise the president to appoint you. Nobody wants to block you from appointment or anything like that. You may be asked difficult questions, but that's simply because commissioners want to satisfy themselves whether you should be appointed to the SCA. You do understand?
Yes, thank you.
Thank you very much. I will ask you some questions, and after that, I will allow the president of the SCA to put some questions to you. Thereafter, the minister, and commissioners that might have questions for you. We have got a lot of information on you, which you have supplied by way of the questionnaire and other documents. We are all aware of it. Everybody is presumed to have read the bundle, so we won't be asking you questions to cover everything. We'll only focus on certain areas.
Very well, thank you.
But everything will be taken into account in the decisions that are to be made. I see that in terms of academic qualifications, you hold a BCom and an LLB, and you got your LLB cum laude from the University of KwaZulu-Natal, and you have a diploma in arbitration. Is that right?
That is correct, Chief Justice.
Yes, and you, after varsity, you served articles, and you actually got admitted as an attorney, as a notary, and as a conveyancer.
That is correct.
Oh, but then you didn't practice much as all of those things, and you went to the bar, is that right?
I practiced for almost a year.
Yeah.
And then I went to the bar in February of 1988.
Yes. I'm sure there are many attorneys who would have liked to be notaries and conveyancers and use it rather than you taking it to the bar.
Well, I went to the sidebar with the intention of going to the bar.
Oh.
I disclosed that to my principal up front.
Yeah.
And I wanted to get experience at the sidebar.
Yeah.
Because I thought it was appropriate for a career at the bar.
Yes, yes. Okay. And then you practiced at the bar for a number of years, and you took silk in 1997, is that right?
That is correct. I practiced as a junior for 10 years, and then in November of 2007, I attained silk status, senior status, yes.
Yes. And then you got appointed as a judge of the High Court in 2006.
November 2006, that's correct, Chief Justice.
Yes. That means that you have been a judge for about, is it 18 years?
17 years. On
Yes.
the 1st of November this year, it'll be 18 years.
Yeah. So you have had quite extensive experience as a High Court judge.
Yes.
Yes. Would you like to share with the commissioners the breadth of your experience as a High Court judge in terms of branches of law where you have given judgments?
Yes, I have a wide and varied range of experience as a High Court judge. Obviously, apart from the normal activities, chamber activities that a High Court judge is responsible for, petitions, the so-called mentals that need to be certified, chamber work. There's also the court work. across the whole spectrum.
Let me interrupt you, Judge Kuhn. Not the activities, but the branches of law where you have given judgment, like delict, contract, commercial law, maritime law, procedural law, administrative law, patent law, that kind of thing.
Yes, I have across the wide range. Obviously, a lot of it is contractual. There are many intellectual claims that I've dealt with. There are administrative laws issues that have arisen. Insurance law, that is short-term and long-term insurance, including judgments on the interpretation of certain rules of long-term insurance. I have been involved in construction law. One of the judgments I refer to was a very large construction law matter. In years gone by, I dealt with some negotiable instruments when we still had checks, but obviously that's now a thing of the past. From my experience as notary, I think I had one matter once with protesting of a bill. Yes, I've had a wide and varied experience. Having regard also to the province in which I am a judge, we don't have the range of exposure to administrative law, like, for example, the Gauteng courts have, with the seat of government being here, or then the Cape Court, Western Cape Court, with Parliament being situated there. But we do have many administrative law issues too, arising from disputes at municipal level. The KwaZulu-Natal province, as you will know, is quite a vibrant province. There are lots of competing interests. So we have regular disputes involving local authorities, control of local authorities, that kind of thing arising. And then just general disputes between man and man, neighbor law issues, or nuisance as they are called in some quarters. Yes, I think that's probably, trying to recall them from the top of my head, the main branches of law that have been involved.
Yes, and you have acted in the Supreme Court of Appeal as well?
I've acted in the Supreme Court of Appeal. I'm there at the moment. The current is my 7th time that I've acted there. Some of them have been for shorter periods. The one in particular was for a single appeal, which you would have noted from my questionnaire, and that was the matter of the Potato Board versus PwC, probably still the longest appeal, I think, in the SCA. It comprised more than 84,000 pages. So my one appointment, which ran from...
Yes, no, that's fine. Tell me, your acting stints in the SCA, have they given you exposure to other branches of law that you might not have had been exposed to in the High Court?
Yes, they have.
Which ones are those?
Well,
branches of law?
Well, when I say branches of law, I didn't write the judgment, but I've been exposed to trademark at the end of last year. It's a reported judgment written by a colleague of mine, Takis Biltong, is the one party. Yes, certainly that's a branch of law that I hadn't dealt with previously. On intellectual property, I think I've only had exposure in KwaZulu-Natal once to a counterfeiting case. They don't come across our bench quite that often. But it's been interesting, and it's been challenging to get involved in other matters too.
Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, my understanding from the doctrine of separation of powers is the clear division in a state between legislature, executive, and judiciary, and that they they operate in separate fields for a very defined purpose. Obviously, the legislature being there to create laws, to enact laws, the executive to give effect to administration, and then the judiciary having the task of adjudication. Now, in any constitutional democracy such as ours, there's obviously the question of review powers and testing both legislative acts and also executive acts from time to time on the basis of either legality or fairness, if it should qualify as a particular conduct should qualify as an administrative action as opposed to executive action. So to that extent, there is a crossover the line, but there must always be the responsible attitude of that there are separate fields of activity, and that one has to show deference to the other fields of activity or the other branches of the state, but at the same time not being, in the case of the judiciary, reduced to a situation of timidity, where if there's a wrongful act or an act which is illegal in the sense of offending against the principle of legality, that it be struck down as constitutional or then otherwise not be in accordance with law. It is, yes, I think it's that probably concludes my answer, yes.
Yes, and the rule of law?
The rule of law is the basis of our Constitution. It's stated in Section 1 of the Constitution. It underlies, and it's part and parcel, inextricably bound up with the principle of legality. It means rule by law, that is, that for every action there must be a legislative, a juridical base, a constitutional base underlying and supporting that particular act. But it's more than just a legality debate. It involves ancillary aspects to it, such as whether it implicates in a particular situation necessarily the duty to give reasons, or then to afford an opportunity to another party or be adversely affected to be heard. And I think it's been expanded over the years, and legitimately so, in an incremental fashion, to give effect to what I think the founders of the Constitution contemplated.
President of the SCA.
Thank you very much, Chief Justice. Good afternoon, Justice Kuhn.
Good afternoon, Judge Molemela.
Yes, just following up on the Chief Justice's question about the spectrum of work you have been exposed to in terms of branches of law, have you done shipping matters?
I've done shipping matters, not many. When in KZN we move between Pietermaritzburg and Durban, as you might know, as judges. And whenever I'm in Durban, the Durban court sits as an Admiralty court, and I've given judgments in matters. Mostly those applications pertain to the arrest of ships. That's what we find most. But there is one judgment, admittedly some time back, which I gave. I cannot recall the name now offhand, but it dealt with a shipping issue, yes.
Yes, thank you. You will recall, Justice Kuhn, that I once invited you to come and participate in an appeal at very short notice in unfortunate circumstances where a colleague had taken ill and the matter had a very long history and could not be postponed, and the panel could not be collapsed to a panel of 3 because of the complexity of the issues raised in the matter. And so the matter had to proceed, and I contacted you after discussing the matter with the presider in the matter. And in my discussion with you, I warned you or forewarned you that if you agree, the presider had asked me to inform whoever has to come on board that they would have to sacrifice all their private time, no weekends, no private evenings, because the appeal was going to be heard within a short space of time. And you agreed to participate in the matter notwithstanding. Do you remember that matter?
Yes, I do. It's indeed the matter of SAPC. as you say, it was unfortunate that a colleague of ours had to withdraw at very short notice. It was set down now for in recently, and I think I had just over 2 weeks, almost 3 weeks, by the time the papers got to me to read the papers. I indicated in the questionnaire that that was the one matter in which I sat, although I was not the scribe, where the judgment was outstanding. And I just wanted to bring it to the attention of the commissioners that the scribe was in fact Ponan J.A., and the judgment in that matter is no longer outstanding. It was handed down on the 20th of March.
Yes, thank you very much. But going back to this matter, because I had called you at such short notice, subsequent to the hearing of the matter, I did have a discussion with you to ask you how you found the experience of participating in a complex appeal where the record is voluminous at very short notice. And I did say to you, I'm asking this question because I don't want to, in the future, be unfair to other colleagues if this has put you on the back foot. And you indicated that you coped, and in fact, your words were that if you were asked again, you would do it again.
Yes, no, I certainly would. It was not a problem. It was, as you say, there were no weekends, and it was full days reading with notes being made. But it was an interesting matter. It involved German law, and that made it so much the easier, I suppose, in a sense. But yes, I had no difficulty in dealing with it.
Yes. Thank you very much. So I note that you have been a permanent judge for 18 years. And prior to that, you were a practicing advocate, save for the time when you were an attorney. And my calculation of your total years of experience is 41 years in the legal profession. Is that correct? More or less?
Yes, that's more or less correct.
Yes. So you are aware, Justice Kuhn, that the SCA has lost a lot of expertise, a lot of experience because of the retirement of very senior experienced judges and those who were elevated to the Constitutional Court. So would it be fair to say that at the moment the retired judges have to be replaced by very senior colleagues who are also very experienced?
Yes, I would go along with that. I think at the level of what comes before the Supreme Court of Appeal, it is vitally important to have experience, to be analytical, and to identify the crux of the case or the issues very pertinently and very accurately. And that is something which mainly, in my respectful experience, comes with experience.
Yes. So,
So there's no substitute.
Sorry.
I think the American lawyer Oliver Wendell Holmes once said that the path of the law has been, in a different context, but the path of the law has been experience, not logic. And there's a lot of truth to that.
Yes. So are you confident that you have special attributes that would stand you in good stead if you were to be appointed?
Yes, I certainly would like to think so. That is the feedback that I've also had from the General Counsel of the Bar and the LSSA.
Yes, and my last question is this. You know that we work strictly in panels, which means that collegiality is very, very important. You'd also agree that judgment writing is a collaborative process or collaborative effort at the Supreme Court of Appeal, where not only do you have to give inputs on other colleagues' judgments, but you also get inputs that you must seriously consider incorporating. You agree?
Yes, indeed.
Yes.
It's the collaborative effort or experience which I think produces the better judgment.
Yes. Have you had any occasion where you delayed the delivery of the judgment, either because you did not give inputs at all, or you gave late inputs, or you delayed in writing a separate concurrence or a dissenting judgment?
No, I've never had that experience. I don't think I've ever had a judgment which I had to contribute to in the form of writing and ascribing it which took more than, say, 3 to 4 weeks. I have one judgment at the moment that I have to scribe, which I haven't completed.
Yes.
The matter was heard this last Tuesday, so it is now 6 days ago. I'm approximately 8 hours from finalizing it, and it will be circulated.
Yes. Now, in terms of your own judgments, would you say you are self-reliant, or have you also had to get assistance from other colleagues in terms of the substance of the judgment?
No, my judgments to date have certainly all been self-reliant. I work completely independently. I do my own research. I do my own typing, own formatting, and preparation of the judgment. It's only when I reach the point where I've finalized it, with reference to the one that's outstanding at the moment, hopefully by tomorrow or so, that I would send it to the researchers just to check that I've got the quotations verbatim correct from the original text and that the case references are correct. But I don't take any, I don't request any input on the substance of the judgment itself. I work independently on that.
Thank you, Justice Kuhn. Thank you, Chief Justice.
Thank you. Minister?
Yeah, thank you, CJ. No question.
Thank you, Commissioner Steinberg.
Afternoon.
Good afternoon, ma'am.
Judge Kuhn. I was rather disturbed when you recused yourself from the criminal trial of former President Zuma, where, as I understand, the circumstances were that neither party had called for your recusal, but you put it on the agenda yourself and then recused yourself. I was concerned because our constitutional court has long said that there's a duty of the judge to sit. Hearing interlocutories or previous rounds in the same case necessarily means that the judge has exercised his discretion on the same case. It's a case of huge national importance, and where the judiciary itself has become the object of criticism due to the fact that it's been going on for 19 years. And by you recusing yourself, initiating that recusal, it of course set back the timelines quite significantly again. So I want to hear your justification for taking that unusual step. Thank you.
Thank you. May I deal with it at a few levels, please? It is correct that I raised the question of my continued participation in the trial, and it was, when it was raised, it was also adopted by certainly Mr. Zuma's team as an issue which they wanted to raise. So the question arose squarely. The judgment that I gave, I think, judges are reluctant to go beyond what's in their judgments. I think it speaks for itself. But if I may just recap very, very briefly, please, so you can understand my reasoning. The process had begun on the basis that there was a challenge to the title of the prosecutor to prosecute. That is in terms of Section 106, 1H of the Criminal Procedure Act. I was faced with an authority from the SCA, but also certain other authorities on what that meant. The case that was presented was, however, at a multitude of levels. When I say the case, that's the case by Mr. Zuma, or President Zuma. It was an attack on the basis of a narrow interpretation of Section 106, and whether a narrow interpretation was the correct interpretation or whether a wider interpretation should be adopted. Not only was it said that the prosecutor lacked the impartiality and the objectivity and therefore would prosecute at all costs, so to speak, But there were also a variety of other grounds that were raised, which it was said Mr. Downer had been involved in, which would disqualify him. So if you read my judgment on that, I dealt with the question of the title to prosecute and then these other grounds. Those other grounds included, for example, the whole CIA involvement, the Luciano secret agent, the spy tapes case and the involvement of the National Prosecuting Authority in that. It also raised, amongst others, towards the end of that argument, after the matter had been adjourned on one occasion, the issue of Mr. Zuma's medical records having been disclosed following an email having been sent from the correctional facility in Escort to the NPA, and the NPA then preparing, National Prosecuting Authority that is, preparing an affidavit, and that affidavit apparently or allegedly being leaked to Ms. Karen Morn before it was formally filed at court. That stage the proceedings are still before me. I came to the conclusion that I said there was nothing wrong, that the correct interpretation to be adopted was a narrow one, and that there was nothing wrong with the title of Mr. Downer to prosecute. But then following Spillhouse in the Constitutional Court, where one cannot just say, well, that's dispositive of the matter before me, I'm not going to deal with the rest. I then, at that stage, as I thought I was enjoined to do, and I think I am, dealt with these other grounds as well. And I said that those grounds were insufficient, and I didn't consider them to have any merit. Now, the reason why I'm telling you this long story is just to the build-up to understand the position. At that point, what was before me, and that I said didn't have any substance, was the alleged contravention of, I think it was Section 24 of the National Prosecuting Authority Act. And that essentially provided that it's a criminal offense for somebody in the National Prosecuting Authority to disseminate or to make available information that the National Prosecuting Authority has. So having said that, I found, on my view, there was no substance to that. What happened thereafter was that, in fact, a criminal charge was laid. The criminal charge did go to the Director of Public Prosecutions. There was a certificate of nolle prosequi. And I think by the time it came before, the hearing came before me again, one of the issues was that Mr. Zuma was now saying that Mr. Downer couldn't remain as a prosecutor, not because of any defect attaching to his title, but he was now also the accused in a matter in which the complainant was Mr. Zuma, and vice versa, and that created an intolerable situation. That was a novel situation. I'm not aware of any precedent on that, certainly in this country. And that was what was going to be argued before me, that there should be a further postponement, or alternatively then that Mr. Downer should be removed, because he was now not only accuser, but also accused in another matter. That issue centrally involved a finding on whether the private prosecution was well-founded. But I'd already previously found that the alleged contravention of Section 24 of the National Prosecuting Authority Act was without substance. I couldn't sit there deciding that issue as to whether Mr. Downer should remain as a prosecutor, where a criminal private prosecution was now on the cards, where I'd previously found that there was no substance to that criminal complaint. It is more important, with respect, that the judicial process be beyond reproach than finding oneself in a position of inevitable conflict as that would have produced. And I respectfully disagree with you on saying that the timelines were pushed out. It was raised at a point where the matter was, due to circumstances, going to be postponed in any event, because appeal processes were still being pursued in respect of my initial judgment to the Supreme Court of Appeal. From the Supreme Court of Appeal, when the petition was refused, it went for reconsideration, then it went to the Constitutional Court. Those processes were still ongoing, and the trial couldn't proceed. So no time was lost as a result of that. The matter was argued, and I gave my judgment, I can't recall the exact dates, but expeditiously within a very short period of time. So I regrettably have to take issue with you when you say it was pushed out on the timelines. It wasn't. Since then, things have developed, but yes, I'll leave it at that because those are issues before court.
Could I just follow up on this, on this issue, Justice Kuhn, if you don't mind?
Yes.
I read your judgment. There's only one reason why you recused yourself. It's because you had made a determination on the medical condition under Section 46, subsection 6 of the National Prosecuting Authority Act. That was the sole basis. Now, what seems to me to have been happening is that the same issue that you had decided was being relitigated. And ordinarily, that would not be a basis for the recusal because you would simply affirm the correctness of your finding. And even if it is correct what you're saying to Commissioner Steinberg, which is there was no specific pushing back of the time, there is still a problem. The Constitution says criminal trials must be finalized without delay. So the consequences, even if not intended, is that a trial that has already been delayed by 19 years is again going to be delayed because a new judge must be appointed and they must familiarize themselves with the matter and then they must read the record again. And yet you have been seized with the matter for 2 years, as I understand. So it's also a matter that I think it really does require reflection because the Constitutional Court in Sarfo said there's a duty to sit. In S. Vasson, it said sometimes you will make adverse rulings to an accused in the course of the trial, but that is not a basis to recuse yourself. So what you have done in this case, you've made an adverse ruling. The matter is then relitigated in a different guise. And then you recuse yourself on that basis. But that's precisely what S. Vasson said should not happen.
With respect, sir, I differ on that. The judgment is not just on the medical condition of Mr. Zuma having been leaked. It was on that. It wasn't the medical condition that was the issue. The issue was that it was information that was in the possession of the NPA, which they say shouldn't have been released. And on that, I had found that.
I apologize, Justice Kuhn. If you can look at paragraph 80 of your judgment, because you say you are not satisfied with any other of the grounds, but you are satisfied with one ground, which is this leakage under Section 46.6.
Yes. Yes, sorry, I don't have the judgment in front of me, but that's my recollection. But you say it's the confirmdness of the correctness of my finding. The fact is, though, that from Mr. Zuma's perspective, this issue was going to have to be tried again. It's going to require a fresh determination. And I thought that it was appropriate that it should be done not by me, where I had expressed a very firm view previously on that issue.
Thank you, Chief.
Thank you very much.
Sorry, Commissioner Steinberg, I
No.
hijacked your question.
Yes, thank you.
Sorry, I hope that answers the question as best I can. I haven't read the judgment recently.
Thank you.
I can only say that I really am a little baffled by your answer, in that I think you, by seeing yourself as conflicted or having spoken on the issue, it might be seen to actually encourage litigants to relitigate the same issue on a different basis again and again. Rather than, you did your job, you did it properly, and you could have done it again. Why there could be a reasonable perception of bias remains confusing to me.
Yes. Well, I've given my reasons. I've given the reference in the judgment and my interpretation of it. I can tell you that recently the judgment that I was asked about, the SAPSI judgment, led to a situation where the appeal succeeded on the basis that the judge, it was also a long trial, as you would have gathered from the record, should have recused himself. at a point which was about halfway through the trial. That entire trial has gone to waste. When there's a possibility of a trial of great magnitude proceeding where the suitability of the judge, whether he should or she should recuse themselves, had arisen, and it was dealt with incorrectly, as in the SAPSI matter too, and the trial runs for 70 days or 75 days, or whatever it may be, and then the whole process has to start de novo, because at the end of the trial, it is found that I should have recused myself, then I think the good administration of justice rather requires that we leave the judicial process beyond reproach, and that if there are reservations as to recusal, that one should then rather treat it as a proper case for recusal.
Thank you, Chief Justice.
Thank you. Judge Kun, I'm not going to be specific to the circumstances under which you recused yourself, but I want to say something about that last statement you have just made. With regard to recusals, isn't the position that we've got to strike a balance? A judge shouldn't just recuse himself just because there are some reservations. He or she is not sure, but she would say, I would rather recuse myself. And a judge shouldn't insist on sitting in a matter where they should recuse themselves. The proper balance is somewhere in between. Because on the one hand, you might say you are accusing yourself because there are reservations. You don't want a situation where after 7 days of trial, it's found that you should have recused yourself. You are trying to avoid that situation. But on the other hand, if we have judges who are too quick to recuse themselves, there may be litigants who would make use of that, take advantage of that. And then you could end up with the same situation where the administration of justice is brought into disrepute because judges are just too quick to recuse themselves. So I'm just saying, probably it might not be correct to say if you have reservations, you must recuse yourself.
No.
It should be more than that.
No, certainly.
You strike a balance somewhere. Is that right?
Yes, certainly. No, I endorse fully what you say. It is not, a recusal is not there for the asking. And I can assure you that I agonized over this issue for quite some time before I came to the conclusion which I did. Ultimately, it's a question also, I suppose, of conscience in a way. You know, I've placed myself in the position of that particular accused. If the judge had previously said that my complaint about Section 24, whatever the section is in the NPA Act, is devoid of merit, it's a lot of nonsense. And I now, in changed circumstances, and I don't necessarily agree that that's relitigating the same point, because now there is a prosecution, now there is a situation of accuser and accused. And he says, well, I don't want that same judge to decide it. Is that a reasonable apprehension of bias if you before a judge who has previously expressed that view? And that was my concern. And I agonized a bit both ways. It was not an easy decision.
Thank you. Commissioner Marumwafai.
Thank you very much, CJ. Good afternoon, Judge Kun.
Good afternoon, Prof.
Judge Kun, can I take you back to 2010? One of the judgments that you wrote, Shoprite Checkers versus Everfresh, it went all the way to the Constitutional Court, and it was a lease contract matter. You remember it. It's part of your papers. I just want to ask you, because in paragraph 23 of the judgment, you say, if the right carried the corollary of negotiating, then our law would require that it be in good faith. And I don't want to talk about the judgment per se. I just want to talk about the concept of good faith in contracts. And there's fight, I like to call it that, between the former judges of the Supreme Court of Appeal and some of the former judges of the Constitutional Court on the status of contract and how it can be influenced by concepts such as good faith, fairness, Ubuntu, and all those concepts. The way you viewed good faith in this case, I just want to understand whether your view has changed over the years, or what role, if any, does good faith as a concept play in, or when parties are contracting, in any type of contract, be it a lease or say whatever contract it is?
Yes. It's a difficult question in the sense that since ever fresh, our jurisprudence has gone quite a long way. At the time when Everfresh was argued before me, it was peripherally on the level of, well, you must negotiate in good faith, that all contracts in South Africa are contracts of good faith. Initially at that stage, we even had insurance contracts, which was considered to be contracts in the utmost good faith, uberima fides. That has since changed, and the courts have said it's all contracts are just contracts of good faith. So at that level, yes. But the debate that I think you're referring to, if I may be so bold as to suggest that, is the different approaches to whether contracts should be enforced, whether on the basis of Ubuntu, whether on the basis of it being contra bonos mores, or whatever, that has been adopted at the Supreme Court of Appeal level and the Constitutional Court level. And you'll be aware, and I think that's possibly what you're also referring to, that there have been articles written by Judge Lewis, also by Judge Brandt, also by Judge Wallace,
yes, and Harams as well,
and adopting a narrower approach, a more formalistic, if you like, approach. These different approaches are actually very nicely summarized in a case note that was written by, I think it was Boonzaier, in the 2020 volume 1 edition of the South African Law Journal, specifically with reference to the judgment of the Constitutional Court in Botha versus Risch in O. And I think well, he makes the point there that it's not so much a case that the provision or the contract is contra bonos mores and is sought to be enforced, but that it's sought to be enforced in a manner which is not conducive, not consistent with good faith. You recall the facts in Botha versus Risch in O was about a certain percentage, I think it was 75% of the purchase price on an immovable property being purchased, having been paid on a property to be purchased. And then the Miss Botha, who was the purchaser, defaulted in making payments. And the breach clause was invoked, and when she didn't remedy her default, the contract was then cancelled. And the issue then arose, well, she'd paid 75% of the purchase price. She would have obtained a right in terms of the Alienation of Land Act to demand transfer against the balance of the purchase price being paid or being secured. But now, effectively, by invoking the default clause, the other party would be entitled to nullify that statutory right to demand transfer against payment of the balance of the purchase price. So the issue, and that's what's being motivated for in that article, is that one must have regard to the different competing rights. And if it's a contractual right that is going to undo, nullify a statutory right i.e. the right to demand transfer of the property against payment of the balance of the purchase price, then that would be an unfair way. It's not a question of fairness and bona fides. It will be an unfair way to defeat her rights. And therefore, the unfairness arises from the manner in which the contract is sought to be enforced, rather than the contract itself being contra bonus mores. And it's in that context. It was in the period also of the Pridmore case, Bidika. I think Bidika at that stage was still making its way up to the Constitutional Court. It had come from Davis in the Western Cape Court. But I suppose the short answer is, I think there's scope for bona fides in the law of contract, but it has specific application, possibly more in the context of enforcement. But the last word, I don't think, has necessarily been spoken on this.
Thank you very much, Judge Kuhn. Thank you, CJ.
Thank you. That was the last question. There were no further hands. And also on the virtual. Thank you very much, Judge Kuhn.
Thank you.
We have come to the end of the interview.
Thank you, Chief Justice.
Thank you for availing yourself once again. You are now excused.
Thank you, and thank you for patiently bearing with me. Thank you.
Thank you. Secretariat, you may call the candidate. Good afternoon, Judge Masipa.
Afternoon, Chief Justice.
How are you this afternoon?
Uh, hopefully fine. I'm having a jaw problem. So
Oh.
as I talk and you see me going quiet, maybe it would have hooked or jammed, and then I may not be able to continue talking. But I hope that it doesn't happen.
Or do you feel some pain when you talk?
Yeah, it actually locks, so I can't open it.
Oh.
Yeah.
Oh, I'm sorry about that. I'm sorry. Well, if it does happen, we'll definitely understand. Thank you very much for availing yourself for once again
Yes.
for consideration for appointment to the SCA. And thank you for coming to this interview as well. I previously disclosed how you and I know each other, so the commissioners know that you were my researcher, law clerk many, many years ago at the Labour Appeal Court. But thank you for coming. The rules that I explained last time about how we go about putting questions to you, interviewing you, are still the same that will apply in this interview. We will be seeking to satisfy ourselves how you meet the selection criteria that we have adopted for the selection of candidates for appointment as judges at different levels. I will ask you some questions, and then I will allow the president of the SCA to ask you questions. Of course, we interviewed you not so long ago, so we are familiar with you. We also have a lot of information that you have supplied to us through the questionnaire and other documents. Therefore, we are not going to try and cover all of that in the questions we'll put to you. Everybody is taken to have read the bundle and to be aware of the information. So we will only focus on those areas where we would like to have answers from you. In terms of your academic qualifications, you hold 3 degrees, BProc, LLB, and LLM from the University of Limpopo and then the University of KwaZulu-Natal, is that right?
Yes, that's correct.
And you got admitted as an attorney in 2004, is that right?
2002.
2002.
Yes.
And after practicing for a certain number of years, you were appointed as a judge of the High Court in KZN. Is that right?
Yes, that's correct, in 2016.
2016, yes. That means you have been a judge for about, what, 8 years, 9 years?
8 years, going to 9 years from next month.
Next month it will be 9.
Yes.
Okay, all right. Now, can you share with the commissioners the breadth of your experience as a judge of the High Court by telling them in what branches of law you have written judgments?
I have, in my previous interview, I dealt with a case that involved the interpretation, the declaration of invalidity of a policy which related to the policy of a private school relating to the payment of fees, which I had to consider whether the application of that policy was in conflict with Section 28 and 29 of the Constitution dealing with the right to education and the best interest of a child. I, having considered the relevant issues, found that the policy was indeed in conflict with the
Okay, I'm sorry, let me interrupt you. I don't need you at this stage to discuss any case. I just want you to reflect on the judgments you have given over the years and be able to say, I've written a judgment in maritime law, I've written a judgment in cultural law, I've written a judgment in patent law, I've written a judgment in trademark law and different branches. So I just want to have an idea of the breadth of your experience.
I understand. So I've written judgments in customary law, in administrative law, in the law of contract, in mostly procedural law, in the law of delict. I have had to deal with some maritime law matters, but then I'm not going to say I've written a judgment in shipping law because they came to me as, on procedural issues as well. I've written judgments in outside the High Court, but in the Labour Court, in employment law. And those obviously involving the Constitution or constitutional law. Yeah, I think that's the sum total of what I can recall.
And then you have acted in the Supreme Court of Appeal. Did that opportunity expose you to other branches of law to which you have not been exposed at high courts?
Well, outside what I've stated, no.
Oh, okay, all right. And you have also been an acting deputy judge president of the KZN division of the High Court, is that right?
Yes, that's correct.
Yes. How did you find that experience to be?
It was quite an interesting experience, having to gain some experience and apply, I guess, some of the previous experience that I gained, managerial work, challenging as well. There were instances where some colleagues were not really cooperative, and some of the things that I asked was mainly senior colleagues, but then even the junior ones would actually, behind me, be making statements that they refuse to do some of the work, and it was shocking for me because it was statements that were coming from judges and not the administrative staff. But I managed them quite well and ensured that the work that needed to be done was done.
Yes. Okay, all right. Can you share with the Commission your understanding of the doctrine of separation of powers?
The doctrine of separation of powers is an important or fundamental principle that in a democratic society, because it ensures that powers are evenly divided within different government spheres. What we have in South Africa is we have Parliament, which obviously makes laws, or legislature, and we have the executive, which applies those laws, and the judiciary, which ensures that those laws are applied properly. Judiciary has to remain independent in doing their work in reviewing both the functions of the legislature and the executive. To ensure that the rights in the Constitution are protected, and that laws of the country that have been passed are properly applied by the executive.
When you say the judiciary makes sure that the laws are applied or applied properly, that sounds to me like implemented.
Yes.
Is that what you are saying?
No, the implementation is done by the executive.
Yes.
And then the judiciary basically oversees that both the executive and legislature are applying those laws properly.
Mm.
They would do that by when cases come to court, reviewing those legislations that's been passed, and the application that would have been the implementation by the executive.
And would you like to share with the commissioners your understanding of the rule of law?
The rule of law says that, or basically sets out that the law, no one is above the law, and that everyone must conform with the law that has been passed, and that the rights that are there are protected, and also that the judiciary remains independent. So the laws that have been passed must be clear. They must be accessible to the public, and they must be passed in a transparent manner.
President of the SA.
Thank you, Chief Justice. Good afternoon, Justice Masip.
Afternoon, President.
Yes, you have previously been interviewed by this body. So my question to you is, what according to you is, let me put it like this, are there any important developments that have taken place since your last interview? You mentioned to the Chief Justice that you were appointed as a DJP, acting DJP. Besides that?
Beyond the scope of the judiciary.
No, within the judiciary.
Yes.
Or I can
No,
also put it differently
I-
and lead you by saying, since then you have
Yes,
had an
no.
opportunity to act again at the Supreme Court of Appeal. Is that
I
correct?
understand.
Yes.
I had indicated at my last interview that I was actually starting my fourth acting stint, which started in October, but then the court obviously sits in November. And it was, to me, very informative. Although I had been allocated 2 judgments to write, I could only write one, but then the involvement that I had in that judgment and in other colleagues' judgment, I was quite happy with. I felt I was afforded an opportunity to do the work that I was there to do. Not that I was not afforded that opportunity, but in the previous acting, the judgments that were allocated to me were allocated as a second scribe. In this instance, I had to be, the sole scribe and write a judgment. I indicated that I had been allocated 2 judgments and I only wrote one. And the reason was that the first matter, having received the record and having read the papers, formed a very strong view that there was an issue of conflict arising in that matter. And I communicated with the deputy president, and I think at some point I also engaged with you and indicated the issue relating to that conflict. We agreed that I recuse myself from the matter, and the matter was then replaced with another matter, but however, I was no longer a scribe in that matter.
So far, how many judgments have you written at the Supreme Court of Appeal?
Can I ask for clarity? You mean me?
Where you were the scribe.
Where I was the sole scribe.
Yes, where you had an opportunity to write a judgment. It doesn't matter whether you were a co-scribe or a sole scribe. As a scribe.
I believe it's 9.
Nine. Okay. All right. So you would have realized, which is something that has been lamented quite a lot at our court, that during your last acting stint, we had fewer law researchers to rely on. You recall this?
Yes.
Yes. So you'd agree that candidates who really must be appointed at the Supreme Court of Appeal, all things considered, are colleagues who are able to be self-reliant in terms of doing their own legal research in preparation for the hearing and also in preparation of the judgment.
Yes, I definitely agree.
Yes. So did you have to receive a lot of assistance from other colleagues in relation to, I'm not talking about style issues, I'm talking about issues of substance in relation to your judgment? Have other colleagues had to make a contribution in matters relating to substance in your judgments?
In respect of all the 9 judgments, you're referring to that, right?
Yes, all the judgments that you have authored.
So the first judgment that I wrote when I first came to the court, it's an RAF matter. I would say that I did. It was not necessarily the substance. What the colleague said to me was, you've given too much information, there's nothing wrong with the information that you've given, but it's a little bit too much. And then assisted me with, you could probably remove this and that and that, and still, deliver the message of, a good judgment that you want to do that you'd want to deliver. But then, in time, I believe in terms of substance, no. Yes, there will obviously be comments to judgments, as you know, but the substance of the judgment, no. It's all the work that I would have put in.
Yes. So in terms of measuring whether a colleague is able to fit in properly at the Supreme Court of Appeal, I think you'd agree that one could use the production of judgment as an assessment too. You agree?
Yes, I do agree.
Yes. How soon do you produce your judgments? Have all your judgments been produced promptly?
I'm not sure what promptly would mean. The first judgment that I mentioned, the RAF matter, was handed down during the second term.
Yes, let me put it like this. We have norms and standards. I know that historically at the Supreme Court of Appeal, the expectation has been for a judgment to be issued within the same term. But we do have norms and standards. So my question is whether you have been able to produce judgments within the time stipulated in the norms and standards. Have you had late judgments? If you have had judgments that were delivered late, what were the reasons?
I actually did not work out the date in terms of that RAF matter, so it may, and I indicated at my previous interview that the reason was that there was a delay in the responses that I received from colleagues. The matter was heard in, I think, around the 15th of August. And the first draft that I had, that I circulated, was on, I think, the 21st of September. But then, because of the delays, I indicated then, and it's still obviously the position, that I received a response from one judge like a week after the 21st of September, but then the other responses took time to come to me. And I think if you will recall, in last year in December, because of what happened obviously at my previous interview, last year in December, I approached you and indicated to you that I was having a similar problem. I had, from what JP Mlambo had said, and Petse, whether I had discussed the previous issue with the presider. I had discussed the issue with the presider, and it seemed to me that she was also having a problem getting to the colleagues, and I indicated to her that I was going to be approaching you to raise the issue with you. You indicated that we should perhaps allow the presider to handle the matter and let's see how it goes. And it did assist. I was able to have the judgment handed down, I think, in the space of 2 months.
Yes, but any other judgments, have all your judgments, maybe, let me put it differently, have all your judgments been produced promptly in terms of you circulating it? Maybe let's not talk about the ones where you had to wait for other colleagues to.
Yes, they have.
All of them?
Yes.
Within how long? What period of time?
You mean if I'm not counting that one that I mentioned?
From the date of the hearing, yes. When were the judgments circulated to your colleagues, to the panel?
So mostly within a space of 2 months.
Well, maybe I ask this question. Have you had any occasion where you were the cause of a delayed judgment, either in terms of circulating it late or um, not circulating a revised draft timeously, or a delay in giving input to other colleagues' judgments?
No, definitely not. When I came to the court, I learned from Justice Govan the importance of ensuring that judgments are handed down timelessly and circulated properly. I learned that when colleagues circulate their own judgments, you have to respond as quickly as you possibly can. So whenever it is that I receive a judgment, I stop everything that I do and I attend to those judgments that have been circulated to me and comment. So if I receive a judgment, I think the worst that I would have done was about 3 to 4 days. I indicated, I think it was Justice Spetse, that I had returned back to the High Court and there was some urgent matter that I was dealing with, and I indicated to him when as well I would give time to attend to the matter, but then I think about 4 days was the worst, longest period that I would have taken to get back on a colleague's matter. But otherwise, when I receive a judgment, I attend to it on the same day and I return it.
Yes, I'm looking at one of the judgments that you submitted with your questionnaire, the matter of Lowe versus Patel. I note that the matter was heard on the 23rd of August and the judgment was only handed down on the 9th of March 2023.
Yes.
Do you have any explanation for the delay in the handing down of the judgment?
There was a delay in me receiving responses from colleagues. I did not actually work out the dates on the computer, but then I circulated the judgment whilst I was still at court, which would have meant at sometime in I don't know, I think in November, if memory serves me well. Numerous undertakings were made that I would get comments, and I had not received them, and I kept on following up and following up and following up. I kept on receiving, I received comments immediately from Justice Govan, as I indicated, that he always responds on time. And I considered his comments. I circulated that, and he was a person that came back to me after I circulated and had further comments. But then it took time.
I know that the judgment was a split decision. It was a 3-2. So would you say the fact that there was also a dissenting judgment that had to be authored, did it also contribute to the delay?
Yes, it did contribute to the delay.
Yes. In terms of you have been a judge, a permanent judge for 8 years now. You said it will be 9 years next year. And you'll agree that given the loss of experience and expertise that the court has suffered due to the retirement of many colleagues and the elevation of others, the court requires expertise and experience desperately. You'd agree?
Yes, I agree.
Yes. So what attributes or special attributes would you bring to the Supreme Court of Appeal to complement the remaining expertise at the court?
I believe that I have the necessary experience and expertise to prepare and write necessary judgments. I work well, as I indicated, with colleagues, and I'm able to assist a lot in the judgments. And I am able to work independently. Even without the assistance of researchers, I guess in my previous work experiences, I did a lot of research such that I do not necessarily need to be relying on researchers to be doing my work. So I believe that with the experience that I have, both from being a judge and from being in practice, I have the necessary skills and expertise to deliver the necessary services that are required at the Supreme Court of Appeals.
Thank you. And what are your views regarding collegiality at an appellate court level?
My experience.
No. Your views.
The judges.
Is it important? And if so, why is it important?
Well, yes, it definitely is important. And the reason is that unlike the High Court, obviously, judges have to work together in writing those judgments. There's 5 judges that sit in a matter. You have to, be able or capable to work with each other and assist each other in dealing with matters to ensure that good judgments are delivered.
Thank you, Justice Masipa. Thank you, Chief Justice.
Thank you. Minister?
I've got no question, Chief Justice.
Thank you. I don't see any indications. Also from the virtual, I'm not aware. Commissioner Marmohai?
Thank you very much, CJ. Good afternoon, Judge.
Afternoon, Commissioner.
I see that in your questionnaire, you had an occasion to deal with a medical negligence matter in the Supreme Court of Appeal. And it was a split decision where Justice Basson and Justice Dambuza dissented on the view. So I just want to ask you a question on delict, and I don't want it to be an unfair question. And what I'm asking you, perhaps it might have been something that it could have also been considered in that, but it's something that has been bothering me. I just want to understand. There is a view that factors such as foreseeability and preventability of harm are relevant to the determination of both wrongfulness and negligence. And sometimes you find that there is this overlap between negligence and wrongfulness. To what extent does South African delict law, if there is such a thing, conflate those two concepts? Because a first-year student or second-year student who's doing delict, they know the elements of delict are distinct, causation, wrongfulness, all those things are set out clearly. But in practice, in cases such as medical negligence and all those, we see that some of the factors that needs to be considered in both wrongfulness and negligence seems to be conflating to some extent, and there's some overlap. Firstly, do you believe that there is? If there is, how can the courts deal with the overlap?
I've actually never given it a thought, right?
No, it's fine. You don't have to take it further than that. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Matolo Zepu?
Thank you, Justice Masipa. One of the comments that we received from the Law Society of South Africa is that you still need more time, according to them, that they're not supporting you in the sense that they feel you need more time and you can do with more acting things at the SCA. What do you say to that?
Well, no, I think that's a previous comment, not a comment that they made now. I'm looking at that, and my understanding of what they were saying was that there are other judges who have been in the judiciary for much longer than I have, and that was the reason why they were not. Yes, it says from other candidates who are applying for this vacancy, there are several applicants who are more experienced than her and will enhance the jurisprudence of the SCA. That was my understanding of their reason why they were not supporting me.
In your view, have you gained enough experience since then up to now? And how so?
Yes, I believe I have. Well, although I have written one judgment, I've been involved in a whole lot of other matters, both in the Supreme Court of Appeals and outside the Supreme Court of Appeals, which were full court matters that have allowed me to gain the necessary experience that would be of value to the Supreme Court of Appeals.
Chief Justice, may I follow up, please?
Okay, thank you.
Thank you. Good afternoon, Judge Masipa.
Afternoon.
The comment raised by the LSSA is that you are not sufficiently exposed to complex commercial litigation.
Yes.
Let's leave aside whether or not that comment was made.
Okay.
Maybe I can get you to respond to the merits of the comment.
Well, I think arising from them, and it would have probably been the issue of the fact that I was coming from a labor law background before I became a judge. But as I indicated, I've been sitting as a judge of the High Court for more than 8 years now. And I have not been dealing with labor matters. I've been dealing with a lot of commercial law matters, in fact, much more than anything. As you are aware, I'm from Durban, and unlike in Pietermaritzburg, we deal more with commercial work than the Pietermaritzburg court. I'm not saying that they don't. What I'm saying is they also have a lot of administrative law matters, which we don't have. But I have been dealing with commercial law matters, so I'm not too sure where that what that comment would be based on.
You see, Judge Masipa, that comment seems to be borne out by the work done by the GCB. If you go through their comments, they managed to find 7 reported judgments, most of them being your SCA, when you were acting in the SCA, and they managed to find 7 unreported judgments. So from that, there does seem to be a scarcity of comprehensive judgments written by yourself in litigation of substance.
Yes. No, I understand where that's coming from now. What has been reported by the GCB is not, it's in respect of mainly the reported judgments. I have written a lot more judgments which are available on Safli. In fact, some comments have been made that I like writing judgments versus delivering extempore judgments. But I have a lot of commercial law matters that I dealt with, and judgments are available. They may not be reported in the law reports, but on Safli you will find them.
And lastly, I think that the concern gets exacerbated when the questionnaire asks for your 10 most significant judgments and you only provide 9.
Well, I think my understanding would probably have been that they wanted them for the past certain period and not, I believe that what was required was the reported judgments, not those ones that were published in SAFLI. But I have a lot of judgments that have been reported on SAFLI.
Thank you, Chief Justice.
May I also ask you about the cases you have listed under question 16 in the questionnaire? Have you got your questionnaire there? Question 16 is at page 9, paginated page 9.
Not too sure that.
Have you got your bundle? Have you got your bundle in front of you?
I have the bundle.
Which has got your questionnaire?
Yes. You said.
Page 9.
Justice, page 9.
Yeah, question 16. Can you see there? Are you there?
Yes.
Yes.
Item number 16.
Yes.
Okay, sorry, it's my page 10, that's why I'm asking.
Well, on what I have, it starts on page 9 and continues to page 10.
Okay.
See, question 16 is, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. You see that?
Yes, I do.
Would you agree that what the question requires is that you must not just give the case, but you must also say why you say it's one of the most significant of your judgments?
Yes.
Okay. You see, if you look at your answer under question 16.1, you give the Zondi judgment there, and then you say unanimous judgment after convincing 3 senior members of the bench who initially were.
Sorry, pardon, I beg your pardon, Chief Justice. Which one are
I'm
you?
sorry. No, I'm sorry. Sorry. No, I'm looking at the wrong page. I'm sorry. I'm sorry. I'm terribly sorry. Commissioners, if there's somebody who has a question, if they can ask in the meantime while I am sorting myself out here. Let me see, Commissioner.
Chief Justice, the page is page 10
Is it?
of this particular applicant's application, where the item 16 appears. So it's page 10 up to page 14.
I'm sorry. Thank you, Commissioner Mugai Toby. I think that please go ahead. Go ahead. I got mixed up with my.
Good afternoon, Judge Masipa.
Afternoon.
In the context of a commercial contractual dispute, how do you see the principles of good faith and fairness fitting in?
Contracts are concluded on the basis of good faith, and it is expected that both the contracting parties are entering conclude their contract in good faith, and with all the bona fides, and where it ultimately appears that there is no good faith in a contract, then the contract, the wrong party will obviously not succeed, with the case.
Sorry, I'm not clear on your answer.
When parties are contracting, they're contracting in good faith. So you have to believe that the other contracting party is being or having all the necessary bona fides in concluding the contract with you. So what I was saying is where there is no good faith in a contract, and there is malafides, the aggrieved party, if there is a case in court, would have an election basically on whether to still have that contract enforced or to be seeking an order to be released from that contract.
So as the judge, could you use the principle of good faith to interfere with a contractual agreement?
Yes, I would, because of the importance of good faith. It's what informs, the intentions of the parties in concluding a contract.
Are you aware of the SCA and Constitutional Court cases that have, in the last couple of years, looked specifically at this question?
No, I have not had to deal with the issue, so I'm not aware of those.
Because in fact, the courts have held that good faith is not a freestanding principle, that in itself can be used to find against a party in a commercial contract.
Could I just follow up? What about fairness? If a party comes along before you and says, I don't like this clause in a contract, I believe it is unfair, I want you as a judge to strike it from the contract, can you do that?
Again, I've not had to consider that issue. When parties contract, it is taken that they have read and they've understood, they understand the base upon which they're entering into a contract. So the difficulty of my answer is that in view of the case that's been mentioned, I am not aware of. I'm at a disadvantage of saying whether that should be done or not.
Thank you.
Thank you. I don't see any other indications. And also from the virtual, I've not been told there is any hand. We have come to the end of this interview. Thank you very much once again, Judge Masuko, for availing yourself. You are now excused.
Thank you.
Thank you. Good afternoon, Judge Mdali.
Good afternoon, CJ and the commissioners.
How are you this afternoon?
I'm fine, CJ.
Thank-
Thank you for asking. I
thank-
take it you're well.
No, we are all well.
Thank you.
Yes. Um, Thank you for availing yourself for consideration for appointment to the SCA and for coming to this interview. We appreciate it. We are going to ask you questions aimed at satisfying ourselves to what extent you meet the selection criteria that we have adopted for the selection of judges for appointment to at different levels of the judiciary. I will ask you some questions. The head of the Supreme Court of Appeal will ask you questions, and the minister and other commissioners. We've got the information
Thank you, CJ.
that you have supplied to us through the questionnaire and other documents. We are not going to seek to cover everything. We'll focus only on certain aspects. But when we consider your candidacy, we will consider everything. You understand?
Thank you, CJ. I fully understand.
Yes. Now, in terms of academic qualifications, I see that you have got BA Law, LLB, and LLM. Is that correct?
Correct, CJ.
And you got your BA Law at the University of the Western Cape, as well as your LLB, but you got your LLM at Cardiff University of Wales. Is that right?
That's correct, CJ.
Yes. And in terms of work experience, you started as a public prosecutor and worked also as a state advocate up to about 2003. Is that correct?
That's correct, CJ.
Yes. And then you were involved in the Special Investigating Unit. You write here as a legal representative. What does that mean?
CJ, that meant that the special investigating gets proclamations to investigate certain government departments for maladministration. And as legal representatives, our duties they entailed giving legal advice to the investigating team as to what the legislation entailed and what areas they could explore.
Yes. And then you were appointed as an acting judge in 2010, June, is that right? In the Land Claims Court?
CJ, it started in 2009, July
Yes.
2009, in the
Yes.
Northern Cape High Court in Kimberley.
Yes, yes. And then that's July to
May 2010.
2010.
Yes,
That's close to a year.
That was close to a year, CJ. Yes.
Yes, and then you continued in, you were also in the Land Claims Court during part of that period.
Yes, it was after I finished at the Northern Cape, and then I went to the Land Claims Court, and that continued, CJ,
Yes.
up to the end of, up until I was appointed, but I stayed there until the end of December.
Yeah, you were appointed to the High Court in October 2010, is that right?
That's correct, CJ.
Yes. That means that you are about, 13 years on the bench now?
No, CJ, is actually in August this year, I'll be 15 years on the bench,
Oh, so at
including
least-
my acting stints.
So I robbed you of 1 year.
2 years, actually,
2
if you
years.
say it's about 13 years.
Okay, all right. Okay, all right. Now, can you share with the commissioners the breadth of your experience as a judge of the High Court in terms of the branches of law in which you have been able to write judgments in the High Court over the years?
CJ, I've had to write judgments in the criminal law, obviously, I have had opportunity to write judgments relating to the law of contract, delict, procedural law also, um, what's the, customary law. That's all I can remember so far, CJ.
Did you say, so customary law?
Customary law, criminal law, law of delict, contract, CJ,
Yes.
law including matters involving the constitution itself.
Yeah.
I've had opportunity to write judgments there too.
Yes. Now, the matters where you have written judgments where you say they involve the Constitution, were they matters where you had to consider certain constitutional principles, or were they matters where you were called upon, for example, to declare legislation invalid and so on?
It would involve both, CJ. There's one case that I've attached, which we discussed in the previous interview, where I had to declare a certain provision unconstitutional.
Yes.
And also with the constitution being the supreme law of the land and impacting in every aspect of the law. It often comes even in crime where you have to decide on constitutionality of certain acts.
Yes. Now, you have also acted in the Supreme Court of Appeal.
That's correct, CJ.
For how long have you acted in the Supreme Court of Appeal?
2 months, CJ, starting from October 2022 right through to the end of November 2022.
Yes. And did your acting in the Supreme Court of Appeal expose you to other branches of law that you have not been exposed to at High Court level?
CJ, I'm trying to think now the number of cases I was involved. Yes, one matter that I wrote on involved extradition that I was not involved in the High Court. But in the other matters that I was involved, that I was allocated to, the areas of law were pretty much the same as what I was used to in the High Court.
Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, CJ, the doctrine of separation of powers entails that power is not concentrated in one sphere of government, but it provides for three arms of government. First being the legislature, which make laws, and then the executive, which makes policy and has a duty to carry out the laws made by the legislature. And then the third one being the judiciary, which has a duty of interpreting the laws and not to make laws.
And the rule of law?
CJ, the rule of law entails that no one, the law governs what happens in this land, and no one is above the law. Every citizen in this country is subject to the operation of law, regardless of stature and otherwise. The Constitution being the supreme law of the land, Yes.
Okay. And then I would like you to go to your questionnaire. Question 16 at page 9, paginated page 9.
Thank you, CJ. I'm there.
Yes, the question there is, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. You understand that?
Yes, that's correct, CJ.
Um, There, the first case you refer to is Zondi versus the state, and where you are supposed to indicate why you regard this case as most significant. You say unanimous judgment after convincing 3 senior members of the bench who initially were of a different view.
That's correct, CJ.
Uh, so, uh, why why is that judgment significant, or one of the most significant?
Well, it is significant in that it was my very first judgment in the SAA in the 2-month stint that I was given. And one would have expected that being a novel in that court, one would be intimidated to express one's views. And it is a judgment which would have gone haywire were it not the fact that I was able to realize my duty as one of the, as part of that panel, that I had a duty to look into the record properly, look into the law, and then I had a duty to make a contribution as a member of that panel.
You don't think that the significance of the judgment is supposed to be on the issues it deals with and the conclusions you reach?
CJ, that does not mean that I think that is not important, but if one reads that judgment, the very first paragraph of that judgment, I mention the duty that lays with the prosecution, with the content and the reason why the outcome of that judgment, what caused the outcome of that judgment to be what it was.
But remember, the questionnaire required you to tell the commission here, in answering the questionnaire, why you regarded the judgment as important. You understand that?
I fully understand that, CJ,
Yes.
but that would talk also to the independent mind that I have, my independence as a judge, to be able to express one's views. That implies what I have said, so they implies my independence as a judge and consciousness of doing justice to matters.
I'm not sure that I follow. You see, the purpose of the questionnaire is to collect enough information from you, which the commissioners can use to see what your abilities are, to see your thinking, and so on. So the questionnaire is saying, give us judgments that you regard as most significant and tell us why. Now, you do mention some things that are in the judgment, but you are not mentioning what is written on the questionnaire as the answer. You understand that?
I fully understand that, CJ, but in my view, one of the attributes of a judge is to be independent.
Yes, but is to be independent meaning not answering the questions that are in the questionnaire? Because We want to know more about you. Now, you are not telling us information. Is that what the independence is about? What are they going to do if I don't give them this information?
Well, CJ, I must have misconstrued what was required there, but I thought this answer that I have given tells that much about me.
Okay, all right. The next case you give at 16.1.2 is Ricardo Paolo Spartani versus ADPP, Western Cape, SCA, unanimous judgment. There, you don't tell us why that one is important, unless the idea is that the fact that it was unanimous is what makes it important.
CJ, I must, as I said earlier on, I didn't know that I was supposed to elaborate on the issues pertaining to the judgment itself. I thought attaching the judgment was there for the commissioners to read the judgment and assess me on the judgment itself.
Yes. Well, I think most of your answers of what you say under 1616 in regard to the cases, it seems it's along the same lines where maybe not all, but most, where the information you have given really doesn't speak to the reasons why you think those cases, those judgments are important. Am I right?
Well, I will accept that, CJ, except for when one looks at 16.8
Yes.
in the list.
Yes.
Um,
16.1.8.
and then 16.17, sorry, 16.17 starting there.
Yeah.
And then 16.18, and then 16.19, as well as 16.10. 16.110.
Yes. But you see, for example, 16.1.8 says you give the case and then you say, granted an interim order which halted the operation of a contract entered into through flouting legal prescripts. So cases like that are happening every day through the breadth and length of South Africa, where tenders had been given unlawfully and they are. So you don't tell the commissioner what was so important about this one. You understand? Where my
I fully
difficulty is.
understand, CJ.
Yes.
And
But I'm not saying necessarily that there isn't one or two where you have given the right information, but I'm saying it seems to me most of them don't have the kind of information that one was expecting, which
CJ,
talks to the importance.
Thank you, CJ. I have now learned. I will try. I
Yes.
will understand next time what is required of me. But I
Okay.
thought attaching the judgment itself is
Yeah.
the best means of assessing my ability
Yes.
for the commissioners here.
Yes. President of the SA.
Thank you, Chief Justice. Good afternoon, Justice Mjali.
Good afternoon, President.
Yes, just to continue where the Chief Justice left off, because I too have the same concerns in terms of the judgments that you refer to under paragraph 16. And this concern also emanates from the fact that you acted at the Supreme Court of Appeal for one term. And I think it was very, very important for you to highlight all these cases, significant cases that you have participated in. And in relation to 16.1, that's the one where you only say unanimous judgment after convincing 3 senior members of the bench who initially were of a different view. Now, I don't know what is significant about that, because At the Supreme Court of Appeal, we sit in panels in every single matter. So after the hearing, in every single matter, we have a conference, a post-hearing conference where we discuss the appeals. And I think it will only be in a few appeals where from the outset colleagues were unanimous. The whole purpose of a post-hearing conference is to debate matters. And that's where we have robust discussions, where we express our views. So I see nothing significant about the fact that at some point colleagues were not agreed and later on a unanimous judgment was handed down, because the judgment remains a unanimous judgment. It's not as if you wrote a dissenting judgment or a separate concurring judgment. What
This
is
is-
your comment?
This is one judgment I would have been prepared to write a dissenting judgment, even if the 3 senior members of the bench were against me. And was my one of my first judgments that I had to write there.
Yes, but that
and
is, sorry,
one
sorry,
of the
sorry for the interruption, Justice Mjali. And maybe you are missing my question. I'm saying it happens all the time in conferences that colleagues have divergent views and they end up agreeing. So for me, the fact that at some point there was no agreement, but later on colleagues agreed and a unanimous judgment was handed down does not make the matter significant, especially since you have not indicated what is significant about the matter other than the fact that there was initially divergent views and later on a unanimous judgment. In other words, the point of the matter is, at the end of the day, it was a unanimous judgment. You did not write a separate judgment, or let me say, you did not have to write a separate judgment or a dissenting judgment. It remains a unanimous judgment.
I don't know how to respond to this question, but I mentioned earlier on that this talks to my independence as a judge. This talks to my realization that even if I'm a novel in that court, I have a duty. And this is the duty I exercised in this judgment when things didn't go. In fact, before we went for the hearing, they were all convinced that this was one appeal to dismiss. And it was clear by means of the questions that I posed in court that they missed something. So if that is not significant, then I thought also attaching this judgment in my with my questionnaire would provide the means for this committee to then properly assess me.
All right, thank you. Can we go to page 12 of your questionnaire, please? 16.4.
Yes.
And list cases in which you gave judgments that were successfully appealed against.
Yes.
I note that you mentioned only one judgment.
Come again? In 16.4?
Yes. How many
I
judgments?
mentioned 2.
Oh,
There's 16.41, there's 16.42.
Oh, okay, all right. 16.41, 16.42. Yes, you mentioned 2. But I see that you signed the questionnaire on the 20th of March 2024.
That's correct.
And by then, another judgment, setting your judgment aside, had been handed down at the Supreme Court of Appeal.
And which judgment was that? I was not aware of it.
Min-
Obviously, I would have mentioned it if I was aware.
Minister of Justice versus Kamani.
Minister of Justice versus Kamani.
It was handed down in 2023.
I was never made aware of it. My apologies. My apologies.
Thank you. So You responded to the CJ's questions regarding the areas of law that you were exposed to at the High Court. And I think he also asked you whether at the Supreme Court of Appeal you had exposure to additional areas of the law. And I think your answer was with reference to a matter pertaining to extradition.
That's correct.
Yes. Did you get any exposure to specialized fields like perhaps maritime law, patents?
In the Supreme Court of Appeal, you mean, President?
Yes.
Not in the Supreme Court of Appeal. There were set cases in which I was involved there, which did not involve maritime law. My exposure to maritime law would be when I'm sitting in Port Elizabeth, where we get applications relating to the arrest of ships and all. Over and above that, my LLM includes maritime law. Was in maritime law, it was in international tax law, as well as international trade law.
Thank you. So, Justice Mjali, you will probably know that the Supreme Court of Appeal has lost a lot of expertise and experience due to the retirement of many judges and elevation of others to the Constitutional Court.
That's correct. I'm fully aware of that,
Yes.
President. That was the case even in the last sitting.
Yes, would you agree that in light of that, it is quite crucial that the candidates that appointed should be candidates who will complement the remaining expertise at the Supreme Court of Appeal, both in terms of expertise and in terms of experience?
Certainly, President.
So what would you regard as special attributes that you bring to the table to the Supreme Court of Appeal should you be appointed?
President, I bring on the table first my experience in law, which started as early as 1989 as a public prosecutor. I bring together with me my experience now on the bench, which stretches to in excess of 14 years, 9 months, I think. My independence as a judge and my decisiveness as a judge. I'm a hard worker. I have not been found wanting in terms of delivering judgments beyond the time allowed to do so. That's all I can say. And I think also I bring with me my experience in the customary law, coming from the area where customary law finds so much application. I think that skill is required in the Supreme Court of Appeal, rather than focusing only on the commercial cases and other areas of law. I think that court should be a well-rounded court. I also bring my lengthy experience in the criminal law side, which I think it's the field of law which is often not given sufficient weight, whereas it's the field of law that affects each and every citizen of this country. It affects the rich, it affects the poor, it impacts on the constitutional rights of people. I bring together with me that kind of experience in the SCA. Should I get the nod?
Yes, thank you. Last question, Chief Justice, would you agree that the SCA being an appellate court, it is very important to have collegiality on that bench?
It's very important, and in fact, not only in the Supreme Court, but in every bench. In the High Court too, we sit in panels of 2, panels of 3. We work together as colleagues. That is where collegiality started. I bring together that experience, which stretches beyond the period of 14 years, collegiality.
Thank you, Justice Njali. Thank you, Chief Justice.
Thank you, Minister.
Thank you very much, Chief Justice and Judge Njali. Good afternoon.
Good morning, Minister. Sorry, good afternoon, Minister. It's late afternoon, actually.
Yeah, thank you. I just want to one question on this matter of Coliso versus State. I think it's in the
Kotleso versus the state.
Coliso.
Pardon, Minister? Pardon me, Minister?
It's Coliso.
Koliso.
Yeah, versus the state.
I think it's the same case.
Oh, yes, the vulture feet case.
Yeah.
Yes, Minister.
My only question relates to that you had taken issue with the fact that it applied to certain parts of
Yes.
the Eastern Cape and not certain parts. And you might be aware that we've just recently repealed the Eastern Cape, or is it the Transkei Penal Code?
The penal code.
The Penal Code, yes.
Yes.
So I'm just asking myself, what then can this also affect any other provincial legislation? This kind of principle that something cannot affect certain parts of the Eastern Cape, but others. Can the same argument apply in relations to provincial legislation that in certain parts of the country something is applicable and others is, because we do have such type of legislation in the provinces, which might be different to, for example, the Western Cape has its own type of legislation, the Western Cape has another one.
CJ, it would be, I'm sorry, Minister, it's obviously absurd to have one legislation applicable to one area of the country and not applicable to the other. I often wondered as to why in the Transkei we still worked with the old Transkei Penal Code, which in effect contains many of the common law crimes. Why not just go the South African way, the old South African? I mean, why not just create a uniform legislation applicable to the whole of South Africa? It has always been a concern that when charge sheets are drawn in that area of the country, it makes reference to the penal code, when in actual fact, it's murder. In Bisho, it's murder in Grahamstown, as well as in PE, those being courts of the same province. I cannot think of any other legislation offhand where the same needs to be done. I unfortunately cannot think clearly now and quickly and be able to refer, Minister, to some kind of legislation where that attention needs to be drawn.
Yeah, no, you're not alone in this wondering. I was also wondering, why did it have to wait for me for 30 years? Thank you.
Thank you.
Thank you.
Thank you, Minister.
I don't, Commissioner Marmohai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Professor.
I have a question for you. It's a general question, but I think I want to place it on one of your judgments, and perhaps as an entry point to it. If I can take you to the judgment in paginated page 47, the Smith judgment. I think it was Smith
Page 47.
47 years. I think it was Smith and a firm of attorneys.
Oh,
It's a
yes.
judicial case.
Yes, yes.
And in particular, paragraph 15 of that judgment.
Paragraph?
15.
Thank you, Professor. I'm there.
Yes. In that paragraph, you deal with the concept of wrongfulness and the concept of negligence. And you, and you correctly rely on a problematic case of Telemex. It's from the Supreme Court of Appeal by Harams.
Yes.
And in that case, Harams makes a point that the former judge Harams makes a point that there is, and just be accurate, he says that to elevate negligence to the determining factor confuses wrongfulness with negligence and leads to the absorption of English law taught of negligence into our law. So, in paragraph 15 of your judgment, that interplay between negligence and wrongfulness comes out, right?
Yes.
So what I want to understand is there some conflation between these two elements of delict? And is our courts done enough to try to put them separate so that we can understand what are the factors that informs one as opposed to the other? And if there is, what can be done to ensure that these two seemingly conflicting sort of grounds for elements of delict can be sort of separated, if separating them makes sense at all? I'm not sure if you get the question that I'm asking.
I'm not sure, Prof, if you can maybe repeat it for
Okay.
me. That would be.
What I mean is, currently we see that when a court is seized with a delictual matter and it has to apply the elements of delict,
Right.
there seems to be some confusion between two elements in particular: wrongfulness and negligence. In other words, the way the court goes into showing that the element of wrongfulness is there seems to be conflating with the way how courts actually show also that negligence is there. So I just want to understand, do you see that conflict? Is there any conflict, or is it just something that is imaginary? And there have been a lot of writings on this. I mean, Nithlin and Potritter have written extensively on this point, on the conflation that I'm talking about.
I remember reading such, but well, the determination of negligence seems is based on the convictions of the community, the boni mores of the community, and if a conduct does not accord with that, there is some element of wrongfulness there. But with negligence, one requires a duty to act, and failure to do so translates to negligence.
No, thank you very much, Judge. Thank you very much, CJ.
Thank you very much. And there are no further hands, and I've not been told that there are any hands on the virtual platform. That means we have come to the end of this interview. Judge Mchali, thank you very much for availing yourself. You are now excused.
Thank you. I thank you, CJ. I thank you, the commissioners. Thank you for having me.
Thank you. Good afternoon, Judge Siwendu.
Good afternoon, Chief Justice and the Commission.
How are you this afternoon?
I'm as well as I can be.
Okay, no, that's all right. Thank you very much for availing yourself for consideration for appointment to the SCA and for coming to this interview once again.
Thank you for inviting me.
Yes. We interviewed you not so long ago, so a lot of things about you are still fresh in the minds of some of us. But in any event, you have given us a lot of information in the questionnaire and in other documents that are in the bundle. So we are aware, and everyone is taken to have read the information. We are therefore not in the interview going to try and cover all the information that is there. We'll simply focus on certain aspects on which we would like to hear what you have to say.
Yes.
We will ask you questions aimed at satisfying us as to what extent you satisfy the selection criteria that we have adopted for the selection of judges to various levels of the judiciary. So nobody wants to block you from elevation, but we all simply want to make sure that we are satisfied about your meeting of those criteria. So I will ask you some questions, and then I will allow the president of the SCA to ask you questions, then the minister, and then other commissioners. So let's start. You hold 3 degrees, is that correct? That is Bachelor of Social Science and the Honors of Social Science and LLB, is that correct?
That's correct, Chief Justice.
And you practiced as an attorney for a number of years.
Yes.
About how many years altogether?
Well, post-admission, I've practiced for 22 years before
22 years.
I got elevated to the bench.
Yes. And you got appointed to the bench when?
It was January 2017. This is
Yes.
after acting as a judge from 2015, I beg your pardon, 2014, 2015, and 2016, but not continuously.
Yes.
Yes.
You practiced at some stage for your own account, for your firm, but at another stage you were with Cliff Decker of Mayor, is that correct?
Yes, I practiced for my own account from 1996 until
2012?
2012, that's correct.
Yes.
Yes.
That's like, is it 14 years?
For my own account? Much longer than that.
Much longer than that?
Yes. 17
1996
years.
to 2012?
Well, from 1996
or 16
to
years?
2012, it was
16 years.
16, 17 years.
Yes.
And then
With-
4 years
with Cliff
with the
Decker.
larger law firm, yes.
Yes. Would you like to share with the Commission the breadth of your experience before you came to the bench? What branches of law were you involved in?
Thank you, Chief Justice. I believe I occupy a rather unique place because I started a commercial practice in 1996. And as I had indicated before that, I was working for a law firm
that was steeped in human rights and also aspects of the development of the Constitution. And within that firm, which is Cheadle, Thompson and Haysom, and as I've said, they started a small department where trade unions were engaging in various transactions. And I worked with one of the respected partners, who's now the president of the Competition Appeal Court, in some of those very early BE transactions. So I got exposed not only just as a fellow at CALS in some of the debates around the Constitution, and also as an academic support program lecturer in labor law. I then got exposed to human rights law, and thereafter started to get involved in those early transactions where trade unions were taking stakes in companies. Once I left Cheadle, Thompson and Haysom to work in Pietermaritzburg, the branch office in Pietermaritzburg, I continued my work in labor law as well as certain aspects of human rights. And then I started my own practice in 1996. And that practice was founded on, and I keep saying, on the back of Transnet specifically, because I started to get involved in property law. And I forgot to mention that the early debates around separating the Port Authority from Transnet and the various divisions, I was advising in those matters. And my firm expanded exponentially, and we took advantage of the thinking around Black economic empowerment, and we were advising smaller companies who were entering into transactions with the larger companies by way of various joint ventures and the like. And my practice also expanded to work with various sectors of the private sector, like the business partners, in relation to litigation, as well as some of the oil majors. Things did improve further in the sense that we got called in some of the early transactions where we were to be doing due diligences. And I've got in mind the old debates around SAA Express, for example, and the electricity restructuring. We were at the cold face of those discussions when they were looking at regional distributors. I got engaged in municipal law from the point of advising around certain infrastructure projects within the municipality. I served in the Best Practice Commission of the City of Durban when they were looking at the impediments to investment and some of the legal framework that is stymieing investment within the city. Side by side with that, I then got involved with various boards in shipping, in retail, in investment, and all that. And that really created this broad foundation of understanding the various business structures, the various models for business structuring. So early 2005, I got called by ESCOM, incidentally, to work with one of the renowned experts in the area of corporate governance. And that's when I commenced my foray in the area. And that work is not just fuzzy, it is taking the legal imperatives and translating them into systems of governance within the companies. So I started to work with various boards in that area, and thereafter, I got involved. I was called in as a fellow at the business school at the University of Stellenbosch, where we started a unit for corporate governance. and we worked with one of the renowned experts in the area to start the center. And when you hear conversations, for example, about ESG, which is environmental and social governance, I'm amongst the people who first proposed that for the PIC, where we devised a rating matrix system for some of their companies, top 40 companies listed on the JSE. So I got involved in a range of areas which really give me insight into not just commercial transactions, but some of the thinking and the structuring of most companies in various sectors. This is before I joined the bench. And then there was obviously the compliance component of it, where you would take, for example, in the mining sector or in retail and so on, where you assist companies with their compliance projects, which is a top-down approach from the board right up to the risk teams. And lastly, I mean, I happened to also be involved in aviation from the perspective of being a non-exec at AXA at the hit of the World Cup and so on. So broadly, I came with that broad understanding.
Yes. Now, over the years that you have been a judge in the High Court, in what branches of law have you given judgments?
I think a variety of matters. I've written on property law. I've written on enforcement of securities, which tends to happen in urgent applications. I've written on enforcement of foreign judgments. I've written on shareholder disputes. I've written on business rescue. I've written on insurance. I've written on reviews, both under PAJA and legality. I've written on procurement. I've written, and I'm just trying to run through I've written on customary law. I've written on family law. I've written on civil litigation broadly. I've written on unjustified enrichment. I've written on contractual disputes, to mention but a few of the areas I've written on.
Well, that didn't sound like a few, but you must understand that the purpose of this question is to enable you to show the commissioners what the breadth of your experience, judicial experience is.
Yes.
So if there are other branches where you have given judgments, tell the commissioners.
Thank you. I just need to find my feet and remember what I would not have mentioned. I think by and large, I've mentioned the areas. I've written on criminal law, obviously, and then civil litigation, various aspects of around contract enforcement, and RAF, and those areas.
Okay, all right. Now, you have acted in the Supreme Court of Appeal over a number of times, is that correct?
That is correct. I got an opportunity to spend a year, in fact, as I had said the last time.
Did your acting stints in the Supreme Court of Appeal give you exposure to other branches of law to which you had not had exposure at the High Court?
The one area that springs to mind is trademark and trademark law. And I sat in two matters at the Supreme Court of Appeal where there were disputes regarding the registration of a trademark, and which I really enjoyed it tremendously. Yes.
Yes.
And the other was a huge infrastructure project, but because I come with that experience around financing and structuring some of those, I also sat in that matter, which was one of my first big matters at the SA.
Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes. If I recall, I know that there may have been many judges of the Constitutional Court which have written around this. I think Judge Noble comes to mind in particular when he talks about this relationship of comity between the various arms of government. And as I understand it, what it really means is that within the Constitution, there are delineated responsibilities for each arm, and also with that, the powers entrusted to each arm, and that the judiciary needs to respect the delineation of the powers and not unduly encroach in the powers, for example, the powers of the executive and so on, and vis-a-vis.
And the rule of law?
The concept of the rule of law, as I understand it, is that all conduct and all laws are really subject to the Constitution, and that is the pervading principle that regulates all of us, citizens, government, the judiciary, and everybody is subject to the Constitution and the rule of law.
Thank you, President of the SCA.
Thank you, Chief Justice. Good afternoon, Justice Suwendu.
Good afternoon, President.
Yes, you acted at the Supreme Court of Appeal for 5 terms. I think it was 5 consecutive terms.
That's correct,
Yes,
President.
yes. How was the transition for you from being a judge of the High Court to being a justice of the Supreme Court of Appeal?
I think I did indicate last interview that the first 2 months were really difficult for me. And the difficulty was not the work itself, but we'd come out of COVID and we'd been working from home. So the difficulty was adjusting to Bloemfontein. I really got very sick those first 2 weeks, but that didn't impede my work. But the other is obviously working with larger teams and larger panels. And I think for those first two months, being trying to sense into the unwritten rules and unwritten expectations and trying to get to know the system. But once I went over that hurdle, which is really a personal hurdle rather than an intellectual or ability hurdle, I was able to find my feet. And I really, towards the end, I really enjoyed myself and feel that I acquitted myself well in relation to the expectations.
Did other colleagues have to give input on matters of substance in relation to your judgments? I'm not referring to style issues or cosmetic issues, but where the judgment that you had circulated had to receive a lot of attention from other colleagues,
No.
specifically in relation to matters of substance?
No, not at all, not at all. And the commission will remember even the last time I did say that one of the areas I really had to work on, and I think I've now come into firm grips of that, is the style of writing for the appellate court. But when it comes to matters of substance, my judgments were never, had to be reworked. And I don't believe in any way that I was in any way a burden on the presiders there.
Yes, I note that you have been a permanent judge for 7 years.
That's correct.
Yes, and you are probably aware that the SCA has lost a lot of experienced judges due to attrition and some retiring and others being elevated to the Constitutional Court. In fact, the amount of experience that has been lost over the last 4 years, 4 years, I think it's more than 100 years of judicial service, so it's quite a lot.
Well, if I remember, it was said 340,
Yes, yeah.
340 collective years.
Yeah, that was, I
Yes.
think, from 2019 or so,
2019.
but it is quite significant, you agree?
Absolutely. It is absolutely significant.
Yes. So
And-
you'd agree that it would be absolutely crucial for that kind of expertise to be replaced with almost similar expertise. In other words, expertise that will actually complement the remaining expertise on the bench so that the court remains a well-rounded court.
I've thought about this a couple of times, and I'm just going to go back to my answers to the commission the last time. I've gone out and I've done my own research in terms of how the court has evolved. And I've found that it's not the first time that the SCA is at an inflection point. There was a time, whether it was because of transformation imperatives or whatever, that it seems to have adopted this principle of infusion in the sense that what I know for sure is that once the longer time you have in the judiciary, you obviously gain the technical skills and the experience. But because law is such a dynamic field, I saw that a couple of times they've appointed, together with experienced judges, judges would say, we've been at the High Court for 3 years, in some instances 2 years, in some instances 5 years. And so it's not unheard of for the court to build a complement of skills. The way I have seen it in this instance is that in most instances, the skill set that is left has stayed there for 20 years. And therefore, the opportunity to refresh got stymied and got limited. And I'm not going to dispute, absolutely, experience is important, experience is critical, but the renewal and fresh thought and fresh thinking sometimes is necessary to keep the law dynamic and responsive to social needs.
Yes. Lastly, you'd agree that the appointees must be candidates who are going to, in some way or another, address the current needs of the court.
I agree.
Yes. Sorry, Chief Justice, I had said the last point. The last point is this one. Would you agree that collegiality is important at an appellate court? I know that we do sometimes in the High Court sit in panels of 2 or 3, but in the Supreme Court of Appeal, there will never be a case in which you will sit alone, all by yourself, which happens in the High Court. Which, would you agree that that is the very reason why collegiality is so crucial at the Supreme Court of Appeal?
I agree, President, entirely and wholeheartedly. And my view is that that gets tested when there are different perspectives and different points of view. And collegiality is such that it's so critical so that one can accommodate different perspectives. And I've found that it only just but enriches the judgment. It only but enriches the thinking around the judgment. And that's where it's like a family. You know the tightness of a family when it is able to resolve, disagreements collegially. Absolutely.
Thank you very much, Justice Siwendu. Thank you, Chief Justice.
Thank you.
Thank you, Minister.
Thank you, CJ. I've got no question.
Thank you very much. Commissioner Marmoha.
Thank you very much, CJ. Good afternoon, Judge Sowendu.
Good afternoon, Commissioner.
In the list of areas that you have written on, you left out one important one. You have also written in pension law. And
I've also written,
in pension law.
oh yes,
Yes.
in the context of review, in the context of reviews, yes.
Yes,
I
but it
have.
went further than that, and that's what I want to discuss with you.
Thank you.
Can I refer you to pagina? The way they are paginated, it's as if it's case line, and they have two paginations. Like there's one on the right and there's one in the bottom. So on the right, you'll have 160 at the top, and I think at the
Just
bottom.
160.
Yes.
Actually, now that you are making me page through, I've forgotten to mention that I've also written on restraint of trades.
Oh yes. So
Yes,
page
160.
160. It is a Southern Sun judgment.
Yes, yes, yes.
This is where the fund applied to distribute or to apportion surpluses. And the FSCA was against that because beneficiaries could not be located.
Yes.
And you dismissed the fund's application, right? And what I don't understand is when I look at paragraph 28,
28.
of your judgment,
Yes.
when you dealt with the regulation, you seem to have approached them. I'm not sure if this is how it was pleaded, but you seem to have approached this matter from an administrative law point of view, and PAJA in particular. I'm not sure if you are aware that this matter was actually subsequently appealed to the
Yes.
Supreme Court of Appeal, and it was overturned.
I've listed it in my
Yes.
list of judgments, yes.
And what I like, the way you determine the issues and the way the Supreme Court of Appeal determined the issues or determine what the main issue was seems to be different. I'm not really sure if the case evolved when it went to the Supreme Court of Appeal. Because what in paragraph 2 of the Supreme Court of Appeal's judgment, they are saying the question that they are seized with is whether the regulation in question is ultra vires the powers assigned to the minister in terms of the PFA. So they seem to find their root within the Pension Funds Act, and quite correctly so. So my question to you is, to what extent disputes that arise within the context of the Pension Funds Act in particular can be resolved in terms of administrative action?
First of all, maybe let me just, let's walk it back and take a little step back. If you read the judgment, there were a series of issues that were raised. The first hurdle was around a dispute of whether this is a PAJA or a legality review. And then the second hurdle was the question of the extension of the time within which the application was launched, right? So I had to first go through those hurdles, and that's what you obviously see under in paragraph. The last hurdle was obviously whether or not the regulation is ultra vires. So all of that is dealt with. And I think the significance, if you go to the list of judgments that I have given, the significance of this judgment is that I point out that there were a triad of matters where the core issue, the core dispute about the reviewability of the regulation was challenged, but those issues were not addressed. And the Supreme Court of Appeal didn't overturn my exercise of the discretion to deal with the merits. So I had to systematically, obviously, as a first court, address first all of those issues before I get into the merits. And that's why they were distilled that way.
I accept that. When I was reading because I actually got to read the Supreme Court of Appeal judgment first before I went to yours. So I was just it was quite interesting how the Supreme Court of Appeal framed the issue. Because when you look at that judgment, they don't actually deal much with Paja per se. They instead, to some extent, deal with the principles of legality. And they don't concern themselves too much about the administrative law part. And there's a reason for that. When you look at the scheme of the Pension Funds Act and how it is actually designed, you are able to deal with disputes that arise. Section 15B of the Pension Funds Act deals explicitly with surplus apportionment.
Yes, I don't disagree.
Yes.
But all I'm saying is that you must remember that there were triad of matters. There were
Yes, you are
actually
correct,
three
yes.
matters. There were three matters involving the
Yeah.
same issue. And so my judgment opened the way for the SCA to get into the merits because all of the other matters were dismissed, even though the court had given an arbiter judgment, they were dismissed on the reason of the extension and without dealing with the merits. So they had to first deal, and they accepted my exercise of discretion so that they can, and even this judgment, even though it was set aside, it goes into the surplus apportionment, it goes into the regulation in terms of what was envisaged in terms of that surplus apportionment, and it deals with the ultra-various issue. And of course, there was an argument about the reasonableness, which was not the basis on which the matter was brought. So towards the end, the judgment deals comprehensively with all of those issues. And I accept my reasoning was set aside.
No, thank you very much. It's actually set aside the regulation itself.
They set aside the
Yes.
regulation itself.
No,
yes.
thank you very much, Judge Suwendi. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon, Justice Wenda.
Good afternoon, Commissioner.
Yerema, yes. In all the branches of law you mentioned, you didn't say anything about the insolvency law.
I forgot to mention.
Have you written some?
Yes.
Yes, okay. If that is the case, I want to test your knowledge on the insolvency law because I've seen that a lot of people are found wanting when it comes to that area of law.
Yes.
Now, what is the basic test of insolvency?
You must remember that, in fact, one of my latest judgments on that is, I think I've given it's 93 quarts, APSA versus 93 quarts. Remember that the act, the jurisdictional requirement is an act of insolvency. And for companies, that's determined by just 345 of the old Companies Act, which deals with the failure or inability to pay debts.
Yes, okay.
Yes.
That's clear.
Yes.
Now, linked to that,
Yes.
Section 8 of the Insolvency Act
Yes.
provides the circumstances under which a debtor can be declared insolvent.
Yes.
Would you mind sharing that with us? Because
Yes.
if that obtains, it becomes a candidate for, a debtor becomes a candidate for sequestration.
Yes.
What are those?
Yes. So remember that we've got two regimes. There's the regime of liquidation, which is regulated by the Companies Act. And then there's the insolvency regime, which deals with partnerships and which deals with sequestration of individuals. And I think it's Section 8, A to G, there's the act of insolvency, failure to pay your debt, or escaping or leaving the country with the intention to evade the payment of the debts. I've forgotten some of the other requirements, but those are mainly the two that come to mind.
Actually, you nailed it. Thank you very much, CJ.
Can I follow up, CJ? Can I, CJ?
Yes.
Yeah. This side. Can I
Oh,
follow
yes,
up?
yeah.
Just when you, that question that Commissioner Dodovu asked triggered a question of mine. I just want to understand. When you are dealing, and by the way, I'm currently writing a case note on your Absa Bank.
I beg your pardon, you are?
I'm currently writing a case note on your Absa Bank
Yes.
case. Right.
Yes.
I just want to understand. When you are liquidating a company,
Yes.
is your source of insolvency in the actual Insolvency Act and in Section 8 that Mr. Dodovu is speaking about? I got confused there.
No, it's not. Let me explain again. You must remember what's happened is that the New Companies Act creates two regimes. There's the winding up provisions. When you are winding up a company, which is different from liquidating a company. So when you are winding up the company, there's a whole criteria for winding up provided under the New Companies Act, which can include disagreements between shareholders and whether it is just and equitable to do so. But when you are liquidating a company, Schedule 9 or Schedule, I've forgotten now, I'm getting muddled. But what that schedule says is that liquidations of companies is regulated by the old Act. So the provisions relating to liquidation of companies, so you've got this straddling between the provisions of the new Act and the old Act. So all liquidation of companies occur under that chapter 14. And all of those provisions apply to liquidation of companies and the process of liquidation. So there's two different processes, the winding up and the liquidation. And under the Insolvency Act, you are dealing with mainly sequestrations. Yes.
But even with liquidation,
Yes.
the 1973 Act deals only with the liquidation of insolvent companies.
Yes.
And the New Companies Act deals with the liquidation of solvent companies.
No, we don't call it a liquidation of solvent companies. We call it a winding up of solvent companies. Because a liquidation envisages a scenario where the company is unable to pay its debts strictly. So the new Act deals with the winding up of companies, not their liquidation.
Yeah, I think no, I hear you.
Yes.
I hear you.
So
Thank you very much.
I'm trying to be strict in the distinctions. Yes.
No, thank you very much. I won't take it further than that. Thank you very much.
Don't. It's becoming more than a follow-up. Commissioner Moiman. I've got Commissioner Moiman, Commissioner Singh.
Yes.
And except for complaints or objections, I think I'll stop there. Okay, Commissioner Moiman.
Thank you, Chief Justice. Good afternoon, Judge Wendu.
Good afternoon, Commissioner.
It's just one question from my side that emerges from the new company regime that is anticipated.
I beg your pardon, I didn't hear that well.
I'm saying that my question relates to the new mining regime.
To the new?
To the new company law regime.
Yes.
That is will probably be signed by the president because it is on his desk.
Yes.
Yes. It relates to. I need to get your view in terms of the changes that were brought to the time bar, which allows the recovery of loss from the previous directors of company.
Yes.
It's in relation to, it's the response to the state capture report. So Parliament then made amendment to the Companies Act. So I needed to get your view in relation to the changes that allows for even the directors that might have left the company, let's say 10 years ago, to be held responsible for the losses that the company might have incurred. That's your views in relation to that? Because it's part and parcel of ensuring that directors are held accountable in terms of the work that they have done.
Yeah.
Thank you.
I must confess, I haven't studied carefully the proposed amendments because of time. But what I am aware of is that under the current regime, I mean, the whole company law is premised on a separation from the corporation and shareholders and directors and a delineation of different duties between the two. If you recall, if you will remember, Section 76 then creates a statutory duty of directors and in a number of ways codifies the common law position around the statutory duty. And I know that very recently the SCA has produced a judgment around this issue as to whether an aggrieved or an affected person can go directly and sue the directors for losses sustained by a company. And if I understand that decision, the answer is definitely no. There's recourse obviously elsewhere, and I think understandably, because unless, for example, the directors have been declared delinquent and all of that, you can't just go direct. So if legislation is intended to alter that position, but I can confess that I have not had the opportunity to study what the import is of the new amendments, particularly around directors' liability. But of course, the legislature is entitled to amend the act and create different duties from those that are codified under Section 76 and 77, and also those which are applicable in terms of common law. It's within its powers to do that.
Yes, I think you are correct because the amendment to Section 162, 1622 and 1623 is particularly aimed at amending the time bar for bringing an application to declare a person delinquent in terms of the mentioned section that I did.
Thank you.
So it is aimed at bridging that gap. Thank you, Chief Justice.
Thank you.
Thank you very much. Commissioner Singh will be the last one. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Justice Suendu. I'm on the virtual platform.
Yes, thank you.
I just want to refer to your time on the special tribunal.
I beg your pardon?
Now, your time on the special tribunal.
Yes.
And I have two questions arising from your participation in the tribunal.
Yes.
Firstly, how effective do you think are special tribunals of this nature and why? And secondly, what experience have you gained from serving there that you think will hold you in good stead in the SCA if you are appointed? Thank you.
It's a very difficult question to answer in terms of effectiveness, because the executive has chosen this path, and I just need to be careful about how I answer that. I think part of the problem is that when you create a tribunal, it's not a court of law. I think the Constitutional Court has dealt with this in Ledler, and to say that the tribunal is not a court of law, even though it has been given these powers. And there is merit in having a specialized structure which is designed to fast track the investigation and dealing with some of these cases. My sense is that sometimes you are competing for the same pace for resources to be able to deal with this. When, as we've seen it, you can create a structure within the High Court to do so. That's the one question that I've raised. My duty there was around with the other senior judge. We wrote the rules, we wrote the code of conduct. I wrote the first report, and I sat in a number of cases where there were asset forfeitures, which were really interim relief and preservation orders. And beyond that, I was taken back to the High Court. So it is more around the awareness of how poker operates and how it interfaces with the SIU Act. And beyond that, really, I don't know that, and the awareness of how tricky sometimes that interface is. And beyond that, I can't add more.
Do you think that the fact that you had to work with others there, as you would have to work in the SCA, will hold you in good stead moving forward?
You know what? I am a deeply felt self-reflective person and probably more introverted than I'd like. So I'm a deep thinker, I'm thoughtful, I'm reflective, and I'm particularly sensitive, social context sensitive and sensitive to others. And I am a very mature person. So I know how to manage myself, especially in the space of disagreement. And I think that awareness will come in really good stead. And just like the president wants to see the best court, I think that I'm going to be able to contribute to the spirit of collegiality, and especially when things get difficult. I'm a very self-restrained person.
Thank you, Judge Surrender. Thank you, Chief Justice.
Thank you very much. That is the end of this interview. Thank you very much, Judge Suwendu, for availing yourself for consideration for appointment to the SCA and for coming to this interview. You are now excused.
Thank you, Chief Justice, and thank you to the Commission.
Thank you. Uh, Thank you. Good afternoon, Judge Smith.
Good afternoon, Chief Justice and Commissioners.
How are you this afternoon?
I am fine, thank you. I trust you and the Commissioners are also well.
Yes, we are all
Thank
very
you.
well. Thank you. We interviewed you not so long ago, so you are familiar with the rules that we follow when we interview candidates. So I won't repeat them, but basically we will ask you questions.
Can't hear anything.
Satisfy ourselves whether you meet the selection criteria that we have adopted for the appointment of judges to various courts. But before we proceed, I must thank you again for availing yourself
Yes.
for consideration for appointment to the
Yes.
SCA and for coming to this interview. Thank you very much.
Yes. Thank you,
Yes.
Chief Justice. It's an honor to be here again.
Thank you. We have a lot of information that you have supplied us with in the questionnaire and in other documents. We will not seek to cover everything, but all the information before us will be considered when we have to make a decision. So in questions, we will simply focus on certain areas only. I will ask some questions, then I will allow the president of the SCA to ask questions, then the minister, and then commissioners.
Yes.
In terms of your academic qualifications, you hold a BA law degree, LLB, and an advanced diploma in labor law, is that right?
That is correct, Chief Justice.
Yes. And you were admitted as an attorney in 1984, is that right?
That is correct, Chief Justice.
And you practiced as such until you were appointed to the bench, is that correct?
That is correct. That was in I think
2010?
in July 2010, yes, Chief Justice.
Yes. So that had been about how many years?
Without the acting stint, which had been recognized, it would be 14, just about going on to 14 years. And then obviously when the acting stint is taken into account, it would be 15 years.
Yes, no, but I'm talking about the time that you spent in private practice from
Oh, sorry, in
1984.
Yes,
1984 to 2010, how many years
I think
was
it was about 26 years.
Okay,
Yes.
okay. And during that time, of course, you did a lot of human rights work, is that correct?
Yes, that is how the
Yes.
firm started out, Chief Justice.
Yes. Apart from that, what other branches of law did you get involved in your practice?
Yes. For the first, I would say almost for the first 10 years, it was mainly human rights work. Criminal matters, which were mainly defending politically charged persons, and administrative law, challenging validity of regulations and enforcement of regulations, and applications, urgent applications to interdict assaults on detainees, trying to get detainees released, and those type of matters. And then I think it was in 1990, 89 or 1990, when the then Ciskei government adopted a constitution which incorporated a justiciable Bill of Rights. We did quite a bit of constitutional work at that time a number of cases where we challenged the validity of laws which allow detention without trial, but blanket bans on meetings and those type of things. Of course, with the advent of things changing in 1992, the character of the firm also started to change, and we linked up with another firm. And from then on, the firm did commercial work, property work. It had quite a large component doing conveyancing. And those type of issues, contractual work and those type of issues that then started to develop. I had also, by that time, did quite a bit of labor law, but I must confess that the labor law practice never really took off. I was always involved more in other type of matters as the firm grew. But it was quite a mixed bag of matters that we dealt with. I must say that my interest and my speciality remained in the area of administrative law. Of course, representing a number of municipalities in the areas, and then also certain government departments as well. So it was the procurement law, administrative law, those type of cases mainly at the time.
Okay. And then as a judge of the High Court, in what branches of law have you written judgments?
Yes. In a varied field, Chief Justice, if you just allow me to explain that because of the unique layout of the...
I'm sorry. I wouldn't like you to explain it. I would like you to simply say, I've written judgments in commercial law, patent law, insurance law, whatever law. So I just want the branches of law so that the commissioners can see the breadth of your experience.
Yes. I was just going to explain in all the areas in the Eastern Cape courts and the certain divisions, the type of matters that you do, but I
don't want that. I just want you to tell me the branches of law.
No, I accept that. Of course, there's criminal, the criminal law. There's a constitutional law. I wrote 2 judgments where the validity of provincial laws were challenged. There's procurement law, property law, other areas. When I sit in Kabeja, there's usually quite a bit of commercial law, contractual law, the straightforward liquidations that we have to do. And those are really the type of matters where I have written most of my judgments, Chief Justice.
Yes, and you have acted in the Supreme Court of Appeal as well.
Yes, I did.
And did your acting stints in the Supreme Court of Appeal expose you to other branches of law to which you have not been exposed at the High Court level?
Yes, yes, it did, Chief Justice.
And tell us which branches of law it exposed you to.
Yeah, in particular in the field of tax law, mostly involving duties, import duties. There's a number of matters I had occasion to write a judgment on that particular issue. Of course, there was procurement law as well, but in a different context. I had occasion to sit on matters involving the competency of the JSE to impose obligation on companies to restate certain information on on their financial statements. I'm just thinking now. I have recently had occasion to write a judgment which involved criminal law, which surprisingly enough, having done quite a bit of criminal cases in the High Court, it's a matter that I never had to deal with, but that involved the question of reservation of questions of law, in which I wrote a judgment that was, I think, just about delivered 2 weeks ago. Yes.
Yes, and may I now refer you to your questionnaire, question number 16.
Question number 16.
Yes.
Yes. Yes, I've got that, Chief Justice.
Question number 16 says, list the cases where you have written the judgment not more than 10, which you regard as being the most significant and why.
Yes.
And you have referred us to Annexure A,
Yes.
which appears on paginated page 13A, capital letter A. Are you there?
I've got it, yes, Chief Justice.
Yes, the first case there, SA versus JHA, it's a Supreme Court of Appeals judgment. But when I look at the narration that comes under it, it seems more like what you will get in the heading of a judgment in the law report than you telling the commission why you regarded the case as significant.
Yes. Yes, I did that for the sake of brevity, Chief Justice, and maybe I could have been more descriptive. But I thought that because I also annexed that judgment that it would capture the essence of why I thought it was an important case in the context of other cases that I dealt with.
Yes, I think you adopt the same approach.
Yes.
With most, if not all of them.
Yes.
For example, number 3, it's where you're supposed to say why you regard it as significant. You say pension fund rules, amendment of rule governing withdrawal benefits so as to reduce such benefits, amended rule retroactive effect, validity of rule, held that the rule was of retroactive application and that the presumption retroactivity against retroactivity was rebutted by the funds, clear intention. So that's the approach you adopted, but you concede that it doesn't make it clear as one would have preferred to say, no, this is the reason why you regard it as important.
No, I accept that. I could have been more explicit in my reasons and added a bit more description.
Yeah.
But as I say, I just thought for the sake of brevity, but I take the point, Chief Justice.
Yes, thank you. Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, Chief Justice, the Constitution allocates and delineate the constitutional responsibilities and obligations of the 3 spheres of government, being legislature, the judiciary, and the executive. And the Constitution provides that the one sphere should not encroach or impose on the sphere of the other sphere of government. The issue becomes particularly pertinent when it comes to the judiciary, because it's the judiciary that has to declare the law, and it is often the judiciary that is placed in this dilemma as to whether or not it should it should grant an order that could possibly encroach on the area of particular of the executive, for example. So, but that is basically the principle. It is essentially deference for the constitutional responsibility and power of another sphere of government.
And rule of law?
The rule of law is one of the founding principles of the Constitution, Chief Justice. It is mentioned in, I think, Section 1 of the Constitution. It is a principle, it's almost a universal principle that says that everybody is subject to the law, and in particular, including organs of state as well, that they must be held to account for acting in terms of the powers that have been granted to them in terms of the Constitution.
Thank you, President of the SA.
Thank you, Chief Justice. Good afternoon, Justice Smith.
Good afternoon, Madam President.
You have acted at the SCA for about 4 terms, am I correct, or is it more?
Yes, I think it would be more. Now, I think this is my 5th term, Madam President.
Oh, okay.
But it wasn't continuous. As you know, I acted, I think, last in
Yes.
2023, and then I again this year from February been acting in the Supreme Court of Appeal.
Yes. How was the transition from being a judge of the High Court to being a justice of the Supreme Court of Appeal?
Initially, the learning curve was quite steep. I think what made it worse for me is that unfortunately the first 2 stints, 2 terms in the Constitution was during the COVID period lockdown. It was during hard lockdown, and we did everything virtually. So I couldn't have the benefit of interacting with my colleagues. And then fortunately, there was a bit of a lifting. So during the 3rd term, I went and came to Bloemfontein and then was able to interact. But it was challenging because it is very different from how we work at the High Court. The way in which judgments are being written in the Supreme Court of Appeal is different. The fact that there are invariably 4 other colleagues that you have to work with and get their buy-in into your way of thinking, and also make contributions to their judgments as well. So it was initially, but I managed to find my feet quite quickly, and speaking under correction, I was able to deliver all my judgments within time. And I don't think there was any complaint of any delays on the part of the judgments. I was also able to prepare for the hearings, to read the records and come prepared and able to make a contribution both in court in terms of putting questions to counsel in order to elucidate issues further and to make issues clearer, to understand their arguments. And during the post-hearing conference, I was able to make contribution and made some input on the judgments of others as well. Although these were, to be honest, mostly sometimes cosmetic and sometimes just a suggestion that maybe we can deal with this case as well. But as I say, in the end, towards the end of the 3rd term, I felt more comfortable, and I felt that I was beginning to enjoy myself, and there was a bit less stress. Yeah.
Yes, but you'd agree that in these 5 terms that you have acted there, that the one thing that is consistent there is the enormous workload. I mean, the pace is just relentless. You agree?
Yes.
Yes.
Yes, certainly, Madam President. You'd recall that in February, I think I was given, I don't want to exaggerate, but it was about 2 or 3 weeks notice of the acting, and I think I got the records about 2 weeks before the time. I was at the time engaged in a criminal trial in Grahamstown, and you quite graciously agreed to allow me to finish that trial before I started my acting appointment. But in the end, it meant that there was tremendous pressure on me to prepare myself, to read all the records, to prepare myself. And then I had 3 judgments to write in that, in the first term as well. So the workload is daunting. The pressure, as you say, is relentless, and one has to just make sure that you stay up to date. Otherwise, you're going to sink if you don't swim.
Yes. So you agree that a strong work ethic is crucial?
Absolutely.
Yes. Now, you are probably aware that the Supreme Court of Appeal has lost a lot of experienced judges. Some have retired, others have been elevated to other courts, and there is therefore a need to complement the existing expertise with strong candidates, if I can put it that way.
Yes.
Candidates who will be able to hit the ground running and not rely on any kind of hand holding, be able to work independently and basically be self-reliant.
Yes, I realized that. One of the senior judges took retirement during my first stint, and I know that the Supreme Court of Appeal has lost a lot of experienced judges, and it is imperative that there are people who are able to, whoever comes in must be able to, as you say, hit the ground running. And then, yeah, I understand that statement,
Yes.
Madam President.
I note that you have been a judge for 14 years now, and according to my calculation, your experience prior to appointment to the bench is about 28 years, which gives you about 42 years experience in the legal field. Is
Yes.
that a fair assessment?
It is a fair assessment, Madam President.
Yes. So what are special attributes that make you the right candidate to be considered for appointment at the Supreme Court of Appeal? What will you bring into the table? What will you contribute to the skill set and the experience that is required there?
Yes. Madam President, I think I've shown that I work hard. I make sure that my judgments are ready for circulation as soon as possible. One of the judgment was literally a week after the hearing, the judgment was circulated. And it was during the time when, as you know, we've struggled with getting any type of assistance from the researchers. So we had to do research ourselves, a huge challenge. And I've been able to do it. I've made contributions, as I said. I do think that my background in law, in particular in constitutional administrative law, it enables me. I'm not going to say that I can walk into any type of case without preparation, but it has enabled me to discern in any type of matter, whatever you call it, if you call it tax matter or any other type of matter that I just cannot think, any branch of the law, that I am able to discern the legal principles that are applicable in that type of matter, and that will have to be resolved in order to dispose of the list between the parties. So I've been able to understand issues in matters that I have not dealt with before. I've mentioned, for example, issue relating to a dispute between the JSE and a listed company. I've never dealt with that in the Eastern Cape. But one gets to the point where you can go in and you identify the legal issues that lie at the core of those, because often you find that you deal with terminology, strange terminology, but when you break it down, it comes down to certain legal issues, but it's hard work to get there. But I think I'm a team player. I get along well with my colleagues. It's been like that in the Eastern Cape, and I think I don't expect that you would have received any complaints from any of my colleagues about my inability to work with them or to defer to them, to listen to them and interact properly and professionally with them. So that is what I bring and I think I have shown with this first term now, having such a short period of time to prepare myself, that I've shown that I can hit the ground running, as you put it. So I think I'm ready, but it's up to you to decide whether that is in fact the situation.
Yes, you mean the JSC, not me personally.
Yes.
Thank you, Justice
I mean
Smith.
collectively, Madam President.
Yes. Thank you, Justice Smith. Thank you, Chief Justice.
Thank you. Minister?
I've got no question, Chief Justice.
Thank you, Minister. Commissioner Marmoha?
Thank you very much, Chief Justice. Good afternoon, Judge Smith.
Good afternoon, Prof. How are you?
I'm fine, thanks. And you? I have a question for you, but for some reason, the judgment that I wanted to talk to you about, which is part of your panel, for some,
Yes.
your bundle, but for some reason I cannot locate it. It's DVT versus BMT. It was a domestic violence case.
Yes.
It appears for the first time in page 14 of your bundle.
Yes.
I tried to locate it in the rest of your bundle, but for some reason I cannot locate it there.
Yes.
But I located it somewhere else. I'm not really sure if on your bundle you can be able to locate it. This was a case that dealt with domestic violence.
Yes.
And I understand that you don't have the act in front of you.
Yes.
And perhaps the question that I want to ask you, it might be somewhat unfair. Because and I think I agree with everything that you did in the judgment, except what I'm going to put to you now. In paragraph 10 of that judgment, you quote from, and I assume this is the Domestic Violence Act.
Yes.
You quote from the Domestic Violence Act, and you define emotional, verbal, and psychological abuse. And in the quoted part where you define it, A, you say repeated insults, then B, you say repeated threats, then C, you say repeated exhibition. I'm not sure if I have the old version of the act or not, because what I see from the version that I have, it doesn't seem that the word repeated appears there. So it was just a little bit something that was concerning for me, and I might be the one who's wrong. And it becomes unfair because you don't have the act.
No,
with you.
I don't
But
have
let me
it.
ask you a general question nonetheless, because that for me it's concerning as to where do you get the word repeated. Can a person be found to have committed an act of domestic violence which is not repetitive, that happened only once? Because when one looks at how the Domestic Violence Act works and how the Harassment Act, actually the Prohibition of Harassment Act works, where the courts have repeatedly said that yes, there might be a repetitive sort of conduct, but a single event can be so serious that even on a single event, a person can actually be found to have committed an act of harassment.
Yes.
So I just want to transfer everything into the Domestic Violence Act. Is it possible for a person to be found to have committed an act of domestic violence so that the remedies that are provided by this act can be applicable, or the complainant can actually benefit from them?
Yeah, not having the benefit of having the act here, I would say undoubtedly so. I think the issue of repetition, and perhaps where an applicant may have to show repetition, is that certain conduct isolated incidents of conduct which may in itself not appear to be aimed at abuse or appear to be violent. If repeated, it can. We know that, you can walk past the person and touch him or her on the shoulder, and then it would be nothing. But if you do it 3, 4 times, then it is starting to look like you've got another agenda. So I would say certainly, and a single act can, and in most cases, a single act would constitute domestic violence. But the more innocuous, seemingly innocuous acts could also, if repeated, uh, amount to harassment or domestic violence. I think that is essentially what I was trying to say. And it's in the context of that case where these SMS messages, that if you take the one in isolation, you think, this is nothing. But 2, 3, or 4 of them, then you're beginning to see a pattern, and then this is now harassment. So that is what happened in that case.
No, thank you very much, Judge. But my parting shot would be, if you do get a chance, please look at this repeated thing, because if I'm wrong, then everything is fine. But if I'm right, that word is not in the definition, then that means this decision might have created some challenges. But please look at it when you
Yes,
when you
now
have a chance.
I shall do that, and perhaps at the next conference where we speak again, I shall let you know, Prof.
No, thank you very much, Smith. Thank you very much, CG.
I wonder what Judge Smith is eyeing for next time.
No, and I think a few weeks ago we were speakers at the same conference.
I thought you said in the same forum.
Hopefully not, Chief Justice.
There is a position we hope to fill tomorrow in the SCA.
Yes.
Commissioner Nguwaitobi.
Thank you, Chief Justice. Judge Smith, it's just to get some clarity. I have it from your CV that you acted at the SCA between October 2021 and May 2022. Is that correct?
Yes, I think.
And then you acted again between February 2024 and March 2024.
Yes, and now I'm acting at the moment, Mr. Nguwaitobi.
Now, in that period, which is roughly 10 months, you produced 4 judgments.
Yes, I think that excludes the 3 judgments that I wrote in the last term. I gave one of the judgments I submitted. There are 2 others which came after the deadline. So I wrote 3 judgments in the last term.
Yeah, I'm just talking about that period of 10 months.
Yes.
Of October 2021 to
Yes.
March 2024. That's 4 judgments.
Yes.
All right. Yeah, that's fine. Thank you.
Thank you.
Thank you. I don't see any other hand, and I've not been told there's any hand on the virtual platform. Thank you very much. We have come to the end of this interview. Thank you very much, Judge Smith. You are now excused.
Thank you, Chief Justice, and all the commissioners. Thank you very much.
Thank you. Good afternoon, Judge Unterhalter.
Good afternoon.
How are you this afternoon?
I'm very well. How are you, Chief Justice?
No, I'm all right. Thank you for once again availing yourself for consideration for appointment to the Supreme Court of Appeal. I'm not going to repeat the rules that we follow in these interviews because you know them so well by now.
Indeed.
So I will ask you questions and then I will allow the president of the SCA and then after the minister and the commissioners. We will all be trying to just satisfy ourselves to what extent you meet the selection criteria that we have adopted. But you have been here, what is the fourth time now?
I think so, yes. I think that's right.
Yes, so we know you quite well, but we still have a lot of information on you that you have supplied in the questionnaire and other documents. So we won't try and cover everything that's in the documents because everybody is deemed to have read what's in the documents. We'll just focus on certain matters on which we would like to hear you. Your academic qualifications are BA, LLB, MA, and BCL. Is that correct?
That's correct.
Yes, and the universities are Cambridge, Wits, Oxford, and Cambridge.
Yes, that's right.
That's right. And you were in the academia before you started practicing as an advocate, is that right? And when you were practicing, you were also partly teaching as well.
Yes, I had a stint in academia, and then whilst I was practicing, I also was an academic. And then I went into academic. I then became the head of CALS, and then I went back into practice. But I continued my academic career whilst I was at the bar.
Yes. If I remember correctly from last time you were here, I think we said you had practiced as an advocate for, is it 27 years? Or
27 years.
27 years, yes. And would you like to just share with the commissioners once again the different branches of law in which your practice was involved?
Yes, well, I had a spread of competences in my practice. I did a fair amount of commercial law, I did a lot of public law, and I also did numbers of more specialized forms of regulatory law, particularly competition law and aspects of trade law. So I also had some dealings with intellectual property law. So that, in general terms, I suppose, was my practice.
Yes. And during the time when you were practicing and teaching, you published numerous articles which are listed in the questionnaire and the annexures, and you also got involved in writing of some books as well, isn't it?
Yes, it was part of my academic work. It required academic writing, and I've listed those publications.
And there's a long list in the documents, And during that period of 27 years in practice, is it true that there were, is it over 300 reported cases in which you had appeared in the various courts?
I haven't done a counting, but I appeared many times in many of our courts, and there were many reported judgments.
Yes, I'm sure. I'm sorry for that. Well, I remember having a look at the last interview. The list was certainly not less than 100.
No, I think it was in excess of that.
Yeah.
So yes, there were hundreds, I think.
Yeah, yeah. And you were then appointed as a judge of the High Court, is it about 6 years ago?
Yes, in 2018. I commenced in 2018.
Yes, yes. And over the period, you have written numerous reported judgments as well, is that correct?
Yes, I think a little in excess of 50 or something more, I think, yes.
Yes. And would you like to share with the commissioners the different branches of law in which you have written judgments as a judge of the High Court?
Well, I've tried to list some of the more important ones in my curriculum vitae, but they include judgments in commercial law, in various aspects of public law. There are certain judgments on intellectual property law. So there are some criminal appeal matters as well. So a fair range of the kinds of judgments that one gets, as well as the law of delict and the law of contract. The High Court is a court of general jurisdiction, and so one gets cases from many areas of the law, and that's part of the challenge for being there. So yes, those are some of the areas.
But don't do yourself a disservice, because the purpose of the question is just for you to show the breadth of your experience. So there is insurance law, there is patent law, there is trademark law, there is customary law, and commission law. Just feel free to mention them.
Yes, well, I think that there are various areas in the law of contract, various areas in the law of delict, in particular, numbers of reported judgments concerning some of the more conceptually difficult parts of the law of delict around pure economic loss and how to think about it and its relationship to the law of contract. There's company law, where I wrote a long judgment in the Steinhoff case about that particular cause of action. There have been numbers of cases in public law and constitutional law. I had a long practice in constitutional law as our constitution developed, and I've sought to take some of that up in my judicial work. So I think across quite a large range of public and private law areas, you can see that I have offered my views in numbers of judgments.
And when you acted in the Supreme Court of Appeal, are there any branches of law that you got exposed to which you had not been exposed at High Court level?
Well, I think one of the things about the Supreme Court of Appeal, and certainly that's where I got exposure to, in particular, intellectual property law, which I'd had a little bit of exposure to in the High Court, but much more of it in the Supreme Court of Appeal, and tax law as well, which, forms part of the steady diet of the Supreme Court of Appeal, as well as, of course, the many public law areas that come, some questions on liquidations and insolvency. So it certainly broadens the scope of the work that I've done.
But you also acted in the Constitutional Court for 2 terms or so, is that correct?
Yes, that's correct.
Yes. Would you like just to share with the commissioners your understanding of the doctrine of the separation of powers?
Yes, certainly. The doctrine has 2 basic components to it. The first is that the 3 spheres of government are separate. And the second aspect of the doctrine is that the separation, however, also involves checks and balances, which is why it's a doctrine that has seemingly opposed component parts to it. Every constitution has its own doctrine of the separation of powers, and precisely how these components interact with each other is really an ongoing form of analysis. As our courts have said, South Africa has a distinctive doctrine of the separation of powers, but it manifests itself in different ways. One of the features that is obvious about the Constitution is that although it entails checks and balances, it also entails obligations of cooperation. And so in our constitutional order, it's addedly complicated because separation actually also requires cooperation. And so we have a somewhat unique blend of constitutional features that makes up our separation of powers.
Yes, and then the rule of law.
Well, the rule of law is a founding value of our Constitution. I mean, currently in many debates, the rule of law seems to be able to encompass almost everything that anyone ever seems to want to say about law. But if I could distill perhaps three things that I think are fundamental about the concept of the rule of law. The first is the notion of equality before the law. The second is the supremacy of law, and in our case, the supremacy of the Constitution. And the third is the independence of the judiciary. Now, some of these concepts obviously, again, interact with each other, but I think a constitution that lacks those essential features is a diminished form of a constitutional expression of the rule of law.
Thank you. President of the SCA.
Thank you very much. Good afternoon, Justice Unterhout.
Good afternoon, President.
Yes, you have had a number of acting stints at the Supreme Court of Appeal.
Yes.
How did you find the environment overall throughout, from your first stint up to the last? I think your last one was in November, right?
Yes, that's correct.
Yes.
Well, obviously, in joining and coming into act in a new court, there are many things to learn, both about how the court works and what are the ways in which colleagues engage one another in that court. But I think that I relatively quickly became accustomed to the ways of the Supreme Court of Appeal, and as time has gone on, because I think I've now had, about 10 acting stints in the Supreme Court of Appeal, I think I know its ways reasonably well. I've come to greatly appreciate the value of my colleagues there and the manner in which the court operates and works. And I've sought to work hard and be a productive member of the court. And so I would say that in general terms has been my experience.
Yes, you made reference to colleagues, so I'll ask you this question. Do you think that collegiality is an important aspect of being a justice of the Supreme Court of Appeal, given the fact that we only decide our cases sitting in panels, sometimes 3, sometimes 5, but you are never alone? So do you think that collegiality is important in that sense?
I think it's indispensable, both in the formal sense that in order to get the work done, one has to and must engage with one's colleagues for the purposes of preparing for hearing and then deciding cases. But collegiality is just as important in the more informal ways in which colleagues must respect each other, be open to persuasion by one another, and be able to assist each other when the need arises. And my experience of the Supreme Court of Appeal has been that is a court marked by its collegiality, both formal and informal. So it is, I would say, indispensable.
Yes. Have you ever had any issues with colleagues in any way in your 10 acting stints?
I've never had any problems with any of my colleagues, none that have ever been referred to me or none that they've ever raised with me. I've always endeavored to have a very open, engaging and friendly relationship with my colleagues, to help where I can and to be helped when I've needed assistance. There have been occasions where a colleague suffered some ill health, and I stepped in to be a member of that panel. And another occasion when a colleague was overburdened with many judgments, and I took on an extra judgment to assist. These are just examples of what all members of a court do to assist one another to make the court work. So I've never had any difficulty with collegial engagement, to which I attach a high value.
Have you at any stage delayed your own judgment or contributed to the delay of another colleague's, the handing down of another colleague's judgment, for example, by not submitting your inputs timeously or delaying to accept suggestions from other colleagues?
No, I think my record is that I turn in my judgments promptly. I try to adhere to the norm that I understood when I came to act in the Supreme Court of Appeal, that one tries one's level best to get one's judgments out by the end of term. That's not always possible for a variety of reasons. But I do think that it's important to try and adhere wherever possible to time limits in respect of the production of judgments. There are, one has to recognize occasions where, because judgments are the product of persuasion and engagement, sometimes colleagues have opposed views at one point in time, and then it takes some time to think about these matters and bring ideas together. And sometimes a dissenting judgment can turn into a collaborative judgment with a colleague. Those sorts of instances can sometimes take longer, and I can think of two instances where I've been party, I haven't been the main scribe, but I've ended up as party to a concurring judgment, a joint effort, where those judgments took a little bit longer, but it was a process of engagement to get to what we thought was ultimately the best answer.
Yes. So you are obviously aware that the Supreme Court of Appeal has experienced a loss of expertise and experience due to the retirement of judges and elevation to other courts, and amongst other things, hence the existence of these three posts. So would you agree that given the amount of experience that is lost, it would be crucial to replace such colleagues with equally experienced colleagues, both in terms of judicial experience and overall skill set?
I think it is critical. I mean, one of the things that one benefits from enormously in coming into a court like the Supreme Court of Appeal is the guidance and assistance of senior colleagues. That is just critical to the way in which courts work. When one loses some of that experience, one needs to try and supplement it as best one can. And so, yes, I think experience and expertise is at a premium for the court, and it's good working.
Yes, I'm just curious, looking at your CV, as I noted that you have been a lecturer for quite some time. In fact, up until now, you are still a part-time lecturer at the University of Cape Town, is that correct?
That's correct, yes.
Yes, which courses did you lecture on over the years?
Well, over the years, I've taught in quite a lot of different areas, but I started off life in jurisprudence, but then I've taught in public law. I've spent a lot of time teaching in competition law, international trade, and various other aspects of public law. So, and I currently assist in the master's program in competition law. So I've covered a number of areas.
Yes, I note that your overall experience as a permanent judge and your experience prior to elevation to the bench spans around 40 years or so. Is that a fair estimate?
It's aging me enormously, but it is true. I think it comes out at 34, but still, it's a lot.
Yeah, okay. Oh, well, prior to the bench is 34, plus the bench, 6 years total,
Indeed.
40 years. So, Justice Unterhalter, what would you say is the special attribute that you will bring to the table at the Supreme Court of Appeal in terms of complementing the existing expertise at that court?
Well, I think I've been privileged in my practice to have had a very well-rounded exposure both to many aspects of commercial law and many aspects of public law. And while the variety of cases that come to the SCA is such that no one can possibly have expertise in all of these matters, and I recognize areas where I don't have much experience from my days in practice, I do think that I have a lot of experience across many areas of law that are of relevance to the Supreme Court of Appeal. And I think that that really does help, because although you can work up a case when you don't have experience in the area, knowledge of the area, it obviously takes more time to do so. And if you know your way around the doctrine of restraint of trade and the like, you can just get to the issues more quickly, and that means that you've got a bit more time to deal with your workload and work efficiently and get to the issues and hopefully assist others in the court as well as in respect of your own work. So I think that's one of the things I hope to contribute. The second is that I think in the course of working in the SCA and in the Constitutional Court, as also in the High Court, I work hard and quickly to try and produce results, and I'd continue to try and do that in the SCA.
Thank you. Thank you, Justice Winterhalter. Thank you, Chief Justice.
Minister?
I've got no question, CJ.
Thank you, Minister. Commissioner Marmohai.
Thank you very much, CJ. Good evening, Judge.
Good evening, Professor.
In your introductory remarks, you referred to, or you said something that is quite true, that the law of delict it is one of those areas that are a little bit problematic. And I want to use one of your judgments to ask you just a general proposition. It is the judgment that is found in page 362 of the bundle.
Perhaps you just give me the name of the case and now.
It is Van der Bijl.
Oh, yes, yes. I know the case.
Van der Bijl versus Featherbrook Estate. Yes. In paragraph 17, you say the law of delict has been principally concerned with liability for injury to persons and property. In other words, this is where you start dealing with the elements of the law of delict. I have recently found out that the elements of delict are not as straightforward as we teach them in the classroom, like for LLB. That there is this somewhat overlap between wrongfulness and negligence to some extent.
Yes.
I just want to hear your view on that possible conflation between the two elements and the role that they play in trying to make us understand liability in delict.
Well, I was very fortunate to be taught delict by Professor Boberg, and I was always told that the cardinal sin of that you could commit in the law of delict was to confuse negligence and wrongfulness. So I'll try and be a good disciple of the person who taught me the law of delict. But I think essentially, wrongfulness is concerned with various ways in which we might seek to impose obligations upon parties for civil wrongs. And negligence is a mediating doctrine, which says, well, we are not going to, except in very rare circumstances, allow our conception of what is wrong from the perspective of civil liability to be unmitigated by some concept of foresight. And I say other than in a few instances, because there are certain instances of strict liability. But I do understand that however one casts this language, the notion of duty of care and how that duty manifests itself, for example, in cases of pure economic loss and the like, which is what the Van der Bijl case was concerned with, so often seem to shade into kind of moral judgments around, well, if they could foresee this harm, why shouldn't I impose liability? And I think that's sometimes where these crossovers come about. And even though I think there's conceptual separation, I can see in terms of one's sort of thinking around whether there should be liability or not, but sometimes these concepts seem to bleed into each other.
No, you answered me. Thank you very much. Thank you very much, CJ.
Thank you very much. Commissioner Mangena.
Thank you, Chief Justice. Good afternoon,
Good afternoon,
Judge
Commissioner.
Onthalter. My question relates to the issues that were raised by Professor Dendi.
Yes, yes.
And we were told that you were offered an opportunity to deal with that aspect, and you indicated that you will deal with it in this hearing. The Chief Justice asked you a question relating to the rule of law.
Yes.
And you answered that the rule of law is a founding value of the Constitution.
Yes.
And you would also know that part of the rule of law is that it establishes certainty and predictability amongst litigants and members of the public. With that said, why did you find yourself not bound by a judgment of the higher court, the Supreme Court of Appeal, in this case of De Bruin versus Steno?
Yes. Well, I've of course read what Mr. Dendi had to say in his complaint. But I'm afraid I can't agree with the basis upon which he makes the complaint, because I reread very carefully what I said in De Bruin, and I reread very carefully what the Supreme Court of Appeal said in the Children's Resources Trust case. And if one pays close regard to paragraphs 38 and 39 of the Children's Trust, two things seem to be very clear. The first is that the notion of what is a tribal issue for the purposes of certifying a class action include the concept of an exception. So what I had found in De Bruin is that in order to determine what is a tribal issue, one could, as a court considering certification, determine whether there was a good cause of action as a matter of law, and that there was no reason why the certification court shouldn't decide that matter. And if it did decide that there was no cause of action in law, it seemed very difficult to see the basis upon which certification could be granted. Now, when one has regard to the Children's Resources Trust, and in particular paragraph 38, the Supreme Court of Appeal essentially said the same thing. And not only, I'm afraid, I think contrary to Mr. Dendi's view about this, what the Supreme Court of Appeal said is that often the certification court will have more information than a court would have on exception, because there is evidence as well as a draft set of pleadings. It's true that in paragraph 39, the Supreme Court of Appeal said, well, certification doesn't mean that an exception can't be raised later, but it didn't mean by that that exception proceeding or something akin to exception would not be relevant for the purposes of determining a certification. So I think I spent a fair amount of time in De Bruin thinking very carefully about what the Supreme Court of Appeal had said, and indeed what the Constitutional Court had said in Makadam, and try to give my best interpretation in fidelity to the Supreme Court of Appeal, not in opposition to it. Now, I may have interpreted wrongly, but what I was trying to do was to be faithful to the courts, not to be oppositional to them. And if I could just say one final thing, because I have obviously given this some thought. If the Commission has a look at what I had to say in the Capitec judgment, in that case I spend a good deal of time explaining why our law has changed in respect of the parallel evidence rule and how we interpret contracts, and showing fidelity, again, to the Constitutional Court in the manner in which extrinsic evidence becomes admissible for the purposes of showing what the purposes and context of a judgment should be, even though it's an expansion of what would ordinarily have been the case. So I think that the criticism that Mr. Dendi has offered is one I just can't agree with on my own analysis of the matter.
So in brief, you support the the correctness of the study cases.
Absolutely.
Yes, and you've got authority to back you, because in another case, TWK Agriculture Holdings
Yes.
versus Wachfeld, you did come out strongly in support of that principle of stare decisis on paragraph 20 of that judgment.
Yes, in that case, I reflected on what it was 100 years of authority in the Supreme Court of Appeal, starting with Innes CJ in the Blauwklippen case. And I said that essentially there were good reasons to continue to follow what had been said in that court for 100 years. Not everyone agrees with me, but that's what I said.
Thank you. Chief Justice, with your indulgence, this is my last and final question. It relates to the costs in Steenhof.
Yes.
Right, it's a long judgment, but right at the end, you dealt with the question of costs in a single paragraph. And you predicated the funding, the litigation model. And I couldn't understand why you ordered people that you found to be poor litigants to pay costs.
I'm afraid you find me without recollection as to precisely what my reasoning was in a very long judgment around costs. I'd probably have to go and look at how I came to that. I think, and this is only from recollection, because unless we spend some time, I'm not going to be able to immediately remember. But one of the features of that case was that this was funded class action litigation. One of the controversies in the case was precisely who the funders were and how they were funding the litigation. And I don't say that that was my reasoning, but it occurs to me that this wasn't seeking to impose on poor people who couldn't afford litigation costs, but it may well have been that because it was funded litigation. Class actions become our business in the world, sometimes for good and sometimes not. And this was a funded piece of class litigation.
Thank you, Chief Justice.
Thank you. Commissioner Singh. After Commissioner Singh, I've got Commissioner Makwanishe and then Commissioner Dodovu. Thank you. Commissioner Singh.
Thank you very much, Chief Justice, and good evening, Judge Untalta. I'm on the virtual platform this evening.
Good evening.
I trust you can hear me. Judge, during the 6th term of Parliament where I serve, we have seen 2 judges removed from their posts, which was the first time in our country's democratic history that this has happened. And consequently, public trust in the judiciary has suffered. How do you propose public trust in our own judicial system be restored? And here I also want to refer to the letter of objection where there were some allegations from Mr. Eric Akucho. If you can just tie those 2 in and then give us your view on that. Thank you, Judge.
Well, I think there are 2 ways in which...
Just interject on this, because, we get taken to task precisely because of this issue. The objection of Mr. Ochuko was considered by the JSC in the last interview. It was also considered at the JCC. On both occasions, it was decided by the JSC to reject it. And it was also decided not to put to the candidate. So this is the kind of thing where we get taken to task because we are not following our own rules.
Yeah. Commissioner Singh, you get reminded.
I heard that from the Commissioner, Chief Justice, but I believe, it will not be a problem if Judge Ontalta has to repeat, his complete denial of the allegations. I think that's good for the public as well.
Well,
But I just want, how do you
if we have
propose
agreed that
public-
we won't proceed with it, if we have agreed, I think we should stick to that agreement. Commissioner Singh?
Well, I'm not aware of such agreement, but if you say so, Chief Justice, then
Well,
I will
Commissioner Ngwetobi just reminded us, or did I misunderstand you, Commissioner Ngwetobi?
No, you didn't, Chief Justice. We
Yes.
debated Mr. Achuko's complaint in full.
Yes, yes.
In October 2023.
Yes.
And we decided that it had no basis, it would not be put to the candidate.
Yeah.
He then complained to the JCC. Justice Meyer delivered a judgment rejecting the complaint as unfounded.
Yeah.
On this occasion, we again decided at the objections committee that the complaint had no merit.
Yes. No, I think
It's completely unfair to put to this candidate.
I think we don't proceed with it, Commissioner Singh.
Thank you. Then you'll answer the first question, but I'll take the matter up later in discussions, Chief Justice.
Okay.
Yes, on the question of trust in the judiciary, obviously it's a vital matter for the public. I think the way in which confidence in the judiciary is manifested is really threefold. The first is how are litigants treated in court and their representatives? Are they given fair hearings? They may be rigorous, but their cases are heard, and the judiciary is plainly on top of the materials and able to deal with the cases that come before them in a fair and rigorous way. That's the first thing. The second is that judgments are rendered in a well-reasoned fashion, particularly if a litigant has lost a case. They will be unhappy, but at least they should have the comfort of knowing that their case was properly considered, that the reasoning is sustainable, and that if they are still unhappy, there are places for them to go for other courts to have a look at it. And the third, of course, is when judgments come out. It's very important that the judiciary produce these judgments in reasonable time, so that we don't have a situation where people have to wait for years and years and years to have their matters disposed of at the courts. We achieve some of this some of the time, and we must always strive to try and achieve all of it as best we can.
Well, thank you. Would you agree, Judge, that confidence in the judiciary has been eroded because of these two historic findings or decisions by Parliament and the JCC?
Well, it's always very unfortunate that that these things should happen, but I believe the public has confidence in the judiciary as an institution. It's not a question of particular judges. It's how does the institution perform, and that is the cumulative effect of what I think more than 200 judges do every day, every month, and every year. And it's the cumulative force of that that contributes to what I think is still wide regard for the judiciary as an independent institution that has done considerably more good than harm in the last 30 years of our democratic order.
Well, thank you very much. Thank you, Chief Justice.
Thank you. Commissioner Makwanesh.
Well, thank you, Chief Justice. Good afternoon, Judge Budenhalter.
Good afternoon.
How will the years that you spent between 2006 and 2013 in the World Trade Organization be of help to the work of the Supreme Court of Appeal if you were to be appointed?
I'm sorry, I'm having a little bit of difficulty hearing, but you were asking whether what I contributed between 2006.
No, I was saying that the experience that you have been able to gather
Yes.
at the WTO.
Yes.
How do you think it will be of help?
Oh, I see. I'm sorry, I didn't hear the question. Yes. Well, I think there are really two ways in which that might be so. The first is that the appellate body is also an appellate let me not use the word court because that is controversial, but it's an appellate tribunal within the structure of the WTO. And so it has many of the same features as an appellate court. And I served there for many years, and so I had gained experience of what it means to operate in an appellate court and how courts of that kind operate. And the second is that although trade law is a specialized branch of international economic law, there are many principles of international law that suffuse international trade law. And since our Constitution gives a special privilege to the importance of international law, I think many of those principles are ones that I'm very familiar with and would help not only when there's a case directly involving international law, but also because of the regard our Constitution has for those principles and the benefit of understanding something, at least, of international law.
Thank you, CJ.
Thank you very much, Commissioner Dodovu. And on my list, that would be the last one. Commissioner Ngogatovu will be the next one. Commissioner Dodovu.
Thank you very much, CJ. Good evening, Justice.
Good evening.
As CJ prefaced his questions to you from the beginning, he said part of it was to say you came here several times to these interviews.
Yes.
What do you think that since the last interview that you were here and unsuccessful, what do you think are the improvements, better approaches that can persuade us to consider you this time around?
Well, I think you'll probably understand that after going through an interview process on a number of occasions, one has plenty of time to look back with hindsight at things and think about issues raised and so on, which I've obviously had occasion to do. And, you know, without going back through the issues that were raised with me, I think that part of this process is to understand what are the concerns of the Commission and how should one reflect on them, not in a hostile way, but simply to think about what these issues are and how they have arisen and what they mean. And I've done so, and if I may just let me mention one, which I think you may have raised with me last time we were here, which was the question of the error that I made in respect of the petition before the SCA and the Constitutional Court. We got into some very deep waters, and I'm sure I was a significant contributor to that. I recognize I made an error. I would much have wanted not to have made that error, and I would very much have wanted to have known that I was in a position where I previously heard the case by way of petition in the SCA, because then I could have referred the matter to my colleagues to tell them what the problem was, and we would hopefully have worked something out together. So it's in that spirit that I return to say, you know, this is a learning process, and I've certainly learned some things along the way.
I might just say, through you, Chief Justice, that for us, I think bygones is bygones. Whatever happened in the past is in the past, and we are here today. You applied, and we must give you a fresh opportunity. It cannot be double jeopardy. If that was the reason that we used to not appoint you, and I say if it was, it cannot be used this time around to consider your application. And you answered that you made some reflections about the past, and we are here. Let's move forward. Thank you, Chief Justice.
Thank you very much. Commissioner Ngogatovu.
Thank you, Chief Justice. Judge Unterhalter, I just want to get some clarifications. What I've got from your CV is that you've been on the bench since 2018. Is that correct?
That's correct.
Which month?
I started in January.
Oh, that's January 2018. So that's around 5 years.
Yes.
And in that period, what I've got is that you delivered, I've counted 55 judgments in total. 20, I'm talking about reported judgments,
Yes.
not because I'm sure you've done so many other judgments.
Yeah.
Now, out of that, 22 are as a judge of the Supreme Court of Appeal,
That's correct.
and 7 as a judge of the Constitutional Court, and then 3 as a judge of the Competition Appeal Court, and 22 as a judge of the High Court.
I think those numbers seem about right.
Yes, which I mean, is a remarkable output of something like 10 reported judgments, well, 12 reported judgments every year.
I'll let the commission be the judge of that.
Thank you, Chief Justice.
Thank you very much. There are no further hands. Thank you. We have come to the end of this interview. Judge Umteralta, once again, thank you for availing yourself. You are now excused.
Thank you, Chief Justice. Thank you, members of the commission.
Thank you. Good afternoon, Judge Wendell.
Good afternoon, Chief Justice.
How are you?
I'm very well, thank you. How are you?
All right. Have you been waiting for a long time?
It's been a long day, yes, but not so bad, thank you.
Yes. Okay. No, that's fine. Thank you very much for availing yourself for consideration for appointment to the SCA and for coming to this interview. We are going to ask you questions with a view to satisfying ourselves to what extent you are able to meet the selection criteria that have been adopted by this commission for the selection of candidates for appointment as judges at various levels. And you have given us a lot of information about yourself in the questionnaire and other documents here. And we are not going to try and cover all the information in our questions. We'll focus only on certain areas. We are all deemed to have read this information and we'll take it into account when we make our decision. But for purposes of the questions, we will just focus on certain areas. Is that only?
Thank you, Chief Justice.
I will ask you questions, and thereafter I will ask the President of the Supreme Court of Appeal to ask questions, then the Minister, and then other commissioners. I see that in terms of your academic qualifications, you hold a BUris and an LLB degree, is that correct?
That is correct.
And the BUris was from the University of Northwest and the LLB from UNISA, is that right?
That is correct.
Yes, and in terms of your career, you started as a prosecutor and later you were a magistrate up to 2013 when you got appointed as a judge of the High Court, is that correct?
That is correct.
And so you have been a judge of the High Court since 2013. That makes it, what, 11 years now?
11 years, yes.
Yes. As a magistrate, and you were a magistrate for 10 years as well, huh? 1993 to 2013, am I right?
It's actually 20 years.
Oh, I'm sorry, you are right, yeah. My arithmetic. Did you do civil work as a magistrate over those years?
Yes, I actually did exclusively civil work.
Yes.
When I arrived in Potchefstroom in 1995,
Yeah.
I've only done 2 years of criminal work as a magistrate.
Yeah.
And when I arrived there as a young 26-year-old, the civil magistrate has just retired. And
Yeah.
nobody wanted actually to do the civil work.
Yes.
And I was then given that opportunity.
Yes.
And for the next 20 years, I was a civil magistrate.
Yes. What kind of matters did you cover as a magistrate? Did you deal with?
It's basically this, not everything is the same as in the High Court, but a variety of matters. There is the university in Potchefstroom. There are several advocates practicing from Potchefstroom. So the quality of work that came to our division or to our court was of a high standard. For example, we had opposed motions on a Tuesday where we would deal with approximately 18 opposed matters and about 100 unopposed matters. So when I came to Johannesburg and I had to do the motion court, I could cope because it was more or less the same. Obviously, there are fields of law that we don't do in the magistrates' court, for example, tax law. So there are fields of law that I only encountered when I came to the High Court.
Yes, but I'm more interested in the nature of the civil cases that you had. I just want you to assist us to see what was the nature of the different matters that used to come before you, civil matters.
Well,
I don't know whether debt collection did come
yes,
before you.
Section 65
Section
High Court,
65.
yes.
Yeah.
Yes.
What else came before you?
So we dealt with ESTA matters, we dealt with PI matters, we dealt with contractual matters, delictual matters. I'm trying now to
Insurance?
think back. Yes?
Insurance law?
No, not insurance law really
okay.
in the magistrate court. Not that I can remember now.
What about collision of cars and insurance comes in?
Pardon?
Collision of cars and then insurance law comes in?
Yeah, that might be. Yeah, we had lots of them. Yes.
Okay.
And
right.
obviously family law, lots of family law matters in the district court and in the magistrates court.
Yes.
So I did domestic violence, maintenance, we did estates, civil
Yeah.
work. Yeah, so there's a variety of matters that I did.
Yes. And then you got appointed to the High Court in 2013.
Yes.
What branches of law did you come across at the High Court that you had not had access to in the magistrates' courts?
Well, for example, the one thing that I thought of today is the tax law. When I came to the High Court, I've never done a tax case in my life. So when I got the opportunity to go to the tax court, I found it quite exciting and interesting. And you'll see from my CV that I've delivered 7 written judgments on tax law. And when I acted in the SCA, I was allocated scribe duties in a tax matter. and that matter has been reported. So that is, for example, one of the fields of law that we don't encounter as in a magistrate's court.
Okay, so apart from tax law, what
Yes.
other branches of law have you delivered judgments on in the High Court?
In the High Court. Let's start with criminal law. So I've done criminal matters. That would be criminal law as well as criminal procedure. Also reviews, criminal reviews that we will get in terms of Rule 53. Then going to civil matters, I've dealt with intellectual matters, contract law, insurance law. I've dealt with matters dealing with PAIA, first of all, Access to Information Act and the Promotion of Administrative Justice Act. I've dealt with matters in the family law. I've not had the occasion to deal with equality court matters, but when I was a magistrate, I was a designated person in the Northwest Province that dealt with equality matters, where I've dealt with 16 equality trials. I'm trying not to think of other matters, but it's now escaping me. But a wide variety of different fields.
And administrative law, you have
Yes, sorry,
judgments?
yes, lots of administrative law matters, yes.
Yes. The trademark law?
Not had the occasion to do that, no.
And not patent law either?
No.
Okay. Customary law?
Yes, I have.
You have?
Yes.
Okay. And then you acted in the Supreme Court of Appeal?
Yes, I did.
And in the Supreme Court of Appeal, did your acting stint expose you to other branches of law that you had not had access to at High Court level?
I'm trying to think. I think I did one matter where I was a scribe in a servitude matter that I've not encountered in the High Court.
Yes.
But I've acted for 3 terms in the SCA. I've been allocated 6 judgments, 2 per term, and I've written obviously 6 written judgments, and 4 of them were reported.
Yes. And I would like now to refer you to your questionnaire, in particular question 16.
Is it this one? Yes, sorry.
It's on paginated page 10 of the bundle.
Yes.
If we look at the first case, or question 16 says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. Can you see that?
Yes, I do.
The first case you have put in there is J versus S, and you then write domestic violence, emotional abuse, repeated messages and phone calls constitute emotional abuse. It is an important judgment that gives guidance to the lower courts and is informative to the public.
Yes.
In terms of giving guidance to the lower courts, do you want to be specific in what way it gives guidance, or on what issue it gives guidance?
Because I was a magistrate, there are very few matters, reported matters dealing with domestic violence. So when I had the opportunity to write a judgment, I decided to make it very practical, because I know that lower courts seek guidance from higher courts. So in this matter, there was the issue of harassment. And I've explained the procedure, and I also gave some guidance to the lower courts as how one should go about, because in that matter, the magistrate excluded certain evidence. So I had to give guidance and say, but because we are dealing here with a specific procedure, it's a quasi-judicial procedure. what evidence should be actually considered when one needs to decide whether a final order should be granted. And I thought that was helpful to the lower courts.
Yes, and then in number two, case number two is City of Cape Town. You then say, finding that NERSA is an organ of state, failure to comply with the requirements of Section 41 of Constitution and provisions of Intergovernmental Relations Framework Act 13 of 2005. Then you say judicial overreach. Apart from saying you made a finding that NERSA is an organ of state, and then that there was also failure to comply with the requirements of Section 41. I'm not sure what you are saying here reveals the importance of the case, because remember the question wants you to tell us
Yes.
what's important about this case. I'm not sure when I read this.
Yes, maybe it was too
you are
cryptic.
saying.
What is important about that case is that I found that NERSA is an organ of state in the sphere of government. As I did some research before I wrote this judgment, because this was a point in limine that was raised. And I then did some research and I found that there has not been a judgment where NERSA, that's the energy regulator, has been found to be an organ of state in the sphere of government. And therefore, the Framework Act actually applied to this matter, because the point that was raised is that it does not, the point in limine should be dismissed because NERSA is not a state of organ in the sphere of government. So that's why I thought this was an important judgment.
Why was the finding that NERSA is an organ of state important?
Because there are many matters where the energy regulator is a litigant, and I found that they are bound to the Framework Act and they must try and resolve their dispute as an organ of state before they can approach courts.
Yes, and then the next one is number 3 in Chongwana. You say mental incapacity, implications of failure to testify.
Yes.
There are many occasions when courts have pronounced on the implications of failure to testify.
Well, I was
So
a scribe
why
in
was
this.
this significant?
Sorry, Chief Justice. I was a scribe in this matter, and you would be surprised that there are very few cases dealing with where the accused failed to testify, and how one then approached the onus that is on accused, because you will remember that there's an onus on the accused to satisfy the court that he is not is incapacitated. So I thought this was an important judgment because none of the cases that we researched, and you will see from the judgment, none of the cases dealt with this specific factual, with these specific facts.
You see, the questionnaire requires you to tell the commissioners what was important about the case.
Yes.
If you take this one, if you look at what you said here, I want to suggest to you that really there's nothing that reveals why it's important, because you said so little.
Yes, I
What do you say about
apologize for that. I apologize for that. I realize that it's too cryptic. I thought I should keep it short. So I apologize for that.
And then number 4, right cloth, you say court's duty in eviction applications, not business as usual. Armchair approach not suitable. Well, I think there are more. It's just important that you answer these questions properly, because there's a reason why the questionnaire requires you to give us those cases which you consider important, and to tell us
Yes.
why they are important, because that enables us to see that you have been involved in really important cases. That's the kind of experience you have. But when you don't give enough information that reveals their importance, it doesn't help you.
I
You
accept
understand?
that.
Okay. Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, there are three arms of government, and basically what it means is that each arm of government has a specific function, and one must be very careful that you must stay in your lane and not tread in another field of arm of government. So basically that's what it means.
And the rule of law?
The rule of law, basically, if I can put it just shortly, nobody is above the law. It's also in terms of Section 1 of the Constitution, one of the founding values. And for that reason, everybody is bound to the law, even government, every single person in the Republic of South Africa.
President of the SA?
Thank you very much, Chief Justice. Good afternoon, Justice Window.
Good afternoon, President.
Yes, you mentioned that you acted at the Supreme Court of Appeal for 3 terms. Is that correct?
That is correct.
And it was 3 consecutive terms, right?
Pardon?
Was it 3 consecutive terms?
No, the first time I acted was in 2022, from the 1st of June up to the end of November. That was 2 terms. And then I was invited back last year for the 3rd term. I acted from the 1st of June until end of September.
Okay, thank you very much. So, how did you find the environment, and how did you find the transition from being a judge of the High Court to being a justice of the Supreme Court of Appeal?
It was definitely different. I want to compare that to when I first came to Johannesburg. As a magistrate, being in Potchefstroom for 20 years, when I first came to Johannesburg, it was a big adjustment. Because there are people that think when you come from a magistracy, you don't actually belong in the High Court. So it takes a lot of hard work. And I'm not saying you must convince people, but I mean, for me, it's important that I show that I am worthy to be there. So with the first time when I also arrived at the SCA, I felt myself also have that same feeling over again. You know, here I am, what a privilege, the pinnacle of my career. It was such a fantastic thing that happened to me. And I think the first 6 months I was sort of on a cloud. I found it extremely intellectually challenging. But I loved it. I loved the fact that we are all there. We're all from different provinces. We are working very hard. You can have wonderful conversations with colleagues. The colleagues were all very nice. I made very good friends there. And I also learned a lot about myself. And that's why I wanted to compare that to the first time I came to Johannesburg. Because then I realized that I have a voice, that I can contribute when we are in conferences, when we are in court. Questions that are asked, they are valid, they are good questions. So I think for myself, when I went back the 3rd term, I actually settled down. And it was a wonderful experience.
Did you have any difficulties in crafting your judgments?
No, no, I'm not that I can recall.
Did other colleagues have to give a lot of input in your judgments in terms of matters of substance?
No, I'm not. My first language is not English, so you know when a colleague that is first language is English and tell me that change that word, I'm going to change that word if it makes it better.
I'm referring specifically to matters of substance, not cosmetic or stylistic issues.
Yes. No, I'm not that I can recall.
Yes. And you were there for 3 terms. You now know that the workload in that court is quite enormous.
Yes.
You are also aware of the loss of expertise that the court has experienced due to attrition in terms of elevation of some judges to the Constitutional Court and retirement of others.
Yes,
you are
that's
aware
correct.
of that, yes. In fact, the experience, collective experience that has been lost is estimated to be over 150 years in actual fact. You'd agree then under those circumstances is very, very important for experienced colleagues with broad skill set to be appointed to replace those who have left in order to complement the expertise at the court. Would you agree?
Yes, I do.
So I note that you have been a permanent judge for 11 years. Is that correct?
That is correct.
Yes, and that prior to your appointment, you were you were in the legal profession for 20 years. Is that correct?
Yes, in total, I've gotten 29 years as a presiding officer. That is 20, almost actually 30 years.
Yeah.
20 years as a magistrate and 10 years as a judge.
And 10 years as a judge, so approximately 30 years experience. That being the case, what special attributes would you bring to the table at the SCA in terms of your contribution as far as the judicial experience and the skill set is concerned, are concerned?
Well, I'm now 56 years old. I've got 35 years of experience. 2 years of that 35 years as a prosecutor, 33 years as the presiding officer, 3 years in the criminal court, and about 31 years in the civil section. I bring with me a wealth of experience. You can give me any type of matter, and I will be able to conquer that matter and deliver a judgment. I've got a judicial temperament. I think my work speaks for itself. I've got the ability to listen to parties, and I deliver my judgments in most cases within 3 months.
Yes, and in response to the questions from the Chief Justice, you mentioned that you have had exposure to a variety of work in the legal field, but you have not yet had exposure to trademarks. Is that correct?
No, I've not had the opportunity.
Yes, at the Supreme Court of Appeal, did you get an opportunity to participate as a panel member in a shipping matter?
No.
Not yet. Okay, last but not least, do you think collegiality is important in an appellate court? I know that in response to that question, some would say that collegiality in general is always necessary, but speaking with specific reference to the Supreme Court of Appeal as an appellate court, where you'll never ever sit alone, you know, in any case, you'll always be with other judges, either in a panel of 3 or a panel of 5. Would you say that collegiality is very important?
Yes,
In terms of the
absolutely.
functioning of the court?
Yes, absolutely. Because you're working in teams of 5, it is very important to get along with your colleagues. And we've got different personalities. It might happen that because my personality, you don't like my type of personality, that there might be an issue. But when it comes to work, you have to put aside all your differences and you have to work as a team. And I think it's of utmost importance in the Supreme Court of Appeal.
Yes, you said you wrote 6 judgments at the SCA. Were they produced promptly? In other words, in accordance with the norms and standards?
Yes, they were all delivered promptly.
Have you ever contributed to the delay of another colleague's judgment in terms of maybe delaying to give input and so forth?
No, definitely not. I think that is because a person has put so much work into that judgment. When that judgment lands on your desk, you have to put everything aside and attend to that judgment.
Thank you very much, Justice.
Thank you,
Thank
President.
you, Chief Justice.
Minister?
I've got no questions, CJ.
Thank you. Commissioner Marmohai?
Thank you very much, CJ. Good evening, Judge.
Good evening, Professor Marochmagai.
Thank you very much. I need to talk to you about one of your judgments that I read sometime last year. And for some reason, it has been troubling me. So perhaps maybe we can we can have a discussion about it. It's Gruskin versus Gruskin.
Oh,
The one
Gruskin,
for
yes.
leave to appeal that was granted by the Supreme Court of Appeal to the full court.
Yes.
Yes. That let me just ask this question. In your judgment, you say that a court that grants leave to appeal, it is the court that should be approached to deal with the issue of security of costs.
Yes, because I think it's Rule 4913 that specifically says that the court that grants leave to appeal should deal with, actually not order security for costs, because that is actually, the rule says they must provide security for costs, except if the court relieve them from that duty.
Yeah, the problem is you answered before I asked the question.
Okay, sorry.
And that's where the problem is. Because
Yes.
if you look at the uniform rules of court, Rule 1 defines a court in a particular way.
Yes.
And Rule 14 and 13 deals with a court as defined in Rule 1.
Yes.
Right. And when one applies for leave to appeal, that has been refused by a single judge sitting at the High Court. You apply for leave to appeal based on Rule 17 2B. You don't apply for leave to appeal based on any rules of any court.
Are you talking about when it goes on petition to the SCA?
Yes, to the SCA.
Yes.
When
yes.
a single judge refuses leave to appeal at the High Court,
Yes.
you don't have anywhere to go but unless you apply for direct access to the Constitutional Court. But nonetheless, to the SCA.
Yeah, so my reasoning was when you approach that single
I would
judge.
like to ask a question.
Sorry, Professor.
Because now, so that you can answer. Now, when a single judge who has just refused leave to appeal in the High Court, and now you are forced to go to petition the SCA, my question is this. When leave to appeal is refused, that means there is no obligation that arises for anyone to do anything. In other words, the matter dies. If no one approaches the Supreme Court of Appeal, that means the matter dies a natural death.
Yes.
What I want to understand is, how then does, and you might be wrong, you might be right, and
Yes.
I'm just satisfying my curiosity. How then does an obligation to pay security of costs arise when you are applying to the Supreme Court of Appeal in terms of a statutory provision and not the rule? That's the conflict that I have in my mind, because if leave to appeal was granted, then I would have been forced to furnish security for costs because
Yes.
I'm within the realms of 4913.
Yes.
Then I have to, unless I ask the court to excuse me from paying them. But now, if leave to appeal has been refused and there's no obligation that arises anyway, if I go to the Supreme Court of Appeal, because Rule 9 of the Supreme Court of Appeal says the party who's brought to the Supreme Court of Appeal can actually apply for security for costs if he or she or it wishes to do so. So my question is, when leave to appeal has been refused by a single judge in the High Court, how does an obligation to pay security of costs arise? That's where I'm like, when I read your judgment, and again, your judgment, there is another judgment, Alem versus Barr. And in your judgment, you don't deal with it. And the judge in that judgment deals with this question. So that's where my confusion is a little bit.
Which matter do you refer to?
Alem versus Barr. You refer to it in your judgment. I beg your sorry, Chief Justice, this is taking longer, but I think it's really important.
Yeah, okay.
I'll tell you now. You refer to it in paragraph 8 of the judgment. It is in paginated page 7. Oh, paginated page 133.
One?
No, I'm wrong. It's paragraph 8 of the judgment. It's paginated page 134. Yes, line 1, 2, 3, 4, 5, 6, 7, 8 from the top. You refer to it. You just say Dr. Maureen Allen versus Bart. The court found that Rule 49.3a does not infringe the right to access to court, and you leave it there. And you don't deal with the. And I'm not saying that you ought to have dealt with it, but it was surprising to me because the judge in this judgment decides something different. It deals with the question of how Rule 49, subsection 13 is not applicable when leave to appeal has been granted by the Supreme Court of Appeal. And I'm not saying that I'm right and you are wrong. I'm just debating with you. I just want to understand this.
Listen, this was a very, very interesting matter to me. It took me some time to come to the conclusion. And in my view, if you read further, I explain why I say if a single judge refuses leave to appeal, obviously the question of security will not arise. But now they petition to the SCA. The SCA grants leave, say, back to the full court. So again, if you then go back to the full court, you are bound by the uniform rules of court, which is Rule 49. And Rule 49 says, before you can lodge your appeal record, you must furnish security. So that was my reasoning, that even though the SCA, when they grant leave to appeal, does not excuse the plaintiff or the person that's appealing from providing security, if you look at what the rules say, as soon as it's back in our courts, that is the High Court, they will have to provide security in terms of 49.13. Otherwise, the appeal will not be able to continue.
But the court defines, the uniform rule defines a court in Uniform Rule 1 as a court as understood in Section 9 of the Superior Court Act and in Section 6 of the Superior Court Act. And Section 6 mentions the High Court and all of its divisions. It does not talk about the Supreme Court of Appeal. And that's where my confusion is at. As to how then, when there was no obligation, when the single judge refused leave to appeal, and the rules of the Supreme Court of Appeal specifically deals with the issue of security for cause, if anyone desires them, then the court, because remember, when you're applying to the Supreme Court of Appeal, you don't know what the Supreme Court of Appeal will do. It might say we want to hear the matter, or it might revert back the matter back to the full bench.
Yes.
My fundamental question.
Let's try and bring it to finality.
Yes, I will. I think I make a point that I can leave it there. Thank you very much.
Something you can't resolve yet. Okay, all right. I didn't see any other hands. Therefore, we have come to the end of this interview. Thank you very much, Judge Windrell, and
Thank you, Chief Justice,
for availing yourself once again and for coming to this interview. You are now excused.
Thank you.
Thank you.